In the last instance, on last Wednesday, it was running in the list number 34. Mr. Shubhashachi Chatterjee have already mentioned it. Well, this is the situation where the alleged SC certificate was issued by SDO Barakpur, and that was seized by SDO Barakpur at 2015 in my instance. Now the writ petitioner have filed this application. I am an intervener.
The matter is there in the list.
Is in the list.
Please do not mention. Yes.
No, well, this is the urgency is that.
Please do not mention. Yesterday, entire list was called on. Nobody was there. Do not mention. Yes.
May I have your lordship's kind leave to move on urgent application, my lord. Where here, my lord, petitioners are all falls under physically disabled persons, my lord, with locomotor disability. My lord, the 100-point roster, my lord, your lordship knows, Supreme Court as well as the PWD Act says that these reservations should be horizontal in nature, cutting across. Now, my lord, the 100-point roster, my lord, says 32nd vacancies SC locomotive. That prevents our, we are unreserved and OBCs. We cannot avail the benefit of this locomotor disability.
What is your immediate relief that you are claiming?
My initial relief is based on this 100-point roster. Every day recruitments are being organized. My lord, SSC recruitment already examination, but there, my lord, the categorization for the timing has not yet started. It will be started soon after 14th, because 14th is 11-12 examination. My lord, I am praying, my lord, to hear the matter at the interim protection that.
But why before this bench and why not before the
100, my lord, SSC notification I cannot, because SSC everybody is issuing notification based on the 100-point roster, my lord, of the Department of the Government of West Bengal, Department of Labor, signed by the Chief Secretary. My lord, unless that is amended or modified, my lord, every recruitment authorities will have to follow this. This is the difficulty. I have challenged that, my lord.
And it has to be taken up by the Group 9 bench.
Yes, my lord.
It cannot be taken up.
It is a Labor Department notifications.
Maybe Labor Department, but then it can go before the education or the
not
service.
Education, because education and service.
It's education service, isn't it?
Education I mentioned, but because no, it is not related to only higher secondary or secondary.
Very well. Give.
Beyond that.
Give.
My lord, one non-prosecution matter.
Friday, my lord.
My lord, one non-prosecution matter.
Give. Yes.
For extension of interim order.
When is it expiring?
It's going to expire on September 26th.
Give.
May I have your lordship's leave to mention a matter, my lords? This is item number 110 of your lordship's monthly list, my lord. Your lordship had previously taken this matter, the urgency being that my contract with PWD has now been unilaterally terminated. My men and machinery and all the labor is there on the site. Your lordships had directed PWD to file a report, on the basis of which I filed my exception. Your lordship will kindly have it on any day, my lords, will not take a lot of time.
Yes.
For the private respondent number 12 and 14, the petitioner person mentioned the matter to be fixed on tomorrow. And
all right.
Fixed on any day after tomorrow, any day.
But then since it has already been fixed, you keep somebody tomorrow in case it appears in the list so that it can be fixed further. Then tomorrow, please keep somebody here. And if the petitioner appears in person, you are representing the private respondent. Who is the authority?
State, I think, probably.
State.
It will be a public interest in any manner that is a different.
Keep somebody here.
My lord, if it could become in the daily list, my lord, that's my only prayer before your lordship, my lord.
Sorry, sir. Yes.
Lord, I'm under compelling circumstances. I'm mentioning, my lord, of your lordship's monthly list, item number 111 and 2. My lord, 1112, my lord. Here, my lord, the petitioner is presently languishing in custody for a period of over 6 months. My lord, the petitioner, my lord, was all along, my lord, but time to time, my lord, her citizenship before the India was extended, stay in India was extended from time to time. She made an application for, my lord, permanent citizenship. That is yet pending, that is yet to be considered by the authorities concerned. Now, my lord, the petitioner is presently in custody in a, my lord, Foreigners Act proceeding. And my lord,
he or he is a foreigner. It is
for the past 40 years, she is residing in India. Her stay was extended from time to time. Now, my lord, presently, my lord, she is suffering, my lord, she is various, my lord, having diseases of neurological problem, my lord, and also
she will visit a doctor from the hospital, from the A
But
correctional home where
difficulty
is
is, my lord,
already.
but my lord, difficulty is, my lord, what I have prayed in the writ petition, my lord, that my application for permanent citizenship, that may be considered by the authorities. That, my lord, that only prayer, my lord, I am humbly beseeching before your lordship. That has not been considered till date. I have made, my lord, the application prior to registration of the FIR.
Yes.
Prior to registration of the FIR, my lord, for the past 6 months, I am languishing in custody. Lord, I am
What is the item number?
1112 of your lordship's monthly list.
All right, next Monday it will appear. Serve notice.
I shall, my lord, I shall. Grateful.
Sleep is not required.
Your Lordship, may
My
I,
lord.
may I permit to mention one matter? Today's item number 16, Landed Council, Mr. Shakti.
16.
Yes, yes, Your Lordship.
Which side?
I'm original side.
Yes.
I'm for the petitioner. Last day, Mr. Shakoshan has mentioned it. He will be out of station till 18.
Yes.
Kindly take the matter after.
Sir, the matter will be called on just now. Why are you mentioning unnecessarily? Yes.
I am mentioning one matter, my lord, which is item number 829 of your lordship's list. Of course, lordship is declined to interfere with any SARFAESI matter, my lord. Here is a case, my lord, where 13.4 was not given. 13.2 reply was not considered, my lord, and not been replied. Still, a police protection order has been obtained.
Yes.
But I have paid the entire dues of the bank. I have no due. I said that kindly inform me as to what is my due. Actually, I have no due. Well, still the police protection order has been obtained. So without 13.4, I cannot go to the tribunal.
Police protection means section 14.
Section 14
Application has
has
been allowed.
Allowed, and 19th is the date.
19th is the date. All right, next Monday it will come. Which number? What is the serial number?
829.
829. Serve notice upon the bank and whoever is there.
I shall give all notice.
Yes.
My lord, I am under compelling circumstances. I'm mentioning, my lord, 649 of the item number 649 of the monthly list, my lord. The last date of tender, my lord, tomorrow. And my lord, the All India Radio has imposed unauthorized restriction upon my client that he will not participate since he has participated in 2017. But the GFR says, my lord, the restriction can be imposed if there is a criminal offense or punishment by criminal court, then for 3 years. My lord, 2017, my lord, they have restricted me. My lord, kindly take up the matter on tomorrow, my lord.
But then why are you mentioning today? If tomorrow is the last date, you could have
My lord,
mentioned it
my lord,
earlier.
yesterday my client has come to learn because since they have restricted, my lord,
That means your client was not interested.
my client cannot reopen the portal, my lord. This is the difficulty, my lord.
Yes, tomorrow is the last date.
cannot
That
enter
means the final date of submission of bids
Lord,
is over.
But
then what remains? Nothing. Yes.
my lord,
No, nothing. Yes.
my lord, tomorrow is the last date, my lord.
That is the reason the court is not agreeable to hear your matter because there is no urgency.
My lord,
Yes,
client cannot
sir,
reopen.
I am refusing your prayer. Yes.
Can I permit to mention one matter for non-prosecution? Lord?
Give. Yes.
May I be permitted to one matter, lordship? There is a lordship. Your lordship has been passed an order of demolition, and that order has not been complied with. I have filed an contempt application, but the writ petition is pending before the honorable courts 3 Justice Sinha, and this lordship, this contempt application should not be listed because the writ petition is pending before there.
Who are you?
I am for the petitioner.
Petition on where?
My application, on the basis of my application, the demolition order was passed, and that order, demolition order, my lord, the person who was the residing.
Whose writ petition is pending over there?
My writ petitions.
Here also the writ petition is
No.
pending.
Here, lord.
Contempt order arises
Contempt
out
application
of.
is filed.
Contempt order arises out of the disposal of the writ petition
No,
order.
the interim order of this writ petition.
From the interim order.
Lordship.
And the main matter is pending.
Main matter is pending. Lordship, may I just lordship kindly have a look. This order of your lordship has passed this order.
No. In your matter?
My matters.
Yes. It will appear in the list on Thursday. Please mention.
May I be permitted to mention a matter for restoration? The
Restoration. That means at which stage the matter is?
lordship,
What is the stage of the matter?
dismissed for default.
Right. So what have you done to get it restored? What have you done? You filed an application.
Yes, lordship.
What yes? Did you or did you not?
Yes, done.
Application has been filed. Why was the matter dismissed? Why was the matter dismissed? For what reason? Don't look over there. Matters are dismissed for what reason?
Non-appearance of the petitioner.
Right. You are there for the petitioner.
Yes.
Why did you not appear? Why did you not appear when the matter was taken up?
May I interrupt you? Since your lordship,
Intervene means? How do you intervene?
since your lordship, I was not the advocate and record on that matter, your lordship. So
Is it the same matter that you are mentioning?
same matter,
Yes.
your lordship, the matter advocate on record was your lordship.
Somebody was the advocate on record. The advocate did not appear. That is the reason the matter got dismissed.
For default.
Now you want it to be restored.
I have filed an application, your lordship, and thereafter, your lordship, I'm trying to restore the matter.
Yes, yes. Put a pressure on the court.
No,
You
Your
did not appear, and then you put the pressure on the court for restoration.
I beg your
There are
pardon.
so many matters. It will not be restored. It is your fault.
My lord, I am mentioning one urgent motion, my lord, that notice under section 17A, subsection B of West Bengal Inland Fisheries Act. Notice has also been served, and 1712 penal provision also, my lord, intimated to the respondent number 12. My lord, respondent number 12, my lord, over the, my lord, more than 20 kathas of pukur. My lord, after filling up that, a complex.
Yesterday
my lord,
only
five-story
you-
complex.
You mentioned one matter or did one matter
My
yesterday?
lord, this
Same
was
thing.
another matter. Another matter.
Separate matter.
Separate matter. My lord, Inland Fisheries Act, my lord, 17(1)B notice has been served.
Yes,
As
and
well
you
as
want
my lord,
implementation. You want implementation of this?
And praying leave, and my lord, fixed any date as your lordship.
Are you praying for implementation or are you
Implementation, only
challenging?
Implementation.
Monday it will appear, serve notice.
Dreadful.
My lord, I'm praying regarding item number 136, my lord. It's a group 5 matter, my lord. Wrongly.
Group 5.
Group 5 matter.
136 of today's list.
Today's one. I was praying for only releasing the matter.
Sheikh Muhammad Safiullah.
136.
All right, released.
19645. Number
19645, released. Group 5. Call the list, please.
Item number 1.
My petition, my lord, for contempt.
Yes. Has the order been complied?
Your Lordship was pleased to direct me to file an affidavit of compliance. On the last occasion, I have submitted before Your Lordship that the petitioner complained about two premises number 22 and 23. The
32 and 33.
32 and 33.
Right.
The
No one was present.
in the writ petition, there is no name of any private respondent. Now, in the meantime, the authorities have inspected the premises upon giving notice to them, but they did not respond. On the other hand, give a reply that is not relevant.
No, here what is the premises number?
Lord, 32 and 33 is Smile Street. my lord.
In
Your lordship on the
Together?
32 and 33 is Smile Street.
Right. Is it together? Are they two separate?
Separate.
Separate.
premises.
Separate.
now 32, there is no existence of 32. No existence. And so far 33 is concerned, that is a land.
Vacant land.
Vacant land. So, my lord, it is impossible to comply with the order.
Lord, I can establish that they are saying that there is no record of 32 Ismail Street. The record of 32 Ismail Street suddenly disappears from the records of KMC. I
Yes.
can establish that there is a record of 32 Ismail Street. Lord, your lordship, they have your lordship on the last occasion directed to file an affidavit of compliance.
Yes.
That was to be filed by
He, my lord,
26th
we have-
August.
Yes.
To serve on me on last Wednesday,
Yes.
much beyond your lordship's order.
All right.
So I had refused it. I have told
I-
them the
All right.
opportunity.
Take it. Please take it.
Lift
But
from the lift.
I am giving here now,
Yes.
my lord.
Affidavit filed by the executive engineer.
Executive engineer.
Let me see.
But I have given, my lord.
Oh,
But I have served, my lord, kindly record.
yes.
This-
Affirmed on 21st August 2025. Filed in court is taken on record. Stop. Copy of the same has been handed over to the learned advocate for the petitioner in court today. Stop. It will be open for the petitioner to file an exception to the same by
Lord, I need at least 2 weeks time, my lord.
4th November. Released on 17th of November. Next.
4th November reply the 17th. I am grateful to Lordship. Hey, petition or file for the contempt na.
Yes.
Before your lordship goes into the matter, the crux of your lordship's direction would appear from your lordship's order dated 7th of March 24. I'm just handing up. Is your lordship having the application?
Is that page 31?
Lordship would come to page 30, your lordship's order,
Yes.
then turns over to page 31.
Right.
Now, in view of the above, Chief Manager, third paragraph, I'm
Yes.
reading.
Yes.
Revenue Kolkata is directed to consider the legal representation filed on behalf of the petitioner in the light of the order passed by the Municipal Assessment Tribunal and take necessary consequential steps in the matter. A decision shall be taken positively within a period of 8 weeks from the date of communication of this order. An opportunity of hearing shall be granted to the petitioner or their authorized representative. The amount that is found to be paid in excess shall positively be refunded at the earliest. This was your lordship's order. Now, there was a hearing given, but unfortunately no order was passed. Now, after your lordship's last direction, because my learned friend made a submission that from 1,06,000, it was not 1,60,000, though the tribunal said it is 90,400, but the effect of that was not being given. Now, my lord,
And further bills were being
yes,
raised.
on that valuation
Enhanced
of
valuation.
1,60,000. Now, my lord, my clients gave a letter to the assessee concerned that come over for a hearing. Now, that was objected to by the advocate on record on behalf of the applicant. Now, to that, I have given a letter. Now, so far as the adjustment part is concerned, the higher value to the lower value, that has been done. My lord, I'm sorry, my lord, I have got only one copy as they have
Give a
said.
copy to him also.
No, I have not got. I'll give a Xerox. Now, my lord, this is
How can I have a look at that?
I know that. I know that. I'll
Yes.
give you a copy. I have got only one copy. Within short time, I could not get it Xerox. My lord, this is the letter given to the advocate on record, who on behalf of his client said, no, at this stage of there cannot be any hearing. Now, the adjustment part was there. That is one part that has been done.
Yes.
Your lordship would kindly see. Now, one more thing was added in the letter. That is the adjustment. I am giving Mr. Chatterjee a copy.
Right.
So you are saying you don't have?
Yes.
He's saying he is having it.
Having what?
He's having the set what I have handed up to your lordship.
Calculation also.
This letter was given to
They were very quick. They uploaded that in the portal last night.
Okay.
I got a copy,
Yes,
but
alright.
I have submissions to make.
Right.
Lordship's order has to be at the end of the day has to be complied. Come what may. If it is, if the communication has gone to him in the night, but my records have been cleaned, and what ought to have been done has been done. So, my lord, my learned cannot.
So some amount of refund, and if
refund
the
part, my lord, first is I have to I have to bring down the valuation from
Yes,
1,60,000 to 90. That part is over. Now, so far as the excess payments are concerned, I have adjusted it.
Yes.
If my learned friend is having any objection to that, and that is, my lord, the reason I have said in my communication that a hearing was given
Alright,
only
yes,
to
what is
comply,
your submission?
and he is reluctant to go there.
Alright,
Yes,
yes.
that's it. They create an urgency and they expect me to jump to that. My lord's order was very clear that all consequential steps have to be taken and refund. They reduce the valuation from 1,60,000 to whatever the tribunal has said. They do not refund. In the letter that is handed over, the letter served on my advocate, they say that we have to stop there. We cannot proceed towards the third paragraph of the letter dated 6th.
Yes, 6th of September.
Yes. The matter of revision of property tax and the unit area assessment, as stated in your letter and the reference, is beyond the scope of the order of the learned man. But it was
Municipal assessment, right?
it was within the scope of my lord's order, because my lord had said all consequential steps. And hence it is beyond the scope of the order of the Honorable Court dated 7th March 2024.
If that be so, if we have to pause there, then refund is also has to follow because they cannot adjust. If we are to follow my lord's order in toto, if we are to construe my lord's order as to consequential steps, not to weed, not to
Sequential steps
let
Malad,
me-
related to the order passed by the tribunal.
Let me understand.
Yes.
The order of the tribunal was on the earlier system of valuation.
Yes, ARV system.
Right. Now, a unitary assessment has not
Started
been
from
made.
1st April 2017.
That has not been made.
has been made.
Unitary assessment.
This is the page 25 of the writ petition.
Yes.
Malad, it was not legible because the stitches were there. Malad.
All right. The unitary assessment has also been made.
Yes.
And are you satisfied with whatever is there? Because that was not under challenge before the
Anyway,
assessment.
That need not be.
Need
because-
not be.
Because irrespective of the valuation,
Right.
kindly see.
Yes. Dekhi. How much does it come? How much does it come to in this
Valuation
unitary?
is not important because of the capping rule, page 5. The tax assessed cannot increase by more than 20%.
The capping is there.
Yes. So they have now that they have determined the assess the tax on basis of the tribunal's order, unitary assessment should have followed by restricting the increase in tax to
20%. Right.
the max.
Right.
Now that they are hostile, I can't expect anything lower than 20,
Right.
but
Right.
they have not done that.
They will do it.
That's the reason, Malad, I have
They will do
asked
it.
for a hearing, giving him
It's
a
not-
hearing.
hearing
He
is
says,
not-
hearing I will not do.
Hearing is
Doesn't
not
matter.
be
If he
there.
doesn't come, you make
I
a
will pass an
calculation
ex parte
and pass
order.
an
Your
order.
lordship clarifies that.
What is
Arithmetical
the
thing.
yeah?
Nothing remains.
What is the need
This is
for
this
the
is
hearing?
mathematical
Nothing
calculation.
remains except for arm twisting. Now,
No,
Not
right
interest-
now the
of course, yes,
mathematical
this is my
calculation.
strategy.
It's the mathematical calculation. If anything is
Arithmetic, simple arithmetic.
if anything is withheld from the excess amount, if it is there with you, it has to be refunded or adjusted, whatever to be done. Please do.
And
Come also. Your lordship clarifies that.
No.
Nothing remains
No,
in the contempt.
now
Stop.
with Malad, one more thing. There's a valuation made even after apportionment, after unitarian. Because
That's not the part of it.
that has also to be reduced.
How can he do ask all these things over here?
Consequential
How can a
steps.
court taking
Consequential
up?
steps in respect of the assessment tribunal's order.
Yes.
Anything comes in
They will
future.
not act,
Your
they will not
lordship
do
cannot,
anything.
in a contempt
Take the
jurisdiction,
higher valuation.
reappraise the
Then-
evidence and
then-
pass a new order.
Then my lord will pause there and ask them to refund on basis of the
Whatever is there.
yes.
It is there. I have called for a hearing. He doesn't want to come. I'll pass
Of
an
the
ex
chief
parte order.
manager within bracket revenue / South Kolkata Municipal Corporation dated 6th September 2025 to the learned advocate on record of the petitioner along with the
Adjustment sheet.
adjustment sheet.
My lord's order did not provide for adjustment, it specified refund. That is a violation.
Yes, I'll record it. Adjustment applicant calculation sheet placed before the court by the learned advocate representing the contemptor is taken on record. Stop. The contemptor is directed to pass a final order in the matter, and after making the arithmetical calculation of the tax payable by the petitioner, if any amount is found to be held in excess by the corporation, the same shall be refunded in terms of the order passed by this court.
My lord will
On
kindly mention the
7th
capping rule.
March
Capping rule.
2024.
Rule is not so far as that.
Next.
This valuation.
Very assessment.
Yes, that is not the part of the subject matter of lease.
That my lord.
Released the matter on 4th of November. Take back your calculation.
My lord would keep that on record.
Yes, this is on record.
Yes.
That one is
I know I'm giving.
petitioner's one is.
And the other one is my London friend is having a copy of that.
Then it's all right. And he said it's uploaded in the portal.
Yes.
That's from where I got.
No, it has been sent to the.
No. This what happened last night.
3.
Great.
Obligement.
May it please your lordship.
Petitioner,
My lord, I am appearing for Standard Chartered Bank. On the previous occasion, my lord may remember, we had filed an application with the SRO for the title deed. So what had happened is we had given the number of the we had not given the number of the IGR. Now we have filed another application for the certified copy. Although lordship, I am still I want to argue on the maintainability of this petition. However, they have returned the bank. The loan has been returned, has been repaid by the petitioner. So on the earlier occasion, we had returned the 4 policies which were kept as security. The
When will you get that?
my lord, we have
When did you apply?
we had applied it on 18th of August. Now we are still awaiting the order, my lord. What I was suggesting,
Pending for such a long period of
this is
time when you
beyond something
apply?
this is beyond our control, my lord. My lord, that is why on the earlier occasion also I had requested, my lord, that kindly ask them to add the ADSR Shialda as a party, because in the earlier occasion the ADSR Shialda informed us that there is no such deed at all. So this information will come from ADSR Shialda. However, Mr. Banerjee on the previous occasion was extremely vehemently opposed that. I don't know if it would have helped his client only.
Anyway, certified copy.
I'd like to appeal for LFCA in this matter. On the 2nd July 25, your lordship had directed me to reassign the policies to the petitioner. I had reassigned, complied with your lordship's direction. I had reassigned the policies and made payments to the petitioner.
Now the payments have also been made. That means the policies have been used.
Yes.
All right, give. Please give. Please give. Please come. Learned advocate representing the Life Insurance Corporation submits upon instruction that the that 4 policies of the petitioner which were submitted before the Life Insurance Corporation has been reassigned to the petitioner, and the same has been credited in the account of the petitioner. On 12th/13th August 2025. Stop paragraph. Right now, only the title deed. One or how many?
Only one title.
Title deed of the petitioner is required to be returned to him. Stop. The loan amount has been repaid by the petitioner. Stop. The bank has applied before the additional district sub-registrar, Shialda, for obtaining certified copy of the deed. So let the certified copy be handed over to the petitioner as soon as the same is supplied by the registering authority. Stop. Released on 4th of November.
Grateful.
Can you get it this side of the vacation? Then I can finish it off.
It's not in my hand, my lord. If I can do that, if my lord grants them leave to add the ADSR Shialda, he can come and say what is the status, because he has said earlier that there is no such.
Adding ADSR will just expand the scope of the writ petition, which the court doesn't want to do.
Absolutely non-maintainable writ petition. Prayers against the
Let me do one thing. I'll keep it on the 25th. On the.
But kindly keeps it on 24th. Then.
All right, 24th.
4th.
If you can get it prior to that, then we can finish it off.
Just I will definitely try.
Follow it up over
I will
there.
definitely instruct my client to do that. Grateful, sir.
In item 4, we appear for the Union of India.
I am for the petitioner. Your lordship had passed an order on the last occasion. The issue was whether we'd be allowed inspection of the goods. Now the railways had handed over their written instructions, which has gone down in your lordship's order of 9th of July 2025. Lord, we've had to take out an application for modification of this order. That application we filed, it's somehow not appearing in the list. The modifications to the extent that the terms of inspection that they've now handed over to your lordship is actually contrary to the agreement between the parties. What they've now, the precondition for inspection is beyond the agreement, and it imposes a large greater cost on me to have the inspection done than to manufacture the goods. So this we have filed a very short modification application. Not if it just could appear.
Want to file?
We filed.
You have already.
It's filed already. We've served it also. It's not appearing in the list today.
All right.
No, if it could just appear tomorrow or day after, my lord, with the application, then.
Oh, it will appear automatically in the list. You have to follow the list. It's not yet numbered.
But
Please come.
would it be your lordship pleasure to direct it to appear on a certain date?
Connecting application has been filed in the writ petition, which is due to appear in the list. Stop. When did you file it? কবে ফাইল হয়েছে কোনো আন্দাজ আছে? List the same at the earliest.
You got a hard copy where we served upon.
Certainly.
Serve calling?
Next.
We'll serve it.
Lordship will kindly take Lordship orders dated 16th of July and 12th of August 2025.
Appeal before the division bench.
Today, both the appeals have been dismissed for default.
Default?
Yes.
No, my lord, what has happened?
No, what has happened? He
Has happened,
is
it
making
happened.
paper submission. Nobody was there. What can be done? The appeal has been dismissed.
I was there outside of this court, my lord. Unfortunately, my lord, two is going on, my lord. And my lord,
No,
that
you
doesn't carry
make
us
an explanation.
my lord.
What is to be done now?
Now, my lord, we are praying for an order, judgment in the nature of the judgment rendered by a coordinate bench, which your lordship will find at page 161 of the petition. Because this was the only ground on the basis of which
161, second volume mein hobe dekhe. This is regarding what?
But this is regarding release of incentives. But your lordship may recollect, for some years, my lord, the relevant certificates were not issued by the Commissioner State Tax. Pursuant to when the matter was pending before your lordship, pursuant to lordship's directions, during the pendency of the writ petition, the certificates were released and the lordship was pleased to dispose of that writ petition on the ground that it has now become infructuous. When we received the certificates, obviously made a demand, raised a demand. That demand your lordship will find at page 229.
Now they are refusing.
They will not do anything, my lord.
Yes.
That's the whole idea. And I am praying for a mandatory order because there is no defense.
This type of matters, my lord, was already fixed this earlier, my lord, matters, my lord, 7th November, my lord. This, my lord, Mr. Thakkar is argument these things, my lord, this.
But that's a different on-bill altogether, subject to correction.
All are same, my lord, because, my lord,
Relying on the scheme, not scheme, now it is an act.
But they may be relying on the act. The act was enacted in April 2025. The adjournments were sought only on the ground of pendency of appeal.
Yes.
Not on the ground that they have made an enactment.
But now that will be a point of law. Please come. The matter relates to grant of incentive to the petitioner. Stop.
November.
List this matter on 7th of November.
And only then, am I to understand from the state that they are relying on the act in my case also? Let there be a clear indication so that I can also take necessary steps in accordance with law. Then they have to make that positive statement here.
Has any opposition been filed over here?
No.
Let a line liggen into. Let affidavit in opposition. Report.
Kindly direct the authorities to file report so that we can also take steps.
Yes. And
a short date, my lord. Otherwise, your lordship knows.
Fixing it on the 7th of November.
But the report may be circulated before vacation.
Prior to that.
Yes.
Let report by way of affidavit dealing with the amendments made in the writ petition be prepared and circulated by 26th September.
Grateful, my lord. Grateful.
Achha, line. It has been brought to the notice of the court that the appeal before the Honorable Division Bench has been dismissed for default today.
It was the golden hour for us.
My lord, I appear for the rest. My lord, I
And for the petitioner, my lord had called for a report.
Yes, your lordship. The report is ready. My lord, there was 10 days delay in filing the report, your lordship.
May be favored with a copy.
Yes, definitely.
remove the lien that has been created over a sum of rupees 1 lakh in the bank account. What is
My
the
lord,
matter?
the petitioner and my lord, the proprietress of the proprietorship concern, my lord, both are husband and wife. My lord, he has suppressed in the entire petition that there was any connection with the proprietress. My lord, then what has happened that this particular company, this particular proprietorship concern, my lord, they have a fixed deposit did an amount of rupees 1 lakh in the bank. Subsequently, my lord, it was extended from time to time.
1 minute.
Lordship.
Petitioner is Cost of Ghosh.
Yes.
There is no mention of any proprietorship firm over here.
Yes, Your Lordship, in the writ petition, they have mentioned that the petitioner is working as in the company in page number 3, Your Lordship will find paragraph number 2, the petitioner submits that petitioner is an employee of one Sharthok Resolution Security Services, a sole proprietorship firm represented by the proprietor Falguni Maiti. Falguni Maiti is the wife of the petitioner, Your Lordship. Well, both the petitioner and his wife, they have opened a fixed deposit account with the respondent bank for an amount of rupees 1 lakh. Subsequently, my lord, it was extended from time to time. In regard to that FD which was there, they have taken an overdraft facility. That facility has been enhanced from time to time. Now, my lord, what has happened that this Falguni Maiti, she went to the bank and said that the FD certificate has been lost, and my lord has filed an indemnity bond by stating that that has been lost. You kindly give me a fresh certificate. My lord, a fresh certificate was given. Then it was found that many cases were pending against the company because this is a proprietorship concern, and that is why a lien has been marked over there. In spite of knowing everything, my lord, they have entirely suppressed in the petition that why the lien was there. And my lord,
and has the petitioner been made aware of all these
yes,
facts?
Your Lordship, because the wife knows. There are communications I have annexed with my report which has been sent to the wife.
Give me the report.
Lordship. Well, look, one page has just come out of it.
All right, stitch it. All right, stitch it.
I made a staple code. Well, look, that page will only reflect that the petitioner. ये copy देखा. I'm going to दिए दो हाँ वही that she is the wife of the petitioner. Well, it will kindly come to the nominee.
Yeah.
Nominee was the husband. Well, after this, what has happened? There has been a case in the year of 2023.
Basically, that you have communicated to the
yes,
Marked lien.
Yes, Your Lordship.
Yes, page 30. 22nd of February 2024.
Yes.
Yes, what is your submission, petitioner?
But I have to take instruction
Very well,
regard to
please
this
come.
because I've just received this.
I am dismissing it with exemplary costs.
I would kindly appreciate that I have to take instructions. I do not know. No, I've just received the copy, my lord.
You do not know the name of your wife.
But I might know the name of my client must be knowing, my lord. I have to take
Yes.
instruction in regard to that, and thereafter, my lord, even if that be so, my lord, can I be held liable for my wife's acts? I do not know what is there in this affidavit.
The report filed by the bank is taken on record. Stop. Copy of the same has been served upon the learned advocate for the petitioner in court today. Stop. According to the bank, there has been gross suppression of material facts. Stop. The petitioner and one Falguni Maiti are husband and wife. Stop. The wife of the petitioner is the sole proprietor of one Messrs. Sharthok Resolution and Security Services. Stop. The certain documents have been annexed to the writ petition in support of the lien.
In the report, Your Lordship.
Support of the lien marked by the bank. Stop. The paragraph, learned advocate for the petitioner seeks time to take instruction. Monday, 15th, I am keeping it. Release the matter on Monday.
Well,
and be ready for costs.
My lord, possibly
I-
it has gone
probably
that
try
certain
to-
documents in the writ petition, it will be
No,
certain
it-
documents in the report.
Certain documents have been annexed to the report.
I'm grateful.
Yes.
sir.
I'll try to convince my lord otherwise.
দিয়ে দিন না, আমি stitch করিয়ে দিতে check করো। Grateful.
Civil Lordship, I beg to appear, my lord, on behalf of petitioner. This is relating to Apartment Ownership Act. Last two occasion, my lord, because of yes, কালকে বোধহয় এসেছিল মনে হয়। কালকে তো আমি ভাবলাম হবে না।
Yes.
No, my lord, it's a case, my lord, 9,20,000 square feet, my lord, Lordship knows, my lord, Eastern Bypass, Silver Spring, near Bortoman.
May I just cut short the matter in a minute? I don't know if he's aware of this. His case is that I'm for the
But
association.
why will he not be aware of his case?
No, he's aware of his
Eh?
case. I indicate. One of his case is that the association is levying something contrary to our act. And he's made a complaint before the complaint authority. The complaint authority is not taking any steps. Well, the complaint authority had appeared yesterday. He was not appearing. Before that, he had appeared. Complaint authority didn't appear. I've been appearing every day. Now we've received the notice on 4th of September 2025, which is why I'm saying he may not know. This is from the this is from the office of the complaint authority seeking reply regarding this complaints. The complaint, Your Lordship can direct the complaint authority to do it within a.
At the same time, they should not permit, my lord, to realize the amount because they are realizing on the one hand, on the other hand, they are incurring expenses so far the puja is concerned. But puja, my lord, 9,20,000 square feet, and they are realizing 36 lakhs.
The petitioner
All the
In
members.
such
has
period, my lord,
raised certain allegation
Hmm?
before the competent authority under the West Bengal Apartment Ownership Act, 1972. Stop. The learned advocate representing the association has produced before this court a communication dated 4th September 2025 by the Special Commissioner and the competent authority under the Act, addressed to the President of the Association, seeking a reply to the complaint filed by the legal representative of the petitioner. Stop. 15 days time has been allowed for filing the reply. Stop. Paragraph. As it appears that the competent authority has already taken steps in response to the complaint filed by the petitioner, accordingly, the instant writ petition stands disposed of by directing the competent authority to take steps in the matter strictly in accordance with law and dispose of the complaint filed by the petitioner at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
no, my
Stop.
lord, but so puja is, my lord, approaching. They are
Yes.
collecting this amount for puja.
No, this is not
And-
the puja amount. This is
The complaint was not regarding the puja. If
No,
you have
but they're-
further complaint, you can always
They're
raise.
realizing this amount for the purpose of puja, which they cannot.
cultural
Which they
activity.
cannot, my lord.
Yes.
Cultural activity is not within
Is
the four
that your
corner.
complaint?
Yes, my lord.
Your complaint is regarding that.
Yes.
আচ্ছা,
And
তাহলে
within the
time টা
four
কমানো
corner of
হলো।
maintenance, that is not covered.
within
And about 40 lakhs, my lord.
6 week,
Not a matter of joke, my lord.
4th September.
Till such
15,
period, no realization, my lord,
19,
subject to correction.
within a period of by 26th of September.
Ma'am.
Date by 26th of September 2025.
After giving an opportunity of
No.
hearing.
Yes, yes.
But till such period, no
After
realization.
giving reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order.
Great.
Stop. Any amount collected by the association on the garb of charges for holding the
Charges
puja.
for cultural activity.
Acha, charges for cultural activity. Puja হবে না, cultural activity shall abide by the order passed by the competent authority after hearing the party.
And no person, no flat owner should be, my lord, forced to, my lord, deposit the
But he can be forced.
At least, my lord, at least protect me, my lord, at least protect me.
Nobody
Otherwise,
can
my lord,
force him.
otherwise, my lord, my learned friend is, my lord, vociferous. My lord, let me allow. My lord, I know, my lord, he is presenting his case very much in a appropriate manner compared to all of us, no doubt in it. But the thing is this, but I am my lord, apprehending that in the event of no payment is made by us, they would take action against me, since, my lord, they would term me as a person who is defaulted to pay maintenance. This is not within the four corner of maintenance.
And cultural
Separate issue. I'm showing
charges is the
only
same.
one
How
bill,
can
my lord.
it be?
Only one bill, my lord. Page
It said
15 may
that
kindly be
interest
looked
will
at.
be levied if I do not pay my
Yes,
15%.
yes. Yes, my
I'm
lord.
an intervening flat owner. The
Yes.
association has said that interest will be paid if I don't pay within 15 seconds.
Even they are at their liberty to stop, my lord, the common services
If
also.
my learned friend doesn't get
That is-
personal, if he doesn't get personal with me, then I'll just address your lordship for a minute.
My lord, that protection may kindly be given because of
Only
because of
one thing. Lord,
because
if
of
your
associate.
lordship passes that order is
It is
anyways
made
covered.
clear that the association cannot force any flat owner
Deeply obliged, my lord.
to pay any charge on account of cultural ageta ki bollam cultural
No,
activity.
that allows this repetition. Well, then lordship will
Cultural-
tell me for a minute.
You cannot force what
Yes, 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 yes.
do it.
My lord, 50 lakhs, my lord, about 50 lakhs target.
Now,
Submission is
yes.
there's an
Yes.
association which is there. What has happened is, well, there are cultural expenses which are there and there are maintenance charges. This entire general body has ratified because culture, what they wanted
No, my lord.
was.
Just wait.
Yes, 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 yes.
Please, 1 minute. Yes.
Entire all of everybody came up with saying 50 paisa for per square feet that you were holding. Now this resolution people objected to. Then in a general body, in a fully constituted meeting, it was found that it is going to be a certain amount of money which you're going to pay towards cultural expenses. He is the only person out of the entire general body who's come forward and made this allegation.
No, there are interveners.
Yes.
It's not about me forcing. What is going to happen is, once the general body has passed an order, I don't mind the
Yes.
competent authority deciding it. The
Right.
bylaws say under the statutory bylaw, the default carries interest.
No, but then default, you have to be rational. You cannot force somebody to
But
pay
he
charges
has
for
to
cultural
adhere-
activity.
No, not cultural. It is covered under common expenses. You also have a look at the definition of the act.
Yes, yes.
This is covered by judgments passed by this court also.
Doesn't matter.
So, if
But then
I don't mind the lordship looking at.
I have mentioned only you cannot apply force.
No, I'm
Deeply
not
obliged.
applying force, but if
This is what he's saying. Submission is you are applying
So kind
force.
of record that
Forcible.
as a submission. If it goes
Yes,
in
yes.
court, I'm not
Forcible.
able to accept what is statutorily available to the association.
Yes.
Then your lordship will provide that.
Yes, yes.
Otherwise, force is going to become force.
Force
may I-
because you are compelling somebody
don't
to
mind
pay.
that, it can be done as force.
Yes.
But I can recover what is there in accordance with law. That your
Yes,
lordship
yes.
will grant me.
Right. That the competent authority will
Deeply
decide.
obliged.
Call the next
Deeply
one.
obliged.
please.
If this is there, may I just indicate this? The competent authority is going to pass an order. Let's say then this entire exercise will abide by the result of what the competent
Yes,
authority
yes.
says.
Certainly.
The last
Certainly.
direction, my lord,
Last
even if it
direction.
doesn't- let us assume that the competent authority holds that this is payable
আচ্ছা
and
একটা
it doesn't pay.
in the meantime যেখানে ফোর্সটা বললাম না
In the meantime, your
in the
lordship.
meantime
Yes.
yes
Wait.
next one
May I intervene, my lord? I am for appearing for the state, my lord. But due to the nature of problem, my lord, just I couldn't place. My lord, I am appearing for
Lordship, I am
state, my lord, in this matter.
which one item 7
Item 7.
Item 7, my lord. Yes. My
item
lord, due to the network problem, I could not just
record his appearance
Lordship, item number 8, I appear on behalf of the petitioners, Lordship.
yes
I'm being led by Mr. Sumitavo Chakraborty. On the last occasion, your Lordship has directed me to serve a copy of the writ petition upon the bank, Lordship.
insurance company all right yes
Yes, the issue is, Lordship, the petitioner is a proprietorship concern. It's proprietorship firm. The petitioner had purchased a car in the year 2000, sometime in 2017. Initial policy was registered with another insurance company. It was in the name of the proprietorship concern. Now the issue is, I decided not to proceed with that insurance company and I decided to proceed with HDFC, which my learned friend is representing. Now, Lordship, the policy was issued not in the name of the proprietorship firm. It was issued in the name of the sole proprietor. I made a representation before them. It was not considered. I made a complaint before the insurance ombudsman. Now, the insurance ombudsman had passed an order, which is at page number 35, Lordship. Your Lordship will come to page number 36.
yes
The matter was taken up through mediation, taking into account the facts and circumstances of the case, the submissions made by both the parties during the course of personal hearing. It is observed that the respondent issued the policy in the name of the proprietor instead of the name of the proprietorship firm at the time of renewal of the policy for the period 2024-2025. Unlike the last year policy of 2023-2024 issued by the Reliance General. Firstly, the policy should have been issued in the name of the registered owner as per the registration certificate of the vehicle. And secondly, the business owners who run the proprietorship businesses can use their personal PAN for their firm. Hence, issuing the policy in the name of the proprietorship in the name of the proprietor and asking for the PAN of the proprietorship firm in spite of submission of the owner's PAN was not in order. Hence, it is recommended to the complainant to submit the following documents to the respondent as evidence immediately on receipt of this recommendation. I submit the documents to them by way of an email, Lordship. Thereafter, no steps were taken. I again approached them by way of an email. After that, I made a representation before the respondent number 1 and 2, which is the state respondents in this case, Lordship. The Department of Transport, Lordship. My humble request before Lordship is, if the name is not changed, in that event, your Lordship will kindly allow me to temporarily use the current name and let me use the vehicle, Lordship.
Current name means?
That means in the name of the proprietor, Lordship.
Yes.
My lord, may I indicate?
Please.
My lord, I am for the insurance company.
Mhm.
My lord, I have gone through this brief not only with the sole purpose to resolve the issue.
Yes.
I am not getting into any contention. My lord, the policy, my lord, the vehicle has been purchased in the name of A. My lord, the policy has been issued in the name of B. My lord, the reason being, my lord, the A is a proprietorship firm and B is the owner of the firm. My lord, when the KYC documents were called for, my lord, the KYC documents were in the name of B, the owner of the firm. So, my lord, in the name of the B, my lord, with the PAN number, my lord, we have got the IRDA circular with on the basis of KYC documents, the policy is to be issued. The only resolve, my lord, is to be made, my lord, by my company, is to change the name from B to A. Instead of, my lord, the name of the proprietor, the name of the proprietorship firm is to be put into the policy. Otherwise, everything else, my lord, is absolutely fine. My lord, we have requested them, my lord, for changing this name, my lord, in the portal. When the portal is to be opened, my lord, it cannot be opened, my lord. Now it is all electronic, my lord. It's through
online mode.
All through online. My lord, a couple of OPDs, my lord, this numbers would go, my lord, go to my lord, the proprietor's, my lord, his mobile number. My lord, if he goes to my client's office today, tomorrow, my lord, half an hour's time, the OPD, my lord, it would be generated. OPD will go to his, my lord, his mobile. He will give them, this name can be changed. Or if he has any difficulty, any ego problem, he can come to my office. My lord, I'll call my client. It can be done, my lord, in within half an hour's time. This is what I can assure you, my lord, this is the best what I can do. This is, my lord, I do not know why, my lord, why this is not being done.
I had been trying this for a considerable period of time. My lord fixes immediate when my client will.
A very good proposal has
Yes,
come.
my lord. My lord, I'm accepting it.
Leave apart the ego problem.
No, my lord, I have no ego problem.
Right. Now, who is going to go where?
I will go. Your lordship fixes the time. When should I go?
Anytime. He is
My
agreeable.
lord, your lordship
the
fixes
office
the
is
time
at
because the
Kakurgachi,
manager will
my lord.
not be there.
The office is at Kakurgachi.
My
Let
lord,
your client go over there
Friday.
and resolve it.
Friday I will go, my lord.
I'll fix it next Monday.
Monday.
Lordship. Lordship.
The matter is made returnable on 15th September 2025. Stuff. In the meantime, the dispute that has cropped up shall positively be resolved amicably in between the parties. Nothing more is recorded, only this much.
One submission, madam. On 4th I appeared. My name did not go in the order copy.
ওনার নামটা দিয়ে দেবেন তো 4 তারিখের অর্ডারে
Navakumar Das.
for this case.
4th also I appeared.
Yes,
I'm good. My lord is fixing it upon Monday, my lord.
Monday.
Yes, your lordship.
My lord, can it be on Tuesday, my lord? So,
Why?
when one SLP will be fixed.
Your junior will be here. It
Well-
can be disposed of and send your client immediately without waiting till Friday because the office is open. It can be done.
My lord, I appear for the writ petitioner, my lord. My lord, I am being led by Mr. Jishnu Chaudhary, learned senior. I'm praying for a short passover, my lord. He's on his legs, my lord. Kindly will give me, because he was addressing on the point of maintenance.
Whatever, passover cannot be granted. It's already 11:33 and
My lord, will kindly keep it not today, my lord,
in
tomorrow.
that case it has to be adjourned.
My lord, tomorrow, my lord.
Now that they will report to your lordship whether they will withdraw the writ petition or will say to.
My lord, we had on the last, yesterday, Mr. Chaudhary was there. He was supposed to address on the point of maintainability, my lord.
This is the
Matter, my lord.
body.
That my lord, the internal.
Yes.
with
No,
regard to body.
so that we will address, my lord. It is concerning that,
Yes.
my lord, that
It's better I post it after the vacation.
no, my lord, tomorrow, my
Fine.
lord, kindly, my lord, will not today, my lord. He's on his legs, my lord. Otherwise, we have done, we are ready in the matter, my lord. Kindly will accommodate me one day.
The ethics officer is going to pass the order tomorrow.
That's
matter-
separate, my lord. My lord, that has nothing to
Hey,
do with that. My lord,
please come. An accommodation has been sought for.
my lord, kindly keeps it tomorrow, my lord.
On behalf of, it cannot be done every.
My lord, I will.
Then in that case, it becomes difficult.
My lord, I will start. Else I have no other option.
No.
Yes.
My lord,
There is nothing to start. It's only you have to make submission as to whether you'll go before the ethics committee
no, my lord, there
or
are two
before the
separate
ombudsman or something.
No, my lord, there are two separate complaints, my lord. Ethics officer, my lord, my humble submission is that's a separate procedure altogether. My lord, the instant matter which has come up, this has come up from the proceedings of a complaint which has been filed before the learned ombudsman. Learned ombudsman was pleased to refer it to the Apex Council. What is this dispute, my lord? I will just briefly say.
No, it has been mentioned last day. Enough time was consumed in this matter.
My lord, 2 minutes, my lord, I'll just take.
Nothing.
My lord, 2 minutes, my lord. My lord,
Okay,
this is a
nothing.
complaint against the treasurer of CAB. My lord, where there were certain allegations of siphoning of funds, which was made before the ombudsman. Ombudsman referred it to the Apex Council with the intent that the Apex Council will take a decision. My lord, why we have come up before this court is because of the procedural irregularities which have happened in referring and disposal of the complaint, my lord. My lord, as far as the CAB rules are concerned, my lord, it specifically speaks about a provision which says that the ombudsman will take a decision. Now, what has happened in the case, my lord, this is absolutely separate from what has happened before the ethics officer. That's a separate proceeding. Before here, the treasurer who is holding the post before CAB has siphoned of funds, and basis being agitated by that, the members have filed a complaint before the ombudsman. Now, ombudsman says that let the Apex Council decide. We write, the writ petitioners write to the Apex Council saying that you kindly gives me an opportunity of hearing. We will come and represent our case. Nothing happens. The meeting is fixed. It is decided behind our back in violation of the principles of natural justice in a meeting where the person against whom the accused was also present. So, my lord will kindly see. My lord will kindly see the minutes, my lord. My lord, this is the case. My lord, I will show from the Supreme Court judgment 2015, where the Supreme Court has said that BCCI also comes within the realm of Article 226, considering the nature that cricket is a popular game and the nature of functions being discharged.
The functions or the allegations that you are making has got nothing, no public element involved. It is absolutely a inter-party private dispute between the members of
my lord, when my lord says that it's inter-party private dispute, my lord, it is against the treasurer, somebody who is discharging the post of a treasurer.
Right.
My lord will kindly see, I'll just clear 2015 judgment. My lord will kindly see 2015 3 SCC 251. My lord. My lord, this relates to the matter where the status, this is the basis of which the Lodha committee was formed, my lord. The Lodha committee, my lord, went into a lot of recommendations, said, keeping in mind the nature of the game and the popularity it enjoys in the nation of India, for that purpose, there were certain recommendations being made. In that, several recommendations.
Please show me.
Yes, my lord. My lord will kindly come to paragraph 22, that is at page 275, my lord. I'll take.
Why don't you go to the conclusion?
My lord.
Conclusion portion.
Yes, my lord. I'll just the Article 12, my lord. This deals with.
No, Article 12 I can understand. Yes, you show me how this private dispute can be resolved.
My lord, it is my humble submission, my lord. There is no private dispute involved out here, because it is a question of the duties being discharged by a person who is holding a had it been a interstate dispute between the clubs, but here the role is of a treasurer. That is why it was referred to the mechanism under CAB, and where the apex council is taking a decision. So it is my humble submission, my lord, that while deciding such a complaint, the rules of natural justice as well as propriety has to be followed out. My lord, it cannot be done in a manner which is arbitrary to the rules and regulations. My lord, as far as the apex council is concerned,
You are not agreeable to go before the apex committee or council.
my lord, that is from where we are coming, my lord. The decision,
Right.
yeah.
Then the ombudsman is there. There also you will not.
My lord,
go.
the mechanism, my lord, I'll just take
You
2 minutes.
only want the writ court to enter into.
My lord, the nature, because we have already exhausted, my lord. My lord, when we went before the learned ombudsman referred it to the apex council. My lord, with saying that it has to be decided as per the rules and regulations of the CAB rules. We followed that procedure. We wrote to them saying that you kindly give us a opportunity of hearing. Behind our back, without any notice to us, without following the due process, my lord, my learned senior had shown the rules, which provides that within a time period, the CEO has to decide.
If that be so, then again you can appeal before the ombudsman. If this is your grievance, you can again appeal.
No, my lord, the nature of the forum.
Ombudsman referred you back to the apex council. Apex council, without hearing you, passed an order. If you are aggrieved,
my lord, but nature of the dispute and the manner in which violation of natural justice and propriety, this order cannot stand. My lord, the writ court will have jurisdiction in deciding that, considering the arbitrariness and the perversity.
Please come.
My lord, will kindly keep.
The petitioner alleges illegal and arbitrary action, as well as defalcation of funds by the treasurer of the Cricket Association of Bengal,
for which he has already filed a suit, and not the High
My lord, that is a separate, my lord, that
Yes.
is the intersave, that has nothing to do with the instant complaint, my lord.
Stop. Next. The respondents raise a preliminary issue with regard to the maintainability of the writ petition. Stop. The respondents are directed to file their affidavit within 7th November. Reply, if any, within 21st of November. Liberty to mention the matter for hearing. The issue of maintainability is kept open. Don't call any other.
May it please your ladyship. I pray appear on behalf of the petitioner.
Sorry to go before your lordship. There was a direction for filing affidavit in opposition.
The last order was on 22nd of July.
4 weeks, my lord. If my lords, I beseech my lord to extend it by 2 weeks, my lord. And my lord, 1 week, my lord, we shall, the instructions have come, my lord, but belatedly it will come, my lord. This week I'll complete.
Your ladyship, with respect, I will not object to my learned senior. However, I am literally suffering because I was liable to pay the PF and ESI for this contract employees. Now, I couldn't pay because there were funds which are already stuck with the concerned department. So I request my learned friend to file it within 2 weeks so that I can reply 1 week thereafter. And I pray before your leadership, let the matter
So
come.
what is to be decided? What is to be decided over here? You want to pay your employees PF?
No. This particular dispute arises out of a contract.
And how are you suffering?
I am suffering because I was subjected to provide manpower to Ichhapur Rifle Factory CBSE school. Now, this manpower which I was providing, I was liable to pay their salaries as well as the other benefits. Now, there was a termination of the contract which I'm challenging.
This
But
is the challenge to the termination.
yes, I'm challenging the termination.
All right.
What happened?
Please come. On the prayer of the learned DSGI, time to file the affidavit in opposition stands extended till 25th September 2025. A reply, if any, by 7th November. Liberty to mention the matter for hearing after conclusion of affidavits.
Your Ladyship, it is in between the vacation. I will serve my. I'll serve my reply so that
Yes.
let it be within the first week after reopening of the after the vacation.
What will it be?
For hearing, yes. I'll share my reply
Hearing
within that
can
time.
be,
7th
hearing will be before the bench having determination. We do not know what's going to happen to the bench after the vacation.
But I'm very
So-
hopeful that your Ladyship will listen to this matter.
How? If the bench does not remain, there is no question of
But if the bench
hearing.
remains, your Ladyship will take it
Then
up. At least
don't
let it
know.
be on the first week. Let it be listed on the first week after reopening. It's a humble request, your Ladyship.
List in the combined monthly list of November Korodin for hearing.
But in
Yes, monthly list of November hearing.
in
It's
that
all right.
case, it'll again go. I filed this matter around March.
I understand, but then it cannot be done. Next.
Much obliged, your Ladyship.
Ma'am, for the petition.
Yes.
It is that mother and daughter matter already.
Was referred to the
Yes.
petition over here.
Communication has been.
And for the respondent number 3, my lord,
You
the
received a communication.
yes, my lord, the mediation center has already appointed an arbitrator, my lord.
Yes, that is the letter.
Honorable Justice Shubhrata Talukdar
Right.
has been appointed, my lord. The next date has been kept on 10th of September, my lord. That is tomorrow.
Very well. Please come.
Let us hope for the best for good solution if comes.
Acha. The Member Secretary Mediation and Conciliation Committee, High Court Calcutta, has brought to the notice of this court that Honorable Justice Shubhrata Talukdar, as his lordship then was, has been engaged as mediator to help the parties to arrive at a solution to the dispute that has cropped up by way of mediation. Stop. It has been brought to the notice of the court that the mediation has been fixed on 10th September 2025. Stop. Next. In view of the above, hearing of the writ petition stands adjourned till 25th September 2025 for recording further updates. The parties are directed to cooperate with the mediator at the time of mediation. Next.
Grateful to Lord.
এটাকে রেখে দেবেন তো?
Let it be kept with the record.
Yes.
Much obliged.
Lord, this is a pathetic case, Lord. The old man.
How have you served the bank?
My Lord, yesterday my junior mentioned, and I tried to serve them, but
How did you try? How did you try to serve
I
them?
sent my man
Yes.
by hand.
Right.
I tried. Today I see that it has been listed, so I have stopped now.
Stop now means?
Stop now means I'm depending upon your lordship direction. Served them to Howrah.
Whatever it is, you have to serve. You could have served them through mail.
It has been served. Petition has been served, my lord. I filed the affidavit. It has been served. Affidavit of service is there.
What is your
They
grievance?
have received it.
What is your grievance?
My lord, just a minute. Affidavit of service. Affidavit of service. My lord, this is this is the case of cybercrime.
Yes.
My lord, this is a case of a cybercrime, and that has been my mobile been fully hacked, and thereafter my credit card has been totally, the amount from the bank has been shifted and has been taken. And that's why I got the message. I got the message mean my helper has received the show me the message from my mobile that my account has been fully exhausted
Yes.
within a night.
Yes. What is to be done?
Night. And that's why I lost the complaint then and there. Within statutory period, I have lost the complaint. On 16 March 24, it was hacked over the night. And I lost the complaint then and there on 18th before the bank. And that bank did not entertain me. That's why I had to move to the ombudsman. And ombudsman rejected my prayer, considering that bank would be liable for deficiency 70% and 30%.
Yes.
That is the order. Order means it has been received by me on mail. Now I have challenged the order, and regarding the inaction, police inaction, I made the complaint to the police, got the diary, and upon that I made the application before the Honorable Bench, Honorable Justice Tirthankar Ghosh. And Your Honor, my Lord, kindly see the order at a glance. It will help. It will help. It will help that the entire matter has been taken in view in the order by Honorable Court. Thereafter, police investigation made and the accused has been arrested and it has been detected. Monies has been recovered. But even then, bank raising day after day, the statement sending to me and sending the recovery agent to me and harassing me for claiming the payment on the interest, which amount has been hacked and
Please
which amount has been...
show me that the money has been recovered.
Money has been recovered by the police report, my lord, kindly see.
Why did you not implicate the police as a party over here?
Party? In this case?
Yes.
In this case, my lord, Lordship, Honorable Justice Tirthankar Ghosh has taken into finding, has been pleased, that it is not the determination of this court, you go to the proper bench. In page 67, my lord. (68) my lord, page. So far as the domain of the court is concerned, it is the sorry. It is directed that the police authorities prima facie have found out the case of the petitioner being defrauded by way of impersonation. Accordingly, the police authorities would arrive at their finding.
But then this court is requires the report from the police. You should have implicated the police as a party.
In this case, before your lordship.
Yes.
Before your lordship, police has not been made party. I can take leave of
leave
that.
is granted to the learned advocate on record of the petitioner to implicate the police.
Investigation still going on, ma'am.
As respondent in the instant writ petition and serve a copy of the writ petition upon the added respondent. Stuff. Let notice served upon all the respondents. Stuff released on 15th September.
In the meantime, not to claim, my lord, not to raise any claim, my lord.
Placed on record by the learned advocate representing the bank and the police. So, affidavit of service is taken on record.
Bank chasing every day, my lord.
Call the next. Item 4.
Lord, my lord, kindly seize this order, my lord.
Yes.
My lord, Mr. The learned ASG sir, he's on hearing.
Am I audible?
Yes, I can hear you.
Kindly see your losses are dated 20th August 2025.
Yes.
Your Lordship wanted an assessment of penalty for overstaying in India of the mother daughter. By order dated 29th of 2025, we have assessed penalty.
Where is the communication?
That is your Lordship wanted for your Lordship. That has been communicated to the client, I understand, by this order.
May I, my lord? My lord, my client also intimated the order to the FRRO via mail, but the inaction on the part of FRRO, he is not evaluating or calculating for the minor daughter.
Where is the
No,
calculation?
it has been calculated by order dated 29th August 2025. Is my
But
learned junior present?
Yes, somebody is here. Where is the calculation? Give the calculation.
Your Lordship, I have only one copy with me.
Let
Is
the
that-
court see what it
Yes,
is.
Your Lordship, I am submitting this.
Hmm.
29th. See, 29th August communication is addressed to you as the ASGI. Where is the copy to the petitioner? The petitioner is not aware of it. There is
No,
nothing on record.
that instruction I did not receive. Actually, it is given to me. Your
Yes,
Lordship
it's given to
what
you.
Your Lordship wanted us to assess, and we have assessed. It should have been, ought to have been
Really?
sent to the petitioner.
You are reading the last portion of paragraph number 3 of that order. And the first portion, the FRO was directed to intimate the petitioner the formalities required to be complied. Where is this intimation? There is no intimation to the petitioner. What is the FRO doing?
But I have already sent a representation after the order.
No, no, keep it with you.
No, it will be communicated today. You kindly record an order.
2nd September, but please.
See, I can see that the daughter has to apply for reapplication. The daughter has to reapply with a valid and new passport. Where from will she manage the passport? I do not know.
We have passport, valid passport.
The daughter?
No. This passport of the daughter.
When was it obtained?
Passport of the.
It has expired.
Expired, but
new
issued.
New has been issued. All right. In that case, you apply, get it done. The penalty is there.
Yes, my lord. We did not receive any.
I understand. Please come. The foreigners registration officer has calculated the payment required to be made on account of penalty of the petitioner's minor son and daughter. Stop. Let the calculation be handed over to the learned advocate representing the petitioner for taking necessary steps. Next Monday, I keep it, or Tuesday? Monday. You want it on Tuesday? Next Tuesday.
Tuesday.
Release the matter on 16th. Stop. All formalities be complied prior to the adjourned date. Give a copy.
Under the same heading.
Under the same heading.
Grateful.
Copy to
But I appear for the state. Last notice is my lord's pleasure was to produce him the document relied upon by the petitioner at the time of granting the certificate.
Supplementary affidavit. Supplementary affidavit was served upon you?
Supplementary affidavit served, and in the supplementary affidavit, the documents he has annexed, that was not relied upon.
Not relied.
Not relied upon at the time of we have brought the records.
My lord,
Yes.
my submissions are, my lord, the main issue for which my certificate has been cancelled is that I use the surname Shaw. And the order contains that the surname Shaw is not connected with the scheduled tribe Gond or Kharwar in both the cases. This is the sole contention. And my lord, at the time of grant, my lord, we had produced all these documents.
No,
Only one
specific
certificate.
submission is that these
No,
documents
my
were
lord,
not produced.
my lord, otherwise, my lord, the authorities concerned could not have issued the certificate. It is not a case that we have made any false representation before the authorities concerned while obtaining the certificate. And my lord, the Shaw's surname was there in all my documents prior at the time of obtaining the certificate. The certificate also contains the surname Shaw. So the my lord, the submission which my learned friend is making, that I have not produced the document at the time of when the grant was being done, my lord, is not correct. My lord, they could have rejected, could not have allowed me the certificate to be issued in my favor with the surname Shaw if it was not so. There were documents, my lord, on consideration of the same, my lord, it was issued. Now, my lord, if my learned friends say that I do not belong to the Gond community, my lord, they have to follow a proper procedure, my lord, because I have not suppressed the fact that I am using the surname Shaw. The basic contention, my lord, mass cancellation was being done.
What are you relying upon? What is this?
The documents your lordship has asked for, Lord.
Let them disclose it by way of, if I can see.
No, no.
No. I don't.
Please come.
My lord, now, my lord, can I? May.
I'm not.
Yes, my lord,
your lordship, can you pardon me? There is a mark, my lord.
Okay.
Lord,
Yes.
person, my lord, they relied upon the Kushi Shao. My lord, his application certificate also cancelled. And my lord, they already directed to proceed against them, my lord, under section 10 of the Act. My lord, this is bullet point one, lordship, kindly consider that.
Now, my lord, kindly just 1 minute, my lord. May I just submit, my lord. This is one aspect of the matter, the documents which I had produced at the time of obtaining the certificate. The case, my lord, that has been made out by learned friend in the order which was given to me on 6th of August 2025. That is the main order, my lord. Kindly see. I had filed a supplementary affidavit prior thereto, my lord, dealing with those documents. Ka supplementary affidavit ka? पुराना वाला old wala.
See, how much can the writ court enter into this?
My lord, I know, my lord, these are the things which are to be determined. But my lord, kindly appreciate one thing, that when I filed the writ petition, till the time of filing of the writ petition, the order of cancellation was not supplied to me. According to them, they had cancelled my certificate on 9th of November 2023. And my lord, when I filed the writ petition in August 2025, my lord, thereafter, my lord, a Xerox copy of the order is sought to be given to me, my lord. First of all, my lord, kindly see, during this period.
Listen, I don't think the writ court can help.
My lord, kindly appreciate one thing. What I was submitting, that what has happened, my lord, it had been a ground that I had obtained the certificate fraudulently or upon misrepresentation of facts, my lord. That could have been a case totally different. Even though there are decisions galore, my lord, which would say, suggest that even the persons were allowed to pursue the course. But I am not taking my course argument to that length. I had obtained a certificate on the basis of this in the year 2020. Thereafter, I appeared in the NEET exam in 2021. I was successful. I was admitted. Thereafter, I was given a scholarship also. I pursued my career in MBBS. For 4 years, I had continued my studies. My final year exams is only have been completed. Only the internship is due. So far as Abhijit Sai is concerned, he has to appear for one supplementary paper. But Sumit Sai has completed his course. Now, after the date of cancellation, according to my learned friend, is 9th of November 2023. Even after the cancellation of the certificate, according to my learned friend, which was never communicated to me, 15th of December 2023, on the basis of the said certificate, the same officer, what I'm suffering is my course. Where shall I go, my lord? I am suffering irreparable loss. In the meantime, my lord, my lord will appreciate. Authorities concerned will.
Reservation certificate issued in favor of the petitioner has been cancelled.
May I just submit one thing? My lord, kindly appreciate
The
thereafter.
petitioner, relying on the said certificate, took admission in the MBBS course. Stuff. It appears that আচ্ছা যেখানে cancel বললাম না date on 9th November 2023.
My lord, allow me to continue my studies. Let the authorities decide in appeal. I do not stand in the way.
The petitioner contends that the cancellation of the caste certificate was not intimated to him in proper time. Stuff. The it is only on the basis of the reservation that the petitioner got admission in the MBBS course. Stuff. According to the respondents, comma, the reservation certificate stood cancelled long ago. Stop. There is a provision for appeal which the petitioner may avail of. Stop. The court permitted the petitioner to rely upon the documents submitted by him for the purpose of obtaining the reservation certificate. Stop. Accordingly, a supplementary affidavit was filed with copy upon the learned advocate representing the respondent authorities. Stop. Learned advocate representing the respondents categorically deny that the documents annexed in the supplementary affidavit were supplied by the petitioner at the time of obtaining the reservation certificate. Stop. It has been submitted that the application was made online by relying upon the caste certificate issued in favor of one Khushi Shaw, his paternal cousin's sister, and reference ST certificate holder. Stuff. The application was processed as a second generation case, comma, recommended and approved. Stuff. After a hearing was provided to the petitioner, the petitioner, not after, at the time of hearing, the petitioner failed to produce any document in support of his relationship with the said Khushi Shaw. Field inquiry was conducted and the statement of the father of the said Khushi Shaw was recorded, and it was confirmed that the petitioner is not the relative of the said Khushi Shaw.
But Khushi Shaw's certificate also cancelled, my lord.
Based on the findings arrived at the hearing, comma, the reference holder's certificate, that is Khushi Shaw's certificate, was also cancelled. Step. Specific case of the respondents is that the caste certificate was obtained by knowingly providing false information, comma, fabricated documents and misrepresentation of facts. Step. The department intends to take steps under section 10 of the West Bengal Scheduled Caste and Scheduled Tribe within bracket Identification Act 1994 against the petitioner.
Against not petitioner, against Khushi Shah, my lord.
No,
They have not said.
Stop.
They have not said against petitioner.
The
My lord, and
one paragraph, whether the petitioner belongs to the reserved category or not is a factual issue which has to be decided upon appreciation of various facts. Step. The prima facie, it appears that the same cannot be adjudicated by way of a writ petition. Step. As the petitioner obtained admission in a course relying on the reservation certificate which was found to be obtained by way of fraudulent means.
My lord, it was not fraudulent means, my lord.
Accordingly, fraudulent means relying upon false and relying upon
No false
misrepresentation and fraudulent statement. Accordingly, the benefit under the reservation cannot be permitted to continue. Stop. It will be open for the petitioner to challenge the cancellation of the caste certificate before the competent authority in accordance with law if so advised.
My lord, after filing the
The
writ petition,
petition
my lord, we have also
and is hereby dismissed.
my lord, we have also filed an appeal. But in the meantime, my lord, I am relying upon two judgments of the Honorable Supreme Court, my lord, that I should be allowed to pursue my studies, my lord.
142, you go before the Supreme Court and get it done.
And my lord, this contention of my learned friend are denied, my lord, because they have not disclosed it. I have no opportunity to controvert them. But kindly record that the allegations made by the respondents are not admitted by the petition.
Recording Koronin. The aforesaid contention of the respondents are, however, denied by the learned advocate representing the petitioner. Next one is the same thing.
Same. Lord, this is the record, and Lord, the point taken Lord, by him, Vishwanath Shaw's relative.
This is not Khushi Shaw.
No, it's another.
This is Vishwanath Shaw.
Obhijit Shaw.
Acha ki Obhijit Shaw. Dekhi.
And
the reference certificate holder is who? Who is the reference certificate holder?
He also withdrew, I annexed that document at last page, his own statement, he withdrew that certificate because he is not belonging to that
community.
That community.
ওখানে খুশি ছিল, ওখানে রাজেশ কুমার শ। এটা হচ্ছে প্যাটার্নাল আঙ্কেল। ওখানে কি প্যাটার্নাল বললাম কিনা একটু দেখে নেবেন। ম্যাটার্নাল ছিল, এখানে তাহলে প্যাটার্নাল রিলেটিভ। আচ্ছা, মাইগ্রেটেড রেফারেন্স ওখানে ক্যান্সেলড হয়েছে, তো এখানে হি ভলেন্টারিলি সার্টিফাইড হিজ ওন। This has to be copied. Relationship is also false.
Will it be my lord's pleasure?
Here also the candidate is a medical student.
Yes, my lord, same. My lord, only one thing, will it be my lord's pleasure to record that my basic challenge in the writ petition is that the procedure for cancellation was not being followed by the authorities. Order was not communicated. This has been communicated only after Xerox copy, after filing of the writ petition. And petitioner was allowed to pursue the studies.
And the procedure followed for cancellation of the certificate was not followed.
And
yes. All right, next. 8.
The documents will be produced for your lordship.
Yes, it will be written with the records.
Your lordship, I appear for the state, your lordship. Your lordship, your ladyship, any submissions before being made, I would like to make it clear that Mr. Somnath Ganguly and Vikas Goswami was appointed the advocate for the state earlier. Now Mr. Somnath Ganguly has been promoted. Thereafter, the new state advocate Sonal Sinha has come into picture. So we need some time to get prepared. I am seeking for a not today.
Your lordship, Miss Sinha is appearing for EKWMA. I am there for EKWMA.
All right. Yes.
Your lordship.
If your lordship kindly.
Water bottle is being filled up, please.
Lordship, kindly.
I annexed.
Your lordship, kindly consider, your lordship, the annexure P6 of the writ petition is page 35. That whenever we have received the complaint, we have forwarded to KMC because they are the main competent authority. Your lordship, as of now, we don't have the instruction because in our office there are some shifting processes there. We have immediately forwarded to KMC. It is expected that KMC must have progressed, and we will communicate with KMC from time to time whenever anything required from our end. Now, your lordship, relating to the official instruction, your lordship, we need some more time to get the proper instruction. Kindly consider page 35.
Fortunate KMC.
You can see the synopsis of the case. This is against the EKW authority.
Yes.
EKW authority.
You please tell me whether have you found that there is any water body which is being constructed upon?
My lord, I have not really, my lord, I tell you, Lordship, because it is relating to entire defined area managed by the East Kolkata Wetland Management Authority. There is a defined act. And my lord, whatever things are happening there, that is to look into by that authority. My lordship asked me, my lord, my officers, my lord, to go and visit and they, whether the water body is really filling up or not, I can, my lord, report to lordship. But my lord,
আমাকে
I
যা
find that
বলেছে আমি
that the
সেটাই
India
বলছি,
report
বুঝেছো?
that the
What steps have you taken pursuant to page 35?
না এটা মিস
দেখে নাও ভাই, নাহলে আমি কেন
23rd 6 2025.
It was in June and today we are in September and I'm sure in the meantime construction has been made over the water body.
এক সেকেন্ড ভাই কি বলছো দেখো
আমরা KKWM এর হয়ে আছি। হ্যাঁ,
Did you take any steps?
ঠিক আছে।
এটা কি করে হলো সোমনাথ গাঙ্গুলি ও তো স্টেটাস অ্যাডভোকেট আছে
এবার
Please come.
স্টেটটাকে চেঞ্জ করে দিয়েছ।
চেঞ্জ করে ওকে ওর নামটা দিয়ে
না
দাও।
হবে না।
তাহলে বলো এটা your ladyship, one thing I would like to clarify. My learned friend had just informed me that Sonal Sinha is appearing for EKWMA and her name has also been suggested as a state advocate for this particular matter. Now this cannot happen technically.
Listen, if you have a problem, solve it out with the person who is allotting the brief. Do not bring this to the notice of the court.
Your
The
ladyship,
court is here to see what the problem of the litigant is and to find a solution and to adjudicate. You have a problem, you solve
your
it.
ladyship kindly gives us some time to have a clarification. That is what
Yes,
I'm that
and
is what
by
I'm
the
just saying.
time the matter was there in the list for quite some time, in the meantime construction is going on. What is your authority doing?
Your lordship, I have just received
Please.
I've just received instructions. That is what my limited scope is.
Please, you should know where to stop. The matter relates to illegal filling up of a water body.
সেরকম হলে অনেক সময়
Stop.
ডুয়াল পজিশনে অ্যাপিয়ার করে যায়।
Neither the learned advocate representing the state nor EKWMA nor the Kolkata Municipal Corporation are ready with instruction as to whether the allegation of illegal filling up of water body is proper or not. All the parties seek time to take instruction. Stop. All the aforesaid three respondents are directed to cause a spot inspection to ascertain as to whether the water body, description of which is appearing at page 35 of the writ petition, is proper or not. The report of spot inspection shall be placed before this court on the adjourned date. Spot inspection. The spot inspection shall be conducted by 22nd September. Release this matter on 24th of September.
Deeply obliged, Your Lordship.
In the event it is noticed that unauthorized construction is going on over a water body, immediate necessary remedial steps shall be taken. Next.
Service kept on record.
Yes.
Grateful to
obliged.
your
Grateful, ma'am.
Please, Your Lordship, this is my application. The affidavit of service, it's appearing after service, my lord. This is writ petition is assailing a final order passed by the national. Writ
Yes.
petition, my lord, filed assailing a final order passed by the National Consumer Dispute Redressal Commission, allowing the insurance company's appeal, which had been, my lord, my complaint before the State Commission had been allowed. That was overturned in appeal. My lord, the only interim relief which I was humbly praying, my lord, is the monies which were deposited by the insurance company pursuant to orders of the National Commission. Your lordship, kindly come to the impugned order once, please, my lord. Kindly have page 168. The order starts.
Yes.
Kindly see page 172, the operative portion once, please. My lord. An order was initially passed. I'm sorry, final judgment order was initially made. That was corrected. Kindly see the operative portion, my lord. The present appeal may be allowed with costs under section 26 of the Consumer Protection Act and the statutory deposit of rupees 35,000, and the 50% award amount with interest deposited by the appellant may be refunded with accrued interest. Similar to all that, I'm humbly praying, my lord, the amount was pending during the entire proceeding of the appeal, because that was a condition imposed by the National Commission.
What was the award amount?
Beg your pardon, my lord?
What was the award amount?
The award amount was, my lord, 86 lakhs plus interest. This was in respect of a
50%.
fire claim. My equipment, which was being transported by a truck, caught fire. So the claim was repudiated on the ground of exclusion clauses in the policy. That was rejected by the State Commission. I was awarded the entire amount along with interest. They preferred an appeal. The appeal was allowed. So, my lord, if your lordship kindly sees the prayers once, please, my lord.
50% of the claimant deposited the State Commission in a fixed deposit.
जानी रे भाई, National Commission in order थे तो.
Where the
Kindly see
refund.
page 37, please, my lord. The National Commission had directed the deposit to be made with the State Commission because the execution would lie there.
Where is the money now?
Money is lying with the State Commission unless my learned friends have withdrawn.
Milord, this notice of upgradation, Milord, my client has received, but Milord, the original copy of writ petition, Milord, is not with my client. May I just have-
Affidavit of service दिखाने को.
Because on 3rd, Milord, this notice of upgradation was sent.
Right.
Before, Milord, my client has received that.
The copy of the writ petition was not received.
Milord, my client, Milord, says he hasn't received the copy of writ application, Milord.
এটা upgradation normal service টা কোথায় দেখান?
August, there is a copy
Yes, my lord. Above writ petition enclosed for your ready reference.
with a copy of the writ petition and the affidavit of competency. It was posted on 21st of August.
Yes. But I'll hand over a copy to my learned
Please
friend,
do.
my lord, please.
So that he can at least go
Yes,
through it.
he can assist your lordship, my lord.
22nd of August, possibly it was received by your client.
Milord, maybe, Milord, but
But I'll hand
Very
over
well,
a copy.
take-
I'll hand over a
give a
copy.
copy.
That's not a difficulty, my lord.
Yes.
And all that I was humbly praying, my lord, is the prayer H, if your lordship kindly considers at page 37, let them not withdraw the monies, my lord.
But without him going through the writ
My lord,
petition,
kindly
will it be
not
proper?
today, my lord, I'll give him a copy today. Then
Give
kindly
a
give him
copy
whenever he
and
wants to.
just inquire where the money is. And the interim order he seeks. Please come.
Milord, on Friday, should be my
All right,
lord's
Friday.
pleasure.
The petitioner prays for issuance of interim order in terms of prayer H
H and I, please. my lord.
and I. Stop. Learned advocate representing the respondents shall come ready with instruction. Released on
मैं किसके लिए हूँ?
Friday 12th.
Lordship, Milord, Friday.
Let a
Kindly give me a
copy
paper, my-
I'm for.
of
Only for the
the
respondent number
Lord,
one.
I'm for
The
respondent
commission
number
should
one.
not have been made.
Panchayat
30, but-
respondent number 1. Who is the other one?
No, no, it's the commission has been made, my lord, should not have been made. We'll, if your lordship grants me leave, my lord, I'll delete the name of the commission.
Please
The
do.
tribunal is generally not impleaded, my lord.
The advocate on 1, respondent number 1 থাকবে. The advocate on record of the petitioner is granted leave to delete the respondent number 2 from the array of respondents.
Grateful, my lord.
Friday it's coming.
Grateful.
Bless your Lordship, Milord.
Next.
extra copy है क्या? Extra copy नहीं आता है. Lord, I'm appearing, Milord, to the writ petitioner. Milord, this is a challenge, Milord, to the revocation of, Milord, the scheme act, Milord, which has.
Incentive Act?
Yes, Milord.
I'll fix it on 7th of November. That is
Milord has passed some orders.
right.
With regard to that, Milord, I find, Milord, the Ultratech, Milord, has fixed it. Yes, Milord, has fixed it, Milord, on 7th of.
There are various matters, not
Yes.
one, several.
Milord, because
About
Several
10
instances
10,
given.
11 matters are
10.
You check my NH.
7th of November.
item 10 is
You have a copy of the order that
Well, I have a copy of it.
Please.
This is in the first matter, this can be the order. In the second matter, of course, we need an interim protection, which was granted in.
opposition in one matter, if you can file, that can cover all. But then they will not get to know what these facts may differ.
Yes, let them.
Item 11 is concerned.
So,
To some extent,
10 target.
10 is different.
Different. 10, I'll, please come. এখানে না অপোজিশনটা করে দিন 26th. By 26th, can the opposition be filed? 26th of September, last day.
Today we are on 9th.
9th. Fact. Points of law mainly. Reply, if any, by 6th October. No, November.
দুটো মামলা হচ্ছে
দুটো কারণ
এটা বাদ যাচ্ছে all right 11 what is the difference?
11 there is part of incentive is already given to us.
Revocation you want this?
This is a similar order past
I don't think there's any apprehension of recovery.
No, that's the order which was passed.
The provision says that if anything has been paid in excess.
And similar facts here also, we also.
Honorable Supreme Court
also. In fact, in this matter, I think last order was passed. In item 11, item the quantity quantified. In fact, previous one. Look, the dates can perhaps.
Yes. File affidavit in opposition. আগেকার ডেটটাই দিয়ে দেবেন এফিডেভিট ইন অপোজিশন হবে এও রেসপন্ডেন্টস আর ডিরেক্টেড টু ফাইল এফিডেভিট ইন অপোজিশন আগেকার যে ডেটস গুলো দিয়েছি 26th সেম করে দেবেন ওখানেই আছে এটা original settlement matter. The respondents are restrained from initiating any proceeding to recover any benefit already granted till the next date of hearing. ঠিক আছে লিবার্টি দেওয়ার দরকার নেই এখানে লিস্ট অন 7th
appearance টা দিরো নলে আবার আগের appearance টা চলে যাবে
all right
but
okay না দেয় নিচের দিকে দেয় শেষে
they should first one the order which we gave is item 10.
yes yes
item 11
এটা item 11 উপরে লিখে রাখুন
কস্টেলটা দেখে নেবেন কিন্তু কস্টেল আবার এটা
item 11 put it inside the file so that it remains in the same file.
Number change হবে এত
the cost title will change
petition number and cost.
It is only the
yes
ordering part.
I'm just being extra careful.
It happens.
That's why again we have to travel to come and say please correct my appearance or correct my
yes next
I'm grateful both 7 November and in the second matter exception we have to file that also has given us a date. I'm grateful.
Item number 12.
Well, my lord, I am appealing for the petitioner.
Of the state is the question.
I am for the private respondent number 12 to 7.
Wakalatnama
My lord, paying for thought pass over my lord. Mr. Sansa appearing in this matter, he is busy and court number.
Wakalatnama
I don't know my.
you don't have
I am not. I don't know my lord. Mr. Sansa appearing in this matter. He over the phone request me. Kindly
My lord, kindly see for a moment page
1
number
minute.
39.
1 minute. Mahashtala Municipality. Service.
Service, my lord, I sir.
You are for the state.
I'm for the state lordship.
Then EKWMA. Sonal Sinha must be appearing.
Yes, my lord. So where is she? That both they are
The answering respondents.
My lord, yesterday I informed Mrs. Sonal Sinha. My lord, she informed me that she did not receive any copy or instruction yet. My lord, this was
Her
information.
junior was here just now. Please, call him and inquire as to whether they are appearing or not. Mr. Sen also appears in some matters. Mr. Sen, EKWMA, you appear in some matters, isn't it? East Kolkata Wetlands.
Yes.
Huh?
I appear. Sir.
Even he appears.
I appear. Yes.
Do you have any instruction? I do not know. There are councils who appear. Here is a case where illegal filling up of water body. So please check up. I do not know who is going to appear.
Let Mr. Sen is here. Let Mr. Sen is appear in this matter.
Yes, one nice copy of the application.
And in the meantime,
Where is the complaint?
My lord, complaint that is page 23. My lord, as per my complaint, my lord, several steps has been taken by the authority. Page 39, my lord, kindly see for a moment.
Yes. 39.
Page 39, my lord, already Wetland Authority intimated to the Executive Officer, Mahasthala Municipality, to take necessary steps and take necessary action accordingly. And then page 40, my lord, additional district magistrate also intimated to the block land.
This is more than 1 year back. 24.
My lord, last, my lord, if your lordship kindly say for a moment, my lord, please, my lord, kindly come to the report filed by the report sent by the inspector in charge. My lord, page 42. Here, inspector in charge also, my lord, intimated to the Mahasthala Municipality to take necessary steps as water body filled up. If your lordship kindly see for a moment, page 42, which was intimate also forwarded to the superintendent of police. Page 42. But respondent number 12 and 12 to 21, if your lordship kindly see for a moment the picture, which they are in full swing, their construction is running on page 48 onwards. And inspector in charge also, my lord, directed to the concerned, my lord, local bodies to take immediate necessary steps to restore the water body in its original form. As per my written comment.
Page 44, there is a circular of the
yes, my lord.
Government of West Bengal.
Yes. That is in terms of the order of this
Division bench.
Division bench order.
In appeal matter. Even then the water body is being filled up.
My lord, may I tell one thing? My lord, a special statute is, my lord, there, and my lord, already, my lord, the special forum is there, that is Green Bench Tribunal, with regard to this type of filling up of water bodies and complaint, because, my lord, the conservation of the, my lord, the not only water body, but the entire, my lord, the I think, my lord, the air pollution and everything. So all these type of, my lord, the matters or issues relating to this should be filed before there.
But then when it is brought to the notice of the writ court,
yes,
that this is going on, will the authorities not take any steps?
I say that
Please see that something is done. Please come. By this way, the water bodies will be filled up.
Dragging the proceedings.
No, there, my lord, the regularly, my lord, the
water bodies will be filled up.
are also being passed there.
What is the effect? How many demolitions have been made, you tell me?
I'm for the private respondent in this matter.
Where is the wakalatnama?
I have filed in the department.
Hey, please check.
The East Kolkata Water Management Act is not applicable in this case.
Yes, what is applicable?
This is outside the jurisdiction of this particular act.
Very well. Now, under which provision you have right to fill up a water body?
This was not at all a water body. Though it is recorded as pond, this was not water body.
Kindly, the recording still remains.
Kindly consider the statement made in the writ petition.
The recording remains.
In the record, it remains,
yes.
but
and you did not take any steps for correcting the recording.
There is no water body.
No water body. How can the water body remain? Because you have filled it up.
No, municipality has already constructed underground drainage.
Municipality has also constructed.
There is no water body.
কি বলে? The petitioner complains illegal filling up of water body under the Maheshtala municipality area. Stop. None represents the municipality. Stop. Learned advocate representing the private respondent.
Private respondent number, my lord.
Number
12 to 17 and 20.
12 to 17 and 20. Submits upon instructions that though the plot in question is recorded as Pukur, but actually the same is not a water body. Stop. Next. It has been submitted that the municipality also made construction
Long ago, my lord,
over the said land long ago. Right? Next. None represents the East Kolkata Wetlands Management Authority. Stop. Next. From the documents annexed to the writ petition, it appears that the State Wetlands Authority intimated the executive officer of the municipality.
And my lord, the photograph annexed, this is not the photograph of this particular area.
All right. Achha. To take immediate steps for conservation of the water body. Stop. Is the BLLRO a party?
Yes, my lord.
But the recorded owner has not been made party in this.
And my lord, page 42, the inspector in charge report to the SP.
Recorded owner has not been made party.
The Maheshtala municipality the State Wetlands Authority, the East Kolkata Wetlands Management Authority, and the Additional District Magistrate and the District Land and Land Reforms Officer are directed to conduct a joint inspection to ascertain as to whether the subject water body, description of which is mentioned at page 39 of the writ petition, is actually being filled up or not. In the event it is found that the water body is being filled up illegally, then immediate necessary remedial steps shall be taken. Let the report of spot inspection be placed before this court on 23rd September 2025. Paragraph. As none represents the East Kolkata Wetlands Management Authority, accordingly, the court directs the learned advocate on record of the petitioner to hand over a copy of the writ petition upon Mr. Amol Kumar Sen, learned advocate, who is present in court and who usually represents the authority before this court. Stop. This much is enough. Service is taken on record.
Report will let that be kept with the record.
What does the report say?
Has been said, the old things has been said, that this has been done. They have intimated that all this.
Reported date
and it appears from the police report there is no existence of any water body.
Because
only direction given to the municipality to restore immediately. A grateful man.
Next.
I am appearing on the appropriate.
Yes.
The
petitioner's husband.
Entire thing depends on the report of the expert body.
Expert body
my lord,
of
formed
expert body of
my lord, expert body, that is my lord,
This
transplant
matter
related
relating to I believe
verification committee that was my lord established under the Act of 1994. Let him place his case, then I shall place.
yes
my lord, this matter relating to my lord kidney transplant.
kidney transplant.
Yes. My lord, the petitioner's husband
Huh?
have the end stage renal disease, my lord. He
Yes.
required kidney transplant, my lord. So according to the statute recruitment, my lord, everything is done. The affidavit, the expert opinion, everything is done, my lord. Thereafter, my lord, till date, my lord, the authorization committee, that is by the government, my lord, not gave the proper NOC, my lord. So that's why, my lord, it is not happening. The hospital is ready. The doctor
Which
opinion is,
hospital?
my lord, Narayana Hospital, my lord.
Who is the authority to take a decision?
My lord, may I tell now?
The
Now it is my turn, Lord.
Kidney board.
But the
Authorization
authorization committee, verification committee,
Which
and
respondent?
the verification committee referred the matter to the board, and board will and board has taken a decision.
Has taken a decision?
Yes.
Let me
kindly
see.
have my lord.
Give a copy
এই
to
যে,
him also.
না এটা হচ্ছে ইনস্ট্রাকশন, এই কপিটা কোথায়?
আমাকে একটা কপি দেন না হলে
একটু দিও।
না হলে কি করব
My lord, kindly, my lord, have a look at the paragraph number 1, and then, my lord, the police verification report. It appears from serial paragraph number 6, and then lordship kindly come to
Possibility of involvement of middlemen and financial
Yes.
transaction cannot be
the
ruled out.
report. It appears from the police report because there is no blood relation between the donor and the donee. So there should be, my lord, the extreme, my lord, the caution in between that whether the, my lord, the kidney transplant
Yes.
regarding that, my lord,
Right.
the passage or on the.
Yes.
So, my lord, that report is at page 6, the police report, page 6 of the, my lord, the report.
Page 6.
Because
Yes.
the police verification according to Act 19.
Who is the donee?
My lord, the
Lordship, I am appearing for pro forma respondent number 7, the donor, your lordship.
And he gave the proper
and
affidavit, my lord.
eventually, lordship
The
kindly.
petitioner is the daughter of the
No,
person who,
wife of the person.
Acha, wife of the person who requires the kidney.
Require, my lord, kidney
All right, he is
transplantation, my
the
lord,
donee.
and
And then the donor is respondent number 7.
7. Yes.
How are you related? How, where?
My lord, the relation is not required according to the statute. I will refer the
And
statute.
then only, if not required, then the statutes they says that the matter should be referred to the verification committee.
Show
then
me
police
the
report,
statute.
And then paragraph number 8 of the report. State Authorization Committee, after careful examination.
Where from did you get hold of this respondent number 7?
Because they are a business friend, my lord.
Business friend.
Yes, yes, yes.
All right.
And
A
my lord,
friend?
I will place the statute as well as.
Friend is donating kidney.
Yes, yes.
A business friend.
Yes, yes.
Let me see. Let me see the act.
Affidavit is annexed with my petition, my lord.
Let me see the act.
If my lords want, my lord, he is present in the court itself.
Who?
So that donor.
What will the court do by
Because of that,
seeing?
if any submission is there, my lord, my learned senior
the
friend
donor-
submission is that there is
The donor
Yes.
come and we
This is the
say
police
that
verification
no
where
transaction.
yes, no transaction. And he is on affidavit, he is saying, his wife on affidavit saying that voluntarily we gave this kidney. He even present, he can present in the
let
court
me
itself.
see the act.
Yes,
Yes.
kindly see that.
দেখা কোন section দেখাই দেখা
Donor, subsection 2F. May I read one? Donor means any person not less than 18 years of age who voluntarily authorized removal of any of his human organs for therapeutic purpose under subsection 1 or subsection 2 of section 3. So any person, there is no such term that they ought to be a relative.
Yes.
No doubt. Now, my lord, section 9. Restriction on removal and transplantation of human organs or tissues or both, save as otherwise provided in subsection 3. No human organ or tissue or both removed from the body of a donor before his death shall be transplanted into a recipient unless the donor is the near relative of the recipient.
1A, where the donor or the recipient being near relative is foreign national or prior approval of the authorization, provided
No, this
that the
is not
authorization-
applicable because the recipient is not the is not the near relative.
1B, no human organ or tissue or both shall be removed from the body of a minor before.
This
his
is
death.
also not
related.
applicable. Mentally challenged.
Line 2, where any donor authorized the removal of any of his human organ or tissue both after his death.
After his death, this is
removal of
not
any
applicable.
authorized the removal. Notwithstanding 3A,
Yes.
notwithstanding anything contained in subsection 3 where any donor has agreed to make a donation of his human organ or tissue or both before his death to a recipient who is his relative, but such donor is
Who is his near relative? So it is not applicable. Which is
compatible. The second donor is on a
Just 7.
Chapter
Chapter 3.
The
Authorization committees.
there is an authorization committee.
yes. The composition, yes, my lord. The second donor is the first donor who is compatible biologically or is a donor for the second recipient. The second donor is compatible biologically by as a donor of human organ or tissue or both for the first recipient, and both donor and both recipient in the apostate group of donor and recipient have entered into a single agreement or to donate, that is C, 3AC.
Regulation.
To donate and receive such human organ or tissue or both according to such biological compatibility in group, the removal and transplantation of human organ or tissue or both as per the agreement referred above shall not be done without prior approval of the authorization committee. So the authorization committee is required. So the authorization committee is C, but my lord, without any basis, they just hold it. That does not the purpose of the law.
No, but then they have got
Then also kindly come to 10.7.
yes.
Section 10.
Yes,
I am in a hospital. No, you have not shown that. Section
10.
7, section 10, within 10, my lord, that is subsection or clause 7. Authorization committee and the what has to do.
Section 10 over here doesn't contain
Authorization
this.
committee.
There is no 7.
This is the regulation.
Sorry, আপনি রেগুলেশনটা কবেকার সেটা বলুন।
This is the act. Show me the regulation.
এটা করতে দিয়েছে আসছে
Of the report.
of the report.
আমাকে ওর পুরো রিপোর্টটা দিয়ে দিন।
না ওনাকে দেওয়া হয়নি, পুরোটা দাওনি।
হ্যাঁ, আমার এক পাতা দিয়ে দেন ফলে আমার কাছে মানে ঠিক আছে, একটা স্ক্যান করে দিন না।
This is a part of what?
Part. I think
It cannot be
Part of
understood.
the
some
regulation.
instruction regulation. Part of
If
regulation.
my lord, if I can peruse
And,
it, if my lord
yes,
have it, I
part of
can
regulation.
came with
And this is chapter 2. That part chapter 2.
No,
Arey bhai.
page 15 is different. It's a Gazette of India extraordinary notification.
Yes,
Check
yes.
up
Yes, I will.
something.
Both
Different.
it is regulation.
That means regulation.
That is
Regulation
regulation.
by notification.
Then this is
Regulation by
something different.
notification, that page has been annexed.
Only that page.
And this is the relevant page that is why
If my landed friend
7.3.
report,
Hmm.
I can take it.
7.
Take instruction and come back. Give a copy to
Please
her.
give a copy.
Please come. The petitioner
Full copy দিয়ে দেন, তাহলে
is the wife of a person diagnosed with bilateral chronic renal
আমার
parenchymal disease.
তার সঙ্গে বলবেন যে আপনাদের এই ডিসিশনটাও চাই, এই বোর্ড মিটিং এর ডিসিশনটা আর এই রেগুলেশনের ফুল কপিটা যেখান থেকে এটা পাওয়া এসেছে,
indicating serious and irreversible damage to both his kidneys requiring long-term medical care. Stop. The patient requires immediate transplantation of kidney. Stop.
দেখি জজ কি বলে।
The petitioner has been able to get hold of a donor who is the respondent number 7 in the instant writ petition. Stop.
voluntarily wants to give it.
The learned advocate representing the donor submits upon instruction. Shailesh, please check whether the respondent number 7 has filed the wakalatnama or not.
Yes.
Acha. Upon instruction that the respondent number 7 is a business friend of the
Family friend.
husband of the
Family.
petitioner
As well as
and voluntarily agrees to donate one of his kidneys to the patient. There is no wakalatnama filed.
he also, my lord, and he gave affidavit also, which is annexed to my writ petition.
All right. The affidavit disclosing voluntary donation of kidney
Yes,
by
as well as
the
his wife.
respondent number 7 and his wife are annexed to the writ petition.
Yes.
Stuff next. The petitioner applied for
Through proper channel.
obtaining a kidney through proper channel, but the same will take some time. Stuff. The petitioner has submitted a formal representation before the authorization committee for obtaining permission to use the kidney of the private respondent. Stop. The same is pending consideration. Stop. Paragraph. Learned advocate representing the state respondents submits that.
On paragraph 8, that matter was placed before the board meeting. at
Yes,
paragraph
yes.
8. Let that resolution or decision of the board
Submits that the state authorization committee carefully examined the case of the petitioner and the committee did not find any favorable aspect with regard to the claim of the petitioner and the private respondent relating to affection and emotional attachment of the donor with the donee. Stop. The case was not recommended for approval and hence rejected by the state authorization committee.
No, Malad, the rejected, it appears at paragraph 8, the second last sentence, and hearing at board meeting. So, Malad, it is not in my knowledge also that.
Last line. So this case was not considered
was
for
not
approval and hence rejected by the state
by the
authorization
state
committee.
authorization
No
committee.
specific reason was,
That reason of the very good.
but no specific reason was assigned.
Acha.
That we placed.
The committee has took note of the possibility of involvement of middlemen
Intended.
and financial transaction between the donor and the donee. Stop. Next. The but tell me one thing, once it has been rejected, what can be done now? Where is the provision for appeal? Is there any appeal provision?
I have to take instruction.
Check.
Yes, my lord.
Check up
In
instruct.
that situation, my lord, one order passed in Delhi High Court, my lord.
All right, go through it and come back. Let a copy of the report forwarded by the Director of Medical Education, West Bengal, and the Chairman of the Authorization Committee, along with all annexures, be handed over to the learned advocate for the petitioner for obtaining instruction. Next Tuesday, 16th. Madam, the wakalatnama is not filed.
My lord, the wakalatnama is filed, but the person who is uploading it in the is not available today. So that is
Because
why maybe
I
it is
cannot
not
see
filed.
that it has been
I'm getting
Filed
it done. I'm getting it done.
And but
It is filed, your lordship.
my lord, already affidavit on behalf of the.
No, it's all right.
And the wife also, as well as police verification also done well.
All right.
And that is also annexed with my writ petition.
Lordship, may I submit the appearance and I will get it
Yes,
done?
yes, certainly your
Because
appearance.
that is the requirement of Form 11, my lord.
Yes,
And
next.
that is also, the proforma is also annexed.
Next. Why don't you keep your bag somewhere? Do you carry it always? Is it the laptop or something? It's a laptop. All right. Yes. Yes, please. Yes.
This is the second round of litigation, madam.
Lordships kindly have, my lord, your lordship's last order, my lord, in the first round of litigation, appearing at page 54 of your lordship's brief, my lord.
Yes.
The lordship would find, my lord, that the petitioners are contractors who were aggrieved by certain clauses in a notice inviting tenders, my lord, which debars the petitioners without any fault from participating, my lord, in the notice in the tender process, my lord, simultaneously for storing as well as for carrying, my lord. My lord, since your lordships, since there was a representation pending, my lord, your lordships did not go into the merit, my lord, and directed, my lord, the state to consider. My lord, they have considered it and they have rejected it, my lord. This rejection order is before your lordship impugned in this petition, my lord, appearing at page 57 onwards, my lord.
Which portion is to be looked into?
My lord, kindly takes page 58, my lord. The very first paragraph, my lord, whereas it starts with whereas, my lord. May I place it, my lord?
Yeah.
Whereas, my lord, whereas the district authority is not debarring nor has imposed blanket restriction as termed by the petitioners upon anyone to participate in the tender process, my lord. My lord, kindly pausing here for a moment, my lord. The clause D2, my lord, which your lordship was pleased to peruse on the last occasion, my lord, was very categoric, my lord, that if I participate in either storing or carrying, my lord, then I will not be allowed to participate, my lord, in the other one, which necessarily implies, my lord, that if I participate in both, my application, my lord, candidature will be rejected for both of them, my lord, because that will be in violation of the tender conditions, my lord.
All right. So each of your contention was taken into consideration and rejected.
My lord.
What is to be done?
My lord, kindly, my lord, if you
Why will the writ court go into all these things?
my lord, may I submit, my lord? My lord, they are the tender committee, my lord. They have the right to frame the rules and regulation, my lord. But as I also submitted on the last occasion, my lord, those rules and regulation cannot be arbitrary, my lord, or unreasonable, my lord. If your lordship kindly sees the reasoning that they have given, my lord.
Yes.
First one, they have said mutual exclusivity. To
Yes.
deal with mutual exclusivity, they have given three reasons. One, smooth operation. Second, to obviate conflict of interest. And third, to select suitable agencies, my lord. My lord, all these grounds, my lord, does it gets defeated by participation per se? The obvious answer is no, my lord, because, my lord,
Listen, the court will not go into all these things. The reasons that have been mentioned
my lord,
does not appear to be so arbitrary so as to requiring the writ court to enter into it. And the other ones also, they want more participation.
my lord.
The one that you said it's restriction, according to them, they want specialized bodies to come into it.
My lord.
Right? Why enter into all this?
May I address your lordships on this count,
Yes.
my lord? My lord, the
the object of specialized agency, my lord, is misplaced for the simple reason, my lord, that the petitioners are already engaged in this sort of work. They have the credentials to support their requirements, my lord. They want to restrict in this district, particular Birbhum, my lord, whereas the petitioners are not under any restriction to participate in anywhere, my
Let
lord.
them participate elsewhere.
If my lord,
No,
kindly,
no.
my lord, kindly
Not only
my
that, my lord, on his
kind-
request, my lord, one
Mhm.
clarification has been made, and not only that, my lord, date has been extended. Who prevent him, my lord, to participate, my lord?
my lord,
He cannot.
my lord, kindly,
That
He
is
cannot.
he
This
cannot.
is why
Because
he is
yes,
aggrieved.
my lord, kindly takes, my lord. I have tried to collate few of the other tenders of other districts, my lord, which does not have this restriction number one, my lord. So the conflict of interest, whatever ground they are submitting, my lord, lordship's note, ICDS project is not a district specific project. It is a nationwide project, my lord. 23 districts are there in West Bengal, my lord. If this is a district specific ground, my lord, then this will not, it will be up, this scheme is in state and nationwide, my lord. So all these will also be there applicable in other
So
districts,
if
my lord.
district wants it to be restricted to its own district,
Well-
why will the court interfere?
My lord,
As long as service is provided to the persons meant for,
my lord.
the lactating mothers and the pregnant mothers, they are all there.
My
The
lord, we have been,
pregnant
my
women.
lord, it is not a case where, my lord, we have defaulted, my lord. If we had
You
defaulted,
have been defaulted.
well, if I am not defaulted, why your lordship is punishing me from participating, my lord?
Punishing
My-
you participate in either the storage
my
or
lord,
the
kindly
others by
my lord,
transportation, whatever it
my lord,
is,
kindly appreciate,
and you appear or participate in other districts.
my lord, kindly appreciate one aspect.
No,
My lord,
sorry.
kindly appreciate
Please,
one,
no.
my lord, kindly, my lord,
Please come.
kindly, my lord, kindly, my lord, kindly, my lord. If I'm allowed to participate, my lord, if they just change the date of the tender, my lord, I can participate if I'm rejected, my lord, in one. Let's say I apply for carriage, my lord, I'm rejected in carriage. My lord, I have an opportunity to participate in storage, my lord. I'll get that opportunity, my lord. Kindly consider that aspect, my lord. Because, my lord, I have annexed document to show that can be done sequentially, my lord. If your lordship kindly have, my lord. Kindly have, my lord. That has been done, my lord. Your lordship kindly takes, my lord. I have given so many examples, my lord, to show that these are done sequentially.
Yes.
My lord.
it has been extended, my lord, from August to September.
That is does not.
Two different. He wants two different dates. So if he fails in one, he gets a
Yes,
chance
my
in
lord,
the
that is-
other. I can
My lord,
understand.
kindly considers, my lord. I have given, my lord. Kindly considers, my lord. I have tried to assist your lordships, my lord. Kindly takes, my lord. Page 71, annexure P7, my lord.
Yes.
My lord, this is ongoing notice inviting e-tender, my lord, for the district of Purulia, my lord. Lordship kindly sees that this is only for district, no, second line, my lord. District level carrying out food stuff.
Yes.
My lord, this is only for district level carrying, my lord. There are no corresponding project level carrying or project level storing. So the sequence can be maintained because here only district. Now, my lord, kindly take the next tender. This is ongoing tender, my lord. Now it is floated, my lord. Not last date is even not over.
This is Purulia.
Purulia, my lord, kindly take
District.
Purulia district. But this can be done. They are saying it cannot be done.
No, if the authority in the district thinks that he can do it in a better way, in a different way, he is free to do it.
Yes, free.
It
My
will
lord,
not be
kindly
proper.
appreciate, my lord. If he does in that way and restricts my right to participation today, I will be, my lord, without bread and butter, my lord.
No, you can participate somewhere else.
Well,
Also.
I cannot have, my lord,
Participate in Purulia.
no, my lord. My storage location cannot be in a different location. My storage is there in Birbhum, my lord. Kindly appreciate, my lord. Kindly also take, my lord, 83, my lord, page 83, my lord.
Is aggrieved by the reasoned order passed by the district program officer.
Birbhum, my lord.
Who is the by the additional district magistrate within bracket development Birbhum, dated 27th August 2025.
Order.
Communicated to the petitioner by the district program officer within bracket ICTS Birbhum, video communication dated 28th August 2025. Stop. The case made out by the petitioner before the authority stood rejected on all counts. Stop. The paragraph, the respondent authority appears to have given reasons for rejecting the claim of the petitioner. Claim of the petitioners. Stop. The reasoning does not appear to be so arbitrary, requiring interference by the writ court. Step paragraph. Learned advocate for the petitioner submits that the authority may be directed to take a decision to extend the date of bidding in respect of storing and আচ্ছা ওখানে extend বললাম তো to fix different dates for the bids to be submitted for the purpose of storing and carrying. Stop paragraph. The court is of the opinion that the tender inviting authority is the best person to assess the requirement of the authority and fix dates and conditions accordingly. Stop. Next. Did you make a request for keeping two different dates?
Yes,
for
my lord.
where is that request?
My lord, in my last, if your lordship sees my, they have rejected it on the ground, my lord. Kindly see the reasoned order C, my lord.
That has also been rejected.
Yes, my lord, by saying that these are interlinked and run sequentially.
Right.
If it runs sequentially, it can be done so, my lord.
The said prayer has also been rejected by the authority. Stop. Next. The court is not inclined to interfere in the instant writ petition. The writ petition fails and is hereby dismissed. Service is taken on record. Next.
I'm grateful, my lord.
Item number 21.
Well, 21 is that matter where the petitioner for unauthorized absence report was directed to be submitted. The school has dealt with the said absence and board has approved it. Well, on the last occasion, Lordship will kindly see on 26th of August 2025, his prayer is already considered and prayer is already, no further prayer has been made here.
All right. Yes.
My lord, I am sending for the petitioner.
The petitioner was appearing in person last time.
Yes, my lord.
Right.
This time I am appearing for on.
Very well. Yes.
This time before your lordship. And my lord, before I proceed further and to understand the nitty-gritty of the fact, we need to unravel the truth and the nuance of the matrix of the fact. The person about whom these charges have been leveled, by profession he is a teacher, and throughout his teaching career, he has been very honest, sincere, cooperative, dedicated, and outright. And just on those grounds, he has been awarded the National Award to teachers in the year 2015. My lord, if you kindly give a glimpse at page number 39.
On the last occasion, the matter was adjourned because the petitioner intended to revert with his learned advocate. And if you want to deal with whatever is there, is a different thing. But what relief can be granted to you over here?
Relief, my lord, that actually the allegations we have been brought, these are all unfounded, my lord.
Very well. So you
Unfounded.
filed
And
separate
that- not
petition
only that, my
challenging
lord,
the same.
And
There is no charge sheet, no allegation.
Because, my lord,
Unauthorized
if your
absence, we
lordship
have
allow
dealt
me
with
to-
it, my lord. As
I
per
need
the
little
order of
time, my
court.
lord. I need little time to
Necessarily, my lord,
express my
dates in and
viewpoints.
dates
No,
of the
you
matter is
cannot
that.
be given the time because right now the decision of the managing committee of the school has been approved by the board. If you are aggrieved by the same, then a separate proceeding will come. What can be done over here? Here nothing can be done. In this case,
I'm standing before the court of the constitution, my lord. I think
try to understand one thing. The writ petition was for a particular purpose. The purpose has been served. What can be done here? If you have further grievances, further writ petitions will come. Over here, what can be done?
his salary has been withheld and all these things.
Obviously, because he has been found to be in unauthorized absence.
No, my lord, actually, I need to explain that part. He was not at all unauthorized.
Your explanation cannot be done over here. It has to be before a competent forum. You want your prayer is for regularization of the absence period and to pay the salary, right, on the basis of the order of the High Court by quashing the impugned disciplinary proceeding.
Milord, if you kindly, if your lordship kindly gives a look at page number 66, my lord, just my humble request, my lord. Page number 66. Page number 66, my lord.
Yes.
Here was an order dated 24/1/26. This order was passed by the secretary in charge. I will just read out the second last paragraph.
Yes.
May I kindly read out, madam, my lord?
The findings.
Findings. It transpires that the WBSC is kept completely in the dark about the happenings in the school, as no concerned parties has ever reported the matter to us, which tantamounts to utter callousness on the part of the school authority, my lord.
Please come to the last paragraph of that same page that you are reading.
Yes, my lord.
The board will take a final decision in this regard. The board has already taken a decision.
But on wrong ground, my lord.
Right. So challenge that order. Please come.
Challenge. No, another. We have to challenge this order.
Petitioner seeks for regularization of his leave period in school stuff. It appears that the managing committee of the school has passed order What is the decision of the school?
School has said that this is the portion unauthorized absence which has been approved by the board.
My lord, my lord, one thing
has come to a finding that the petitioner was in unauthorized absence. Stop.
My lord,
That decision of the managing committee was forwarded to the West Bengal Board of Secondary Education, and the board on 18th July 2025 approved the decision of the managing committee of the school. Stop.
My lord,
the
one thing.
petitioner
One
is
thing, my lord.
aggrieved by the same. Specific submission is that the petitioner was not in unauthorized absence, and the petitioner was deliberately not permitted to mark his attendance in the school register. Stop paragraph. The court is of the opinion that the decision of the board is not impugned in the instant writ petition. Stop. The same is a subsequent and fresh cause of action. Stop. If the petitioner is aggrieved by the same, comma, then the petitioner is required to challenge the same before the competent forum in accordance with law, if so advised.
My lord, one thing, my lord. During that claimed that is called absence period, that time he was engaged by the West Bengal Board and West Bengal Council also, my lord. Then how could it be treated as absence period also?
No, during the time he was in service. Thereafter you were elected.
In view of the above, the writ petition stands disposed of. It will be open for the petitioner to approach the competent forum in accordance with law. Next.
Grateful, my lord.
Yes.
In this matter, Lordship, I'm praying for 1 week accommodation, Lordship. Mr. Dash, due to some medical emergency in his house, Lordship, is absent, Lordship.
Lordship, on previous occasion, adjournment was sought that identical matters on the self-same cause of action are pending before a coordinate bench. On that ground, possibly on the last occasion, it was adjourned.
Yes, Lordship, but this time Lordship he is absent, Lordship.
What happened to that matter which is pending?
That is
All
fixed
these
on,
matters,
Lordship,
It's still pending.
yes.
Lordship,
But
those matter are
but-
fixed on 10th, Lordship.
All right. Learned advocate representing the petitioner seeks accommodation. Stop. In view of such submission, release the matter on 3rd November 2025. Next.
Well, this is my application.
my instruction is they have been
Yes, my lord, final bill has been payment. My lord,
nothing
but
remains.
they have illegally withheld my earnest money, security deposit
It
and
is
the
in
bank.
instruction.
My lord, since there is a illegally withholding since 2020. This is second phase. So some interest maybe I am entitled to claims interest towards the.
The earnest money has been paid or not?
That is
The prayer is regarding release of the 4th and final bill along with the earnest money.
that was their claim
Yes,
in the writ petition. It's
right.
that has been paid.
Now, he says it has not been paid.
Final bill payment.
That's right.
No, what about the earnest money and the security deposit?
Yes.
Security deposit possibly it has been paid.
No.
Sure.
No.
Then I have
The
to.
first time
Every day, if you come with only one instruction, then it becomes difficult. See, the matter is pending from 2023.
It was not known to me, my lord.
If the prayer is such,
There, but
then
on the last occasion, it was said that whether we have been paid, we have paid final bill.
we have
That is the thing, my lord.
paid the
you have to
final bill,
check
2
the
lakh.
prayer also. Please come.
In that event, my lord, your lordship.
It has been brought to the notice of the court that the 4th and final bill of the petitioner has been paid on 29th August 2025. Stop. It appears that the honest money deposit, the security deposit and the performance guarantee are also withheld by the authority. Are you sure they have not been paid?
Yes. It is illegally withheld. They have not.
Not illegal, legally or illegally, that is decided by the court.
Withheld by the authority. Stop. Learned advocate, prayer has been made to release the same along with interest on account of delayed payment. Stop. Next. Learned advocate representing the respondents is directed to revert with instruction. 23rd. 23rd.
Next Budbar.
No, 23rd
আরেকটা আছে এটা এখন তো
24.
24.
Yes, ma'am. My lord, kind pleasure to take it up 2 p.m. My lord.
Right.
ASG is appearing, my lord. Yes, this one. We are ready with the instruction, my lord.
2 o'clock it will be taken up.
Well, this is my application.
Sir, I tender apology for bringing the DSC is stuck in courtroom number 11. The matter is continuing. Pleasure to kindly keeps it on tomorrow. That is.
Let me hear.
Earlier occasion, you are also given the direction to
Yes,
take the appropriate.
Well, we are ready with the instruction. There are
Let me see.
notification, other things, which we'd like to place.
What is it? What is your claim? Payment?
Yes, my lord. I have completed
All right.
question, my lord, under the Monrega Pokolpo.
Uh-huh.
Monrega Pokolpo implemented by through my lord the BTO. BTO issued the tender notice. In terms of the tender notice, I was selected. I have supplied the materials, and FTO, fund transfer order also issued. But till that, my lord, the amount in question.
All right.
Presence of state is also required. Why? Because there are two types of fund.
Yes, the state
and
is
central.
there.
Yes, my lord. So, my lord, and there is a question of audit is also there. So,
Is the
unless it
state
is,
not here?
oh, my lord, state is not. My lord, kindly keeps it tomorrow. We'll come back. We'll have the instruction. We'll.
And FTO, my lord, I have annexed the all
Where is
FTO.
the state council?
Earlier occasion, my lord.
Sugata Shankar Roy and Sakhawat Khandakar.
Yes, my lord.
Where are they?
Madam, occasionally they appear, madam. Since the occasionally, madam, I have seen in this matter. When I asked his junior, madam, I am not interested to. My senior is not
We'll
there.
come back and submit all the documents. It is there. There are provisions in the law.
They have shifted
they have
the
not
burden
complied
upon the
there
setup
are law.
authority, my lord.
We are not against the petition, but there are laws which have not been complied with. The state will show that, my lord.
Suppose there are certain laws not complied by the state, why don't you
That
take
has
it
to
up?
be regularized only.
Why don't you take it up with the state authorities so that the person who actually performed the work can get the benefit?
My lord, will let it be placed before a lordship, and then my lord kindly decide.
And 2022 fund transfer order also issued.
All right. Get hold of the learned counsel for the state. I'll make it only not today.
Yes, ma'am. Tomorrow the same position.
Yes, same.
My application, my lord. This was taken up by your lordship on the last occasion. You know, this was where there's a stay from 2000.
Bank?
Yes, stay from 2003 of willful defaulter. Bank has not filed an affidavit or taken any steps. We had raised two issues primarily. One is that the identification committee has not been constituted in terms of the master circular. Second, the notice has been issued from a bank in Mangalore, whereas my privity of contract in the branch office was in Calcutta. And because every branch is a separate identity and entity now, there could not have been a willful defaulter notice issued by a different bank. This in effect becomes a different bank. Your lordship had directed or asked my learned friend to take instructions from the bank if they can issue a notice from here.
Yes, please.
It is not required. If your lordship takes the master circular once, it was annexed to the writ petition at page 20. Lord, there are certain, my lord, stages in the master circular. Your lordship knows that. Initially, the loan account has to be categorized as a willful defaulter. Lord, thereafter, my lord, the committee has to be constituted, and in terms of that committee, my lord, whether it is a willful or not, that the committee will decide. Lord, prior to that, they were directed to issue a show cause notice. The show cause notice has been replied to them. Thereafter, we had called them for a hearing, personal hearing. We had given them a notice. The master circular does not say that the notice has to be issued from the branch where his loan was operating. Lord, it says the notice has to be issued, a show cause notice has to be issued. We had done that. We had followed all the guidelines that has been provided in the master circular. Now, if your lordship takes the show cause notice at page 20, Lord, this show cause notice was issued by the Committee of Executives for the Identification of Willful Defaulters at page 21, my lord. My lord, here, the convener of the committee is conveying this letter to the borrower. This is a Vishnu Enterprises. Lord, he had given a detailed reply to this letter, the show cause notice. My lord, you will find it at page 45.
Thereafter, what happened?
Lord, thereafter, we had called them for a hearing pursuant to this master circular. Now,
Yes.
I just place your lordship the master circular, note at page 26. This willful defaulter 2.1.3. Lord, I have to show that he has defaulted in repaying the dues of the bank.
No, he has defaulted. Now what steps
Yes,
will you
now,
take?
Now, my lord, if your lordship takes 2.1.3a,
Yes.
the unit has defaulted in making the repayment obligations to the lender even when the capacity to honor the said obligations.
Yes.
The unit has defaulted in meeting the repayments obligations.
No, that is willful default. It is all right. Thereafter.
Thereafter, lordship now takes 3. Mechanism for identification of willful default. Lordship on the last occasion requested me to know whether this 3.2 has been complied with. My instructions are that 3.2 has been complied with. Now, if your lordship takes 3.A, sorry, 3.A. The evidence of willful default on the part of the borrowing company and its promoter, whole-time director at the relevant time should be examined by a committee headed by the executive director or equivalent, consisting of 2 other senior rank of GM and DGM. This has been done. If your lordship takes now the notice that has been impugned in this writ petition, that is at page where we had requested him to appear for a personal hearing. If your lordship takes page 50,
where at Karnataka?
It is at Karnataka, Mangaluru. Page 54.
54. Yes.
With regard to the above, as requested by your letter dated such and such, the committee has decided to provide an opportunity for personal hearing to you on the following date and venue. This order was stayed. Thereafter, my lord, we did not take any steps. Pursuant to this master circular, we had issued this notice. Now, your lordship will now takes the there is an internal communication. The internal, my lord, this is the minutes of meeting. May I just hand up to your lordship? It's very internal document.
Dated?
Lord, it is dated of 2022, 13 July 22.
Lord,
Prior to the stay of order?
Yes, my lord. Prior to the
Right.
Lord,
Yes.
this was done pursuant to, my lord, the show cause notice that was
Yes.
issued. This was headed by the head of the committee, that is a CGM. Lord, CGM is the rank. If your lordship takes now the master circular at 3, not at page 32. ED or equivalent and consisting of 2 other senior officers of the rank of GM and DGM. Now, this Karnataka bank is headed by the MD, Managing Director, and thereafter CGM. Now, CGM is the second post. Now, this first man is the committee headed by the Executive Director. Till 2022, bank did not have the ED. Now, in 2023 onwards, bank is having the ED. Now, this committee is headed by the CGM and 2 other officers, senior rank of the GM and DGM, and the 2 members of the general manager. So that has been complied with.
All right.
Now, whether
and this compliance, did you not communicate it to the petitioner?
Yes, it was.
No.
It was. Lord, this is an internal document. Pursuant to this, my lord, this minutes.
Page 54.
Lord, this minutes, pursuant to these minutes, my lord, we
Page
have
54.
This we are not privy to at all.
No,
In fact,
this
the
cannot be.
challenge
It is a 200
right.
pages, my lord, minutes. My lord, we cannot
Yes.
share this document.
Tell me one thing, can the arrangement of hearing be made from
But
Calcutta?
on the first day, my lord, I had pointed out, my learned friend, whatever suits you, we will arrange for that. Let him answer that.
He is a willful defaulter and he'll go on to the extent of whatever
Bank
suits
has
you.
not bank
Why?
is after now it is not up to your lordship. I leave it to your lordship.
May I
It's entirely up to your lordship.
May I just
Yes,
indicate
please.
one thing? Lord, this document, I don't know. It appears
The
that
court has not looked into it. Take it back.
Another thing, my lord, on the last occasion, my learned friend has stated, Lord, this the person who has signed is convener of the committee.
Yes.
The convener is a person, my lord, who conducts the committee. Supposing, my lord, if I give an example,
Yes, I
the
followed.
Prime Minister is heading a
Oh,
meeting.
1 minute. Yes, please. What is your allegation that it has to be done from here?
no, 2 things. Lord.
Yes.
Challenges on 2 counts. One is that this committee of executives for identification of willful defaulters is not in consonance with the requirement of the master circular.
Right.
That's for 2 reasons. So that if your lordship just has a look at page 21,
Yes.
11th of October 2022. This is issued at the top. Your lordship will find registered and head office so and so Mangaluru 575002. At the top left hand column, you lordship found that. Then kindly see regarding
your credit, firstly, your credit liabilities with our Kolkata AJC Bose Road branch.
Yes.
We have no privity, there is no banking transaction with Mangaluru branch of Karnataka. Immediately on this ground itself, this notice to show cause is bad because the master circular requires that only the bank with whom I have a financial transaction or a banking relation, they will be able to initiate a willful defaulter action against me. This I'll substantiate from the master circular, and I'll rely on one judgment of this honorable court that because these are all commercial banks, they're all independent entities. So, and if that had not been the case, the master circular would not have required this. That's first point. I'll substantiate that with two decisions. The second point is, Your Lordship will see at the top again at page 20, Committee of Executives for Identification of Willful Defaulters. This committee, if Your Lordship doesn't look at that today, what is given, if he files by way of an affidavit and takes an oath, but I'm assuming he's not going to do that, then Your Lordship will just have a look at this one, page 32 once.
Yes.
The evidence of willful default. Now, this is my third point of challenge, so kindly look at it slightly holistically. The evidence of willful default on the part of the borrowing company and its promoter whole-time director at the relevant time should be examined by a committee headed by an executive director or equivalent consisting of two other senior officers of the bank, the general manager or deputy general manager. From this page 20, it doesn't appear from anywhere that 2.3a has been complied with. There is no provision of calling it a committee of executive for identification. In my experience, Your Lordship also would have seen all these notices are issued with the names of the members of the committee, because that is your at least ostensible compliance of 3A. Today, I don't know what the bank is given. Bank is not bringing that way of an affidavit, so I take it what is there in my writ petition. This is not in compliance of 3A. Secondly, my lord, kindly comes back to 3A once more at page 32. The evidence of willful default on the part of the borrowing company should be examined by a committee. Now, Your Lordship will have a look at page 20. Your Lordship will not find any reference to any document here. So, this is apparently a show cause to which I'm asked to reply, and I have to reply, and then they call me for a hearing. So, now I'm attacking it on 3 counts. One is non-compliance of 3A. Next is, oh, I'm sorry, my lord, I should show this to Your Lordship once. Please come back to the master circular once, my lord.
Yes.
Page 26, guidelines on willful defaulters. Please see 2.1.1, definition of lender. The term lender covers all banks or financial institutions to which any amount is due, provided this, my lord, it is arising on account of any banking transaction. I have had no banking transaction with the Mangaluru branch. My lord, I don't know why the bank is also not willing to have a willful defaulter notice issued by the Kolkata branch. Now, yes, to substantiate this, Your Lordship will allow me to refer to one judgment that all scheduled commercial banks, when they have independent branches, each branch is a separate entity. And that gets further bolstered by 2.1.1 because I have to have a banking transaction. Lord considers this today.
The judgment?
Yes, Lord. Today I have entered into a banking transaction with the branch here. And some other branch in Mangaluru is giving me notice. My second point of challenge is 3A. The third point of challenge is, my lord, when you issue this notice to show cause, then you have to not only give all the documents that you're relying on to give me an opportunity to really reply, but also all underlying documents based on which this notice is issued.
Did you seek for?
I'm sorry, my lord.
Did you seek for those documents?
No, I reply, Your Lordship will see. I have taken this specific plea saying I have no privity with you at all. Kindly have a look at page 47 and 50. I'll show, my lord. Page 47, kindly see A.
Yes.
It appears the said notice decision to classify as a willful defaulter is a decision without jurisdiction. It appears that decision to include our names in CIBIL and other credit information company is sought by one committee of executive for identification of willful default. The names of the members of the nature and character of the members of the alleged committee for identification of willful default has not been mentioned. It further appears that the bank represented by the convener of the committee has taken the decision as alleged in the purported notice, which is utterly unlawful. We state that the purported decision could only be taken by a committee headed by an executive director. Then 3A is quoted. Letter is issued by a convener in his individual capacity is not a, and apropos your lordship's query, my lord, kindly turns over. I'm not troubling your lordship with the whole of it. My lord, kindly have a look at page 50. Last paragraph. I'm just saving time, my lord, because the rest of it is also on these lines.
Yes.
In this pretext, you are hereby called upon to withdraw the letter. It is the notice on the, or in the event you insist to proceed further, supply us the relevant documents together with the copy of the committee report on identification of willful defaulters so we can prepare a reasonable answer. This is in my show cause. Now 23 to 25, the bank has done nothing. Today also they don't come up with an affidavit to show how 3A has been complied with. From Jha developers to coordinate bench judgments, your lordships have held that because this is a penal consequence.
The judgment, please.
Firstly, on the point that this is a separate, unique identity. This is AIR 2008, Calcutta 148, the division bench judgment of this honorable court.
Yes. Which portion?
Yes, my lord. There is a detailed analysis. Page number. Kindly have a look at paragraph 24, first line. It has been consistently held by both the Honorable Supreme Court and this Honorable Court that each branch of a bank is a separate entity. This gets further. Paragraph will kindly turn over to paragraph 40 once. 40.
This relates to a filing of a suit. Every branch will have a cause of action. That's a different issue in respect of.
He will get his chance.
Not when the willful defaulter notice was issued.
Yes, please. Next. Which paragraph do you further rely upon?
Just give me 1 minute. একদমই নয়, পুরো detailed analysis ছিল. Kindly bear with me for a minute. Yes, paragraph 25. তোমাকে এই করে রাখো। 25. Honorable Supreme Court in case of Agency Commercial International Limited followed the earlier decision in the case of Delhi Cloth and General Mills. Now it is indisputable as a general proposition of law that a body corporates and its branches are not distinct and separate entities from each other, that the branches constitute more components through which the corporate entities express itself, that all transactions enter into ostensibly with the branches are in legal reality transaction with the corporate body. And it is with the corporate body that a person must deal directly. But it is also now generally agreed that in the case of a bank which operates through its branches, the branches are regarded for many purposes as separate and distinct entities from the head office and from each other. This court observed in Delhi Cloth and General Mills, in banking transactions, the following rules are now settled. The obligation of a bank to pay the check of a customer rests primarily on the branch at which he keeps his account, and the bank can rightly refuse to encash a cash at the branch. So and so, a customer must make a demand for payment at the branch where his account is kept before he has a cause of action against that bank. The rule is the same where the account is a current account or a case of deposit. The last two cases refer to so and so as a case of deposit. Either way, there must be a demand by the customer at his bank where the current account is kept or where the deposit is made and kept before the bank, neither the situs of the debt at place where the current account is kept. It was further held. Yes, 26. The learned counsel of the plaintiff also cited so and so, but none of these decisions are applicable in the case of Indian Overseas, the 56 Calcutta, which incidentally the bank had its head office in Calcutta. It may held down that when a bank has branches in different place, each branch is considered as an entity in itself, and a suit for dealings with the branch should be filed in the court within whose jurisdiction the branch has its office and not where the head office is situated. Now, it is true that this is with regard to jurisdiction, but jurisdiction because I cannot rope in a different bank when I have a different privity of financial transaction with one of its branch offices. Because each branch is a separate entity, I must have a financial transaction. My banking transaction is only and admitted as in paragraph page 20 in the show cause notice.
All
It
right.
is only with the office here in Calcutta.
Anything
And
else?
one more aspect, I am not shying away from meeting a case of willful default. It's about where my records are and where I go and make the representation, because these are penal consequences. It has to be strictly followed. This is first part of my submission. Second, because Your Lordship has seen at page 20, it is admitted that my credit liability is with AJC Bose Road branch. So 24 also does not get satisfied because he is not my lender, the branch in Mangaluru, because it does not arise out of any banking transaction. I have had no banking transaction with Mangaluru. First point. Second, my lord, Your Lordship will allow me to cite another decision, Bombay. My lord, this is 2024 SCC Online Bombay, page 745, the Division Bench Judgment of the Bombay High Court. My lord, this is with regard to willful defaulter. My lord will just come to paragraph 25 onwards. A plain reading of Takano would throw light on how the master circular must, sorry, my lord.
Yes, yes. Go on reading. Yes.
A plain reading of Takano, paragraph 25, would throw light on how the master circular must be construed. The master circular consciously enables inflicting penal consequences and underlines the imperative need to adhere to a transparent mechanism. The avoidance of information asymmetry and the means of ensuring transparency outlined by the Honorable Supreme Court in Takano would necessarily mean that the principles of natural justice, including the need to provide the underlying material, are inherent and implicit in the process stipulated under the master circular. The material and information question for disclosure to the noticee would be all relevant material and not just the information that is relied on or referred to in the show cause notice. Not only must the information that is referred to and relied in the show cause notice be supplied, but also information that may underline the allegations contained in the show cause notice, which may therefore not be referred to or relied on, must be supplied only to ensure that everything relevant to arrive at the truth is available to both the parties. The objective of the proceedings initiated by issuance of a show cause notice is not to somehow find the noticee guilty of willful default on the same terms as alleged. Instead, the objective is to arrive at the truth as to whether or not an individual in question is to be subjected to penal consequences. Therefore, if the bank has conducted a forensic investigation into alleged diversion and siphoning
we
of
are
funds,
not at this stage. Diversion of fund, forensic investigation.
This is at this stage, Manoj. I don't know if they've done a forensic audit report, possibly not, but they have whatever they're relying on in issuance of the show cause notice, that they must give to me. Now, if I just, for 30 more seconds, Manoj, beseech Your Lordship to come back to page 20.
Yes.
Your Lordship will, from this notice, not find reference to or mention of any document. It's just the conclusion. Well, this also is folly of 3B. I'll show that. With reference to the above, we like to inform that credit facilities availed from our Kolkata AJC Bose Road have been classified as NP on so and so. We have failed to credit facilities in spite of request. The bank has given ample time to clear. However, there was no positive response. Now, besides taking recovery steps, we have taken a decision to place your name in willful defaulters of RBI for the reasons mentioned below. Straight away reasons 1, 2, and then 128 is referred to, and I have to give a notice. I'm going to end now. Your Lordship will just come back to once what the master circular requires them to do. Well, the first line at 3A, based on which this Bombay High Court Division Bench judgment is passed. The evidence of willful default on the part of the borrowing company, its promoter, at the relevant time should be examined. So from the show cause notice, your lordship will not find any examination of the evidence. That's one. It's just a conclusion. Secondly, whatever they have relied on or examined to issue the show cause notice, they have to make over those documents. And I specifically asked them to, otherwise, my lord considers this issue. In fact, my lord, the Bombay judgment also considers that somehow banks, what they do now, if your lordship desires, I'll place that paragraph. Banks on issuance of the notice to show cause, they shift the onus or the burden. It's up to me that I have to. And that is considered here. Yes, 23, if your lordship has a look at, my lord. My junior is right. 22 also, if your lordship gives it a cursory glance. In other words, the bank, Union Bank, is firmly of the view that it is not obligated to provide any material to prove its allegations, and that the onus is on the
That is not the submission of the bank over here.
I'm sorry, Milan.
That is not the submission of the bank
No,
over
that's my
here.
challenge, that in the notice to show cause, you've not given me anything.
No, you've sought for it, but they may provide you also. You never know that they will not provide or something of that
Call
sort.
me directly. What your lordships have stayed is the hearing notice.
Yes.
They call me for a hearing before you know, the purpose is to allow me to give a meaningful reply.
Yes.
If with the show cause they don't give, I give the reply, and then they straight away call me for a hearing. There is no scope for me to give another reply. The entire purpose that your lordships have now held is for me to be given an opportunity to show that I don't actually am a willful defaulter. A defaulter doesn't become a willful defaulter, it has to be willful. So the bank, to arrive at the conclusion that I willfully defaulted, they've had to examine the evidence. If I'm not given this document, when I'm replying to the show cause, then the entire process is futile. So they had to give me, first, there is no consideration of any evidence.
Very well, I've followed.
And one more aspect, and 3B, your lordship has seen, the purpose of this is that I be given a show cause notice to which I submit my reply. And 3A precedes 3B.
Yes.
So before issuance of this show cause, the 3B contemplates where the hearing is happening. 3A satisfaction has to be arrived at. That is the Bombay High Court judgment. That when you're giving the show cause at 3A stage, if you're not giving me an opportunity to give that, then 3B becomes completely redundant.
All right. Yes, what about the documents sought for by the petitioner?
If your lordship takes a notice, what my learned friend is referring to, Lord, it is not a branch. Lord, it is a registered and head office. That is Mangaluru. So, my lord, he cannot say the branch has issued this notice. It is the head office who is issuing this notice.
No, that's my point. I have no financial aid with the head office.
Yes,
please. At page 33, my lord, his account has not yet been willfully defaulted as of now. If your lordship takes, he has that recourse. 3C. The order of the committee should be reviewed by another committee headed by the chairman. Chairman, managing director, and the managing director, chief executive officer, in addition to two independent directors, and the order shall become finally only after it is confirmed by the said review committee. However, if the identification committee does not pass an order declaring a borrower as a willful defaulter, then the review committee need not be set up. So he has another opportunity for the review committee to appear before there. It is not that today itself his account is being classified as a willful defaulter.
What about the documents that the petitioner
that argument was not made on the last occasion. I have requested my learned friends junior to supply me the documents, the orders that were being placed today, so that I can take instruction from that.
Which order?
These judgments that were
no, these are for precedents. But thing is, the
Lord, I have to take instruction. Kindly give me 1 day's time.
All right, please come. Please come.
Well, your lordship will also consider the aspect of there being no financial banking transaction with the head office, my lord.
The petitioner is aggrieved by the steps taken by Karnataka Bank Limited to classify the petitioner's account as willful defaulter. Not account, classify the petitioner as willful defaulter. Stop paragraph. The first and the foremost challenge is that the notice dated 11th October 2022, by which the bank intimated the petitioner about placing its name in the willful defaulters list of RBI, has been issued not from the bank, not from the branch of the bank from where the petitioner made its transactions. Step. The petitioner has the bank account in the Kolkata-AJC Bose Road branch of the Karnataka Bank. But the notice has been issued by the Karnataka Bank Limited, having registered an head office at Mangaluru. Step. It has been submitted that as there was no transaction with the Mangaluru branch, accordingly, no notice could have been issued by the said branch. Step. Each bank has to be taken as a separate entity, and if there is any default, the notice ought to have been issued by the branch where the transaction took place. Stop. In support of the said submission, the petitioner relies on the judgment delivered by a division bench of this court in the matter of Oriental Bank of Commerce versus Santosh Kumar Agarwal, check the spelling, reported in AIR 2008 Cal 148. Paragraph. It has further been submitted that for the purpose of providing a proper response to the show cause notice, all documents ought to have been provided to the petitioner. Stop. The petitioner in the reply to the show cause has clearly mentioned regarding the documents required for providing a meaningful response to the show cause. Stop. The said documents have not been provided despite request made. In support of the same, the petitioner relies on the judgment delivered by the Honorable Division Bench of the Bombay High Court in the matter of Milind Patel versus Union Bank of India and others, reported in AIR Bombay. Next. The next argument of the petitioner is that the notice of hearing, now that personal hearing has been fixed at Mangaluru. Stop. As the entire cause of action arose within the jurisdiction of this state, the petitioner ought not to have been summoned to Bangalore, to Karnataka, for the purpose of the hearing. Next. Yes, please. Any further?
3A point also, the identification committee.
Achha.
And their satisfaction.
It has also been submitted that clause 3A of the
Page 24.
Master Circular on Willful Defaulters dated 1st July 2025, published by the Reserve Bank of India, has not been followed. Step. There is no evidence of willful default that has been brought on record. Stop. Prior to all papers being examined by the committee constituted in terms of the said circular, the bank ought not to have declared the petitioner as willful defaulter. Step. The committee of executives for identification of willful defaulters, which issued the notice, impugn notice, dated 11th October 2022, is not in terms of clause 3 within brackets small a of the master circular. Anything else?
No.
Next. Learned advocate representing the the definition of lender as appearing in clause 2.1.1 in the master circular has been referred to. Stuff. It has been pointed out that the definition lender mentions about transaction, about banking transaction in a bank. Stuff. In the instant case, the banking transaction took place in Kolkata, but the notice impugn notice has been issued from the bank at Karnataka. Stuff. Next. Learned advocate representing the bank submits that the committee has been constituted in terms of the master circular published by the Reserve Bank of India. Stuff. The notice by which the petitioner has been asked to appear for personal hearing was merely issued by the convener of the committee. Stuff. The committee itself was constituted strictly in accordance with the master circular. Stuff. It has been admitted that the transaction took place within this state, and the bank is agreeable to provide hearing to the petitioner here in Kolkata. Stuff. Next. It has further been submitted that the bank is yet to classify the petitioner as willful defaulter, and there is provision in section in clause 3 within brackets small b for placing the matter before the review committee for a final decision to be taken. Stuff. It has been contended that the notice has been issued from the registered and the head office of the bank at Mangaluru and not from any other branch office of the bank. Stuff. Next. Prayer has been made to direct the petitioner to participate in the process for identification of the willful defaulter. Stuff. Paragraph. I have heard the submissions made on behalf of both the parties and have perused the materials placed before the court. Stuff. Admittedly, it appears that the petitioner has a bank account in Kolkata and the transactions took place in Kolkata. Stuff. The notice of the Committee of Executives for Identification of Willful Defaulters appears to have been issued from the registered and the head office of the bank at Mangaluru. Stop. The same has not been issued by any other branch office of the bank. Stop. The bank has agreed to provide an opportunity of hearing to the petitioner at Kolkata. Stop. The records of the petitioner are available at Kolkata. Stop. The petitioner has already replied to the show cause notice and has sought for certain documents. Stop. The petitioner has approached the court at the stage where the show cause, where hearing has been provided after a response was given to the show cause notice. Stop. As on date, no order, far less any punitive measure has been taken against the petitioner. Stop. At the show cause stage, the committee is yet to formulate a decision as to whether, not formulate, but come to a decision as to whether the petitioner has actually defaulted in, has willfully defaulted in making payment or not. Stop. No decision has been taken by the committee, identification committee, till date. Stop. The it will be open for the petitioner to participate in the hearing and seek for any further document if required for the purpose of defending its stand as regards the allegation of willful default. Paragraph. The bank has already agreed to provide hearing to the petitioner at Kolkata. Stop. The bank shall provide the facility to the petitioner at Kolkata if prayed for. Stop. As per the master circular, the decision of the committee of by the identification committee is subject to final approval by the review committee. Stop. The bank will be obliged to take steps strictly in terms of the master circular of the Reserve Bank of India. Stop. The writ petition stands disposed of.
Very grateful, Mother. Except one thing, Your Lordship will direct the bank
Just 1 minute.
to make over the documents if we ask for it. That much Your Lordship will just direct.
As regards the decision in the matter of Santosh Kumar Agarwal, within brackets Supra, the court was considering the issue with regard to the jurisdiction of the bank. Now, the jurisdiction for the purpose of filing a suit. Stop. Paragraph 25 of the said judgment has been relied upon, wherein the court took note of the decision passed in the matter of Delhi Cloth and General Mills Company Limited. এর রেফারেন্সটা কিন্তু লিখবেন, ঠিক আছে? Wherein the court took note of the fact that the branches of the bank operates through its branches, and the branches are regarded for many purposes as separate and distinct entities from the head office and from each other. Stop. Paragraph. In the instant case, the head and the registered office of the bank has taken steps in the matter. Stop. The same is not violative of any of the provision of the master circular. Next, in the matter of Milind Patel, within brackets Supra, the paragraphs 23, 25, 26 has been relied upon, which speaks about complying the principles of natural justice. Stop. The bank has issued a show cause notice and afforded opportunity of hearing to the petitioner, which the petitioner did not avail of and instead rushed to the writ court for relief. Stop. It does not appear that there has been any violation of the principle of natural justice at this stage. Stop. এটা উপর দিকে যাবে তারপর এটা আসবে।
Only
Yes,
request
please.
these documents that we ask for, the bank will provide it. The
If
lordship
it
has
is
held.
there in-
Please check up.
If it is there in the master circular,
No, no.
What?
that if the
Document.
document, yes, document.
No, the bank, the petitioner has sought for certain
Lordship has
documents.
directed, if it is required at the time of hearing, prior to hearing, we shall supply. Your lordship has directed.
No, no, my lord, that they'll make it over to me. My lord, kindly record the submission of the bank.
No,
Otherwise,
there
they'll
is-
pass the order. And
No,
then
not
I'll, my
necessary.
lord, once the order is passed, because of the review committee, I'll get stuck.
Yes.
The entire aspect was that they're not providing us the
All right,
document.
I'll take care of it. Next, please.
Right.
26.
26 and 27, same.
Same.
And the dates of the orders? Told you the dates of the orders?
That will give to your lordship's office, sir. That I'll ensure that we give it.
Please check.
So called notice dates and these dates.
I think, Lord, all are similar.
Oh,
All
are
same.
same.
Because, Lord, they are the one
All
of the
same, sir.
directors and the partners.
All are same.
Please check up and let the court know. Yes, 28.
11th October. I'm good.
Item number 28. I am for the respondent number 2, Lordship.
Yes.
In a retender process, after successful, I became the successful bidder, the retender has been cancelled after everything, every process has been completed. And now I'm handing over my supplementary affidavit, which shows that a person,
No
a
copy.
particular, I've been serving, I'm giving it. Particular persons was the blue-white person of that authority. They have given the work without any tender, without doing anything. My lord, kindly see the supplementary affidavit where it shows that the annexure A, it shows that the up to the 10 crores, no permission is required up to the 10 crores of the tender up to the floating tender up to the 10 crores, no permission is required from the competent authority. That, and even then they have rejected rejected the tender on the ground that they have to take the permission from the authority concerned. This is the memorandum I have given. My lord, kindly see the annexure.
So from the writ petition, what is impugned?
The impugned tender cancellation notice.
Please show.
And this is the last annexure P11, last page.
After this cancellation, what has happened?
After nothing, and they are giving the blue-white person. Kindly see that the annexure B of my supplementary affidavit.
Listen, page 84 of the writ petition, 27th of March 2023, the decision to cancel.
Cancelled.
Then fresh tender was floated or not?
No.
From the same tender, somebody has been given after cancellation?
Yes, somebody has been given, day-to-day work has been given, my lord, see.
No, not day-to-day work. What was this work for? This was for a particular purpose, for repairing steel and wooden furniture.
Yes, it is going on the regular basis because I was doing this job since long, and now without any tender that has been in a small scale, the work has been given to their blue-white person. This is annexure B of my supplementary affidavit.
What is your submission?
The bills. From this, it cannot reflect the tender number and whatever.
No, there is not the tender number, not by way of tender.
Should be the purpose of that wood and should be related to the same tender.
What is page 8 notification dated 24th April 2014 you are relying upon?
My lord, I am relying upon the notification of 19th November 2018, annexure A of the
24th November, it's page 8.
Page.
24th of April 2014.
Yes. No, I'm not relying. I am relying upon the notification of the
19th
memorandum.
November. 19th November
19th November 2018.
Yes. What does it say?
What does it say, my lord? The para 2B.
Yes.
My lord, see that the for the taking the up to the 10 lakhs, 10 crores, crores, the HOD will be able to accept the tender.
Where the delegated power of the additional such and such for according administrative is 10 crore, the HOD will be able to accept the tenders.
Yes.
With what? Yes.
Well, HOD will accept the tender because that HOD has medical superintendent has said that the tender is cancelled due to the approval of the purchase tender and purchase committee to hospital memorandum.
What is your submission?
Milord, I have received some informations, but these are all PDFs. Milord, I want to come with the concrete report.
Listen, PDF, you've gone through it.
Yes, I've gone through it.
What
but
does
it
it
is not
say?
clear, Milord.
What do you say it's not
Yes,
clear?
Milord, I have to understand from them.
If you cannot understand, please take help of somebody who can make you understand.
Milord, I have. Milord, there's
What is this? The matter is pending from 2023.
Yes, Milord, I have tried to communicate. I have received the information, but concrete document I will, and this affidavit has been filed today. I will also come back with this also.
Page 84, there is a tender cancellation notice. Has any fresh tender been issued? First. Secondly, how is the work being done by the authority?
Yes, Milord.
Because his submission is that you are taking
someone else.
Help of somebody to get the work done without floating a proper tender. From 23 till 25, what steps have you taken?
I'll come back.
Please come. The matter relates to an e-tender floated by the MSVP, Medical College and Hospital, Kolkata, for repairing steel and wooden furniture. Stop. It appears that the said tender stood cancelled due to non-approval of the competent authority in the department and as per the decision of the tender and purchase committee of the hospital. Stop. The tender cancellation notice is annexed at page 84 of the writ petition. Stop. Paragraph. The petitioner has filed a supplementary affidavit annexing documents to show that the hospital is engaging their favorite persons for getting the work done on short-term basis without calling for a regular tender. Stop paragraph. The writ petition is pending since 2023. The hospital, now the MSVP of the hospital is directed to revert with written instruction as to whether fresh tender process has been initiated after cancellation of the one in the year 2023. Stop. In the event it has not been in the event fresh tender has not been called for, then the steps taken to get the work of repairing steel and wooden furniture of the hospital done. In the event
In the event this tender has not been called for, then the steps taken to get the work of repairing and civilian feature of hospital done.
Done. Stop. The whether the authority is contemplating floating fresh tender shall also be disclosed. Released 19th of September.
I'm good.
29, my lord, I beg to appear for the private respondent.
Yes.
Lordship, in item number 29, we appear for the petitioners. My lord, the matter is that this writ petition was filed challenging the order of the maintenance tribunal, where the maintenance tribunal was pleased to cancel the deed of gift validly executed by a mother in favor of a daughter. My lord, the dispute is on the last occasion, on 1st of September, when the matter was heard by your lordships, on that day there was an allegation that the petitioner did not provide the amount of maintenance. My lord, I have certain evidences to submit before your lordships, which substantiate that the amount was duly paid, but it was refused by the petitioner. My lord, the postal department evidence I'm having.
All right. Have you credited
And
to the
yes, my
bank
lord.
account?
Yes, my lord. This is the evidence in support of my
How
contention.
much have you paid?
My lord, the entire amount.
How much? Give me
It
the
is 10,000.
figure.
It is 18,000.
80.
18,000.
Lord, the
18,000.
entire amount
My
is
lord,
40,000 rupees. My lord, kindly seize your lordship's order. Your lordship will be clear. All the arrears were told to be paid, and it
my lord, from
tantamount
April,
to 40,000. They have only made part compliances of the arrears. They have not allowed me to enter the residence. I have lodged 2 GDs, despite there being a verbal direction of your lordship.
August 2024 order was passed
yes, my
for
lord.
paying. Did you pay?
Entire amount is paid. My lord, the entire amount is paid. The pending amount, which initially they were refusing.
How can you say pending if you say that the entire is paid?
No, because my lord, till the month of April, they were not receiving the amount. But after that, we have regularly made the payment. My lord, actually, we have been appointed in this matter yesterday, and yesterday you have submitted the Vakalatnama itself. My lord, I pray, my lord, your lordships kindly grant us to submit a supplementary affidavit to bring on record all these evidences in support of my contentions.
Which contention? That
my lord, I have made the entire payment.
From August 24?
From August 24 till that.
September 2025.
My lord, the entire payment is made. My lord, kindly gives us 1 week time. My lord, we will submit the supplementary affidavit to bring all these matters on record.
All right. Now you tell me why you are refusing the private respondent to enter into your premises.
My lord, just yesterday, my lord, we have got the brief. We have not got the opportunity to study the entire brief. My lord, I am praying for 1 week accommodation. My lord, I will be able to submit all. I will be able to meet you all the queries of the lordships.
Firstly, my lord, if your lordship kindly comes to page 55, 16th of January 2024 was the order of tribunal.
January
2024, your lordship specifically stated, it's written in the order, lordship, that 2,000 rupees from that day has to be paid. They have only paid 2,000. They have only paid 18,000 rupees, my lords. Secondly, my lords, there was a verbal direction of your lordship that pending this application, I will be allowed to enter. My lord, on the date of the order, I went there, I lodged a GD. They did not allow me to enter. On the second day, on the 2nd of September, I went on a different time. They still did not allow me to enter. And I have lodged the GD just to document the process. Now, if they come up and say that we have got
my lord, there is also.
This is misleading the process.
You are the mother.
I am the mother.
My lord, there is. My lord.
And the property belongs to?
The property belongs to me. I have gifted. Once I have gifted, after the gift was made, I challenged the deed of gift before the appropriate tribunal. There is a specific, if your lordship sees the deed of gift, there is a specific wording that Ami Tomader Shohid Thakibo. That is there in the deed of gift. There is a specific pleading in the petition before the tribunal. Considering both of these, the tribunal rightly passed the order, subject to correction by your lordship, and then
Please come.
Then we have been ousted. My lord, we are seeking.
And my lord,
you received at least 18,000 you have received?
At least 18,000 only. When 40,000 was due, my lord.
You received some? Yes, my lord. You didn't have anything?
My lord, we are seeking.
You received 18,000 you have received? 18,000 you have received? 40,000 was due, my lord. You received some? Yes, my lord. You received some?
I didn't have anything.
So you have at
My-
least 18.
My lord,
But
my lord, in
the
this matter,
residence,
there is a
residence
civil,
can-
civil suit is pending.
I have
And there is also an
Suit regarding what?
regarding this matter,
Which
because when the writ application was filed on the first date, my lord, the matter was heard by Justice Shompa Sarkar, and my lord was pleased to find that the matter should be decided by a civil court. Accordingly, my lord, the petitioner has filed a civil suit, and there is an order of status quo injunction. So far as I have been informed in this matter, my lord, kindly allow us to submit the supplementary affidavit so that all these documents could be placed before your lordships on the next day.
I also seek liberty to file
And
an
my lord, this
opposition.
is the information slip. It has been obtained on 3rd of September 2025.
What is
There is a status
what
quo
is the
injunction.
dispute? What is the dispute in the civil suit?
My lord, actually they have challenged the legality of the gift deed executed. My lord, against this cancellation of gift deed, my lord, the civil suit was referred. So far
The
as I have been
property-
informed in this matter.
The property belonged to the mother.
My lord, the land was belonging to the mother, and on that, after I inherited I got the property by way of execution of gift deed. I have
Right.
made the construction. I have made this.
Exactly.
Yes, my
After
lord.
Then
taking
you
the land
ousted
from
the
the
mother.
mother, you throw
After
her out.
no, my lord.
Absolutely.
After getting the gift from the mother, there was certain.
Then you throw her
No, no,
out.
my lord, I have not thrown her.
Absolutely.
My lord, there are
Why
certain
don't you permit
difficulties.
her to stay with
Absolutely.
My
you?
lord, because I will also present few other documents what relates to the other cases pending before the criminal courts also.
Sir, she is your mother.
No,
Why
my lord.
are you
My lord, first of all, my mother has lost a false complaint being influenced by other persons. My lord, she has alleged that an incident has occurred in the month of March of 2024.
Forget everything.
My lord, kindly, my
I'm
lord.
not going to hear to you. She is your mother and she's going to
My
reside
lord,
over
I
there
know,
because
my
the
lord,
land
she is the
belongs to
mother,
her.
and it will approach the judicial conscience of your lordship, but certain difficulties are there, my lord.
There is no
Not
difficulty.
letting me
Permit
enter, my
her.
lord, despite the directive
Permit
of the
her
Because of the
to
status quo
stay.
injunction, my lord. Because
Nothing is
not
going
let
to
me
happen. The
enter.
High Court will take care of it. She's an aged lady. You permit her to stay over there.
my lord, kindly allow us my lord, kindly accommodate us for 1 week, my lord. I will provide all the documents and I will try to satisfy your lordships.
Not going to hear to anything prior to you permitting your mother to stay with you.
And my lord, on last occasion, it was submitted that if
My lord,
if
kindly allow us one
if
day
the
one
respondent goes today, they will
accommodation,
will
my
have
lord.
no problem,
My lord,
Can
kindly
you
let us
please-
come back with the instruction from the client, my lord. 1 week accommodation, my lord. Just
How many rooms are there?
my lord, only 2 rooms are there.
2 rooms are there.
2 rooms are there.
And
Actually, one
and
bedroom
we-
is there and one veranda was there. What was converted later on into a room. My lord, considering this, my lord, I pray just yesterday we have been appointed in this matter. We have not studied the brief properly. My lord, just provide us 1 week
For
accommodation, my
you-
lord. We'll answer all
for
the
you,
queries of your
it may be
lordship.
the first day.
Yes,
For
yes,
you,
your
it
lordship.
may be the first day.
understand.
For this court, it is not the first day.
I understand.
The petition
I appreciate your lordship.
submitted that the private respondent will be permitted to stay over there.
Much
This was the specific submission. With the
Grateful.
change of counsel, the submissions cannot
No, my lord.
change.
No, my lord,
Absolute
we are
change
not
of
we are not
submission.
changing the submission, my lord. I'm just
Do
saying,
you know what was the
Absolute
submission
change of
earlier?
submission. Kindly cease.
my lord,
do not-
just my lord, kindly accommodate us for 1 week, my lord. I will come back with all the answers of your lordships. My lord, kindly 1 week accommodation be provided, my lord. Please, your lordships.
Pay further sum to your mother because she
And
has to
let
rent
me
the
enter
My lord,
my
place.
if there is,
kindly
my lord, if
appreciates.
there is any outstanding amount, my lord, the client has already informed me that she has already cleared all her dues.
Very well. If she has cleared, that is very good. You pay more. Where will she stay?
My lord,
2,000 rupees a
my
month.
lord, just
and I
1
have
week
to reside
accommodation,
at
my lord,
the-
you provide. Kindly, my lord, grants us 1 week accommodation. I will answer your
1 week accommodation. Can you stay outside for one night?
No, my lord, certainly not.
Not. Why
Certainly
is your mother be permitted to stay out?
not.
How do you make this submission in court?
My lord, the difficulty is,
My lord, we have
my lord, there are
lodged two
certain.
GDs, my lord.
My lord, then
They have a separate residence. She is a married lady.
no, my
Her
lord,
husband
there is no.
a
My lord,
businessman, she is a teacher.
my lord, the husband is not a businessman, and the wife is a para teacher.
I will give
She
the
earns
affidavit.
around
I will
10,000 something
sign it
per
on
month.
record.
My lord, the difficulty is that there practically there are some difficulties, and my lord, I also like to praise certain evidences regarding the activities of the mother. My lord, it is fact that the mother is staying out, but there are certain faults
Where
on the
is
part of
your
the mother.
mother staying? Where is your mother staying?
In maternal aunt's house, so far as I know.
How? Why will she stay in her maternal family if she has her in-laws' house.
My lord, I understand, but my lord, there are some practical, some
There
difficult.
is no stay. My
Practically,
client is
there are some
cancelled
difficulties
without
as it
moving
is
out.
conveyed by the client to me. My lord, kindly
Try to convince your client.
I will try to
And
convince her.
possibly
If there is any
because
fault,
the
if there is any
orders
fault on the
of
part of the
counsel-
petitioner, my lord, I will certainly try to convince her. But my lord, 1 week time can be granted.
It was only because the other set of counsel was not able to convince the client. That is the reason there has been a change, and you have stepped in. Right? The court can understand.
I understand your lordship.
Yes.
But kindly, my lord, I will try to make her understand if there is some, if there is this is really the phenomenon, my lord. Kindly provide us 1 week accommodation, my lord. I will try to convince her, and if it is, if she is having certain other
There will be a change of counsel.
Definitely.
I believe, my lord, that I cannot say.
You cannot say, obviously, you cannot say, because that will be your client's wish. Now the court will direct your
my lord,
client
this is for the last
to
occasion,
be
my lord.
ousted
But this is
and
for the
be
last.
ready to be
My lord,
put
this
in.
is for the last occasion, my
And
lord.
keep
Kindly
the
grant us
only
1 week
child,
accommodation. I will try to accommodate her, or I will try to make her understand whatever it may be the
He's the
scenario.
only child, my lord.
Make her understand that the mother is going to stay over here,
And my
come
lord,
what may.
one additional prayer is there, my lord.
No additional prayer.
My lord, my lord, my lord, this is a purely a family. My lord, this is my lord. Right now, this
It's
is
a
not.
family dispute and the writ petition should go.
No, my lord, I'm not saying that.
No.
I'm just praying if your lordships kindly allow this matter to be go for mediation, so that the
No,
matter.
my lord, we are not ready for
If it is not ready, my lord, just provide us 1 week accommodation, my lord. I will try to convince her. If it is not, if she is not convinced, I will come back with the appropriate.
Learned advocate appearing for the petitioner submits that he has been engaged in the brief only yesterday and he seeks time to take instruction. Stop. It has been submitted that a sum of rupees 18,000. Now, it has been submitted that the entire dues of the private respondent has been paid. Stop. Learned advocate representing the private respondent denies the submission regarding payment of entire dues. Stop. It has been submitted that only rupees 18,000 have been paid. Stop. The private respondent prays for permitting her to stay at the place where the petitioner is currently residing. Stop. The said place. Now, the said plot of land was gifted by the private respondent to the petitioner. And only after execution of the deed of gift, the petitioner has thrown away the private respondent from the said place.
My lord, after construction, the petitioner has stayed with the mother has stayed with the daughter for around 3 years.
Right.
After that, there was a dispute regarding some promoting. While the daughter tried to influence it,
Try to influence.
no, not influence. Influence means she was not permitting because she has spent all this money for making the construction. And then the mother lodged a fake police complaint alleging an incident occurred 9 months back. Now, this is the dispute.
On the prayer of the petitioner for coming ready with proper instruction, released the same on 16th June. September.
But kindly, if I am granted some police assistance to go and reside over there, this has to be recorded because they did not abide by the verbal direction. They misled the court. They came out with different set of counsels. Kindly, my lord, records it.
My lord,
You are an aged lady.
there are multiple litigations pending on
there
this
and
issue.
fight.
No, I will not, my lord. I have nowhere to stay.
You take instruction with regard to how many rooms are there. You must be knowing because you stayed over there, whether separate accommodation can be made and whether you all can live separately or not.
Kindly records, my lord. I will go
My lord,
there.
not
They are
today, my
not
lord.
letting me enter. I have
Right,
not today, my lord. My lord,
they
there are
say-
certain difficulties, my lord.
Next day, let us come and see what happens. Record your appearance. Next.
My lord, liberty may be granted to file the supplementary affidavit.
No.
My lord, just to bring on record that the payment receipts, what you
Payment receipt you show, I'll take it on record. No supplementary.
My lord, I am for the petitioner, my lord.
Yes, please. And make sure that you are there and know there is no change in the counsel. Yes, please. What is the matter?
My lord, here the matter, my lord, the petitioner's account was not hacked, I would say. Rather, petitioners shared his OTP, my lord. And then 33 lakhs odd was transferred to a wrong account, my lord.
Right.
The fraudulent, they created some scenes, my lord.
What is the prayer that you are
My
making
lord,
over
here
here?
I'll show from the document, my lord. I had written to the bank, my lord, to reverse that amount, my lord. There was a provision for reversal of wrong transfer, my lord. The bank wrote to the transferee bank also. Bank has later on annexed in supplementary affidavit that it has wrote to the transferee bank, my lord, to reverse the account, my lord. The transferee bank has asked my bank, my lord, to give indemnity. What is indemnity, my lord? I'll share one form also, my lord. I've collected from other bank. But there is no such indemnity being submitted to the transferee bank, my lord, by my bank. So that amount was supposed to be freezed, my lord. First, it was to be freezed. It was freezed, and thereafter it was to be reversed. But it was not reversed because they did not hand over the indemnity, my lord, and the FIR copy. I'll show from the documents. I'll satisfy your lordship, my lord.
Lord, may I just tell your lordship?
Cut short. Can you cut short it?
Yes.
Yes, please.
He has, my lord, on his app, obtained a loan after giving OTP which comes on his phone, registered somebody's bank account.
Somebody is not his.
No, somebody. Then, my lord, after he's got the loan, he's registered as a payee somebody's bank account with beneficiary. Then with OTP transferred funds to that bank account. And now he says the bank is, my lord, responsible for all of this. Not right. Please see the complaint once.
My lord, may I?
It's absolutely absurd,
my lord, may
cause of action.
My lord, may I put my case first, my lord? Then my learned friend will answer, my lord.
No, but then from the tenor of the argument, it appears that there are factual disputes which cannot be resolved in the writ petition. What can be done?
No, my lord, I'll satisfy
What?
your
No.
lordship. My lord, kindly come to the supplementary affidavit they have filed, my lord.
You have been to the ombudsman.
My lord, I had complained to the bank, my lord. There are two cases made here, my lord. One is, I'll show from the records, my lord. On the date when this incident happened, I had transferred 8 lakhs odd from my bank account, my lord, at 10:35.
You have transferred.
I have transferred.
Sharing of password.
My lord, thereafter there is a provision. I'll satisfy your lordship.
No, you do something voluntarily and then you say
my lord,
my
lord, there is RBI's provision, my lord.
Yes, you take advantage of this.
No, my lord, I'm sharing.
The RBI provision is there for the fraudulent transfers. You do it deliberately.
No, my lord, wrong transfer also. If I wrongly transfer from my account to your lordship's account also,
yes,
and if I report to my bank that this amount has been wrongly transferred to the transferee bank, my lord,
I have to go and get it back.
My lord,
what are you saying?
My lord, what I am saying, my lord, it is the RBI's provision. How can I say, my lord?
Then it goes. Did you approach the ombudsman with the
my lord? I am to approach my bank. My lord, kindly come to supplementary. What my learned friend is saying and is disputing, kindly come to supplementary affidavit, my lord.
Yes.
Filed by my learned friend, client, my lord.
Yes. Which page?
My lord, kindly come to page 2.
Yes.
Paragraph 4.
Yes.
If there is no provision, why these steps are being taken, my lord? The respondent number 1, after being intimated by the petitioner regarding the alleged unauthorized and or fraudulent transaction being carried out from his account immediately on November 9, 2023, itself requested the Punjab National Bank, being the recipient bank, to hold/cancel any payment and return the funds of the concerned transaction as the same have been disputed by the petitioner. Copy of the email communication dated November 9, 2023 is annexed here to and marked as annexure so-and-so. Next paragraph, my lord. The respondent number 1 on November 10, 2023 further informed Punjab National Bank by email dated so-and-so that the concerned RTGS transaction made to the account number so-and-so were suspected to be fraudulent and requested the Punjab National Bank to reverse the transaction intimated from the petitioner.
Initiated from the petitioner's bank account,
maintained with the respondent number 1. Copy of the communication between respondent number 1 so-and-so. Now, my lord, kindly come to page number 7 of this supplementary affidavit, my lord.
Yes.
Dear sir, madam, RTGS transaction to your bank account was initiated with fraudulent. We request you to kindly return the funds to originator account by mentioning ICICI bank reference number. Inconvenience caused is highly regretted. This is my bank writes to the transferee bank, my lord. Now, my lord will kindly come to page 6, my lord.
Yes.
Dear sir, madam, kindly go through the trailing mail. We have informed that the below transaction is unauthorized, fraudulently. Kindly mark lien in the beneficiary of the account. Now, my lord, the bank, transferee bank, what transferee bank writes, my lord? Dear sender bank, at the bottom, if your lordship sees, my lord. Please share indemnity letter and FIR copy with court order. Thereafter, what my bank has done, I don't know, my lord. Now I'll show your lordship. Now, my lord, if your lordship, this is a provision, my lord. On the provision, my bank has acted, my lord. If your lordship wants, I can show the provisions also, my lord. My bank cannot write it to the other bank, my lord, if there is no provision. My lord, this is a sample copy of the indemnity, my lord. I'm handing one of the samples copy of the indemnity, my lord. Because my bank has to take the responsibility of the reversal of the amount, my lord. This is my first case, my lord, and there is a second case in this, my lord. I'll show that also, my lord, with regard to the loan amount.
Yours is ICICI
My
Bank.
lord, mine is an ICICI bank, my lord.
Who is for PNB?
My lord, PNB has not been
PNB
made
is
party
here.
because till date, my lord, I did not knew which account number my amount was transferred. It is in this affidavit they are disclosing to me, my lord. Now I'll show to your lordship, my lord, that I have written letters to them to tell me which account number my amount has been transferred, but they did not let me know that also.
It is you who transferred
Yes,
the
My lord,
from his mobile.
to which account you
my
transferred?
lord, it is my lord, it is a code, my lord. I've stated in my writ petition, it was a code MUM Mumbai for Mumbai MUM and PNB, my lord.
PNB means Punjab National Bank.
My lord, but at that time I did not know the account number, my lord. It was a code.
No, but then at least PNB main branch or something could have been.
My lord, then kindly grant me liberty, my lord. I'll incorporate
No,
my lord.
liberty. What he's trying to do, my lord, I'll show your lordship.
The scope of the writ petition.
My lord, kindly seize these samples of indemnity letter, my lord.
Now the amount is frozen.
No, my lord.
What no?
They have not frozen the amount. This is the problem, my lord. On 9th November, my lord, at 10:35, this transaction has been done of 8 lakh rupees, my lord.
And this is
And
everything
10:50,
is happening.
My lord, 10:50, they allegedly, my lord, transferred 25 lakhs on the ground that I have asked for loan, my lord. 10:50. I informed them that this amount has been wrongly transferred. After 2 days, they tell me that don't use that amount when I've already, I'll show your lordship that I informed them that this amount has been wrongly transferred.
Listen, the writ court cannot enter into all these
Please
things.
give me just 2
I am
minutes.
sorry.
Just 2 minutes. Tell your lordship what mischief is happening. He comes to your lordship, my lord, with a case that he received, my lord, information that one of his, my lord, packages is with Mumbai police. And apparently, my lord, there was a phone conversation. So, my lord, for the purpose of bribing Mumbai police or paying Mumbai police, he, my lord, withdrew money and transfers it. He transfers his own money with OTP on his mobile app. He gets a loan from me because on his app he can get a loan. On his app he gets a loan and he transfers that money also to this Mumbai crime branch person allegedly. This is his story that he's given it to an unknown Mumbai crime branch person. And he's so much under the influence of Mumbai crime branch person that he didn't know and he transferred all this with OTP. Now 48 hours later, he suddenly becomes fine again. He wakes up and he says now that you, my bank, doesn't matter if I fed in OTP and transferred the money, you now recover the money from me. How am I supposed to? Banking norms is if you send me such a email, I'll inform the payee bank immediately, which I have done. Now, why is he continuing this witch hunt before your lordship? Because till the time he continues this loan which is obtained on my app, I can't recover from him. I won't. Naturally, out of respect to court, I can't today go after him and ask him to give the loan. So he'll continue that you, my bank, should have gone and got this money back. In any which ways, I'm not going to pay you. This is the whole objective of this writ petition. First creation of some story with Mumbai Police Crime Branch, then obtaining a loan, transferring money to them. And when you obtain a loan on the app, you receive OTP. When you transfer, you register that person with OTP. And then when you actually transfer, you again transferred with OTP.
Transfer was only, the loan was obtained only for transferring the money?
Yes, my lord, please just have a look at
No, my lord. These
No,
are
no,
all
1
made up
minute.
stories from my learned senior friend, my
No,
lord.
all make up
My lord, I'll give a
report is
notification
there.
of the bank, my lord.
Please come.
Just see my report, my lord. It's a
My lord,
two-page report.
kindly appreciate that indemnity letter was to be sent from my bank.
Let's just see my report for 1
Yes.
minute, my lord.
Mm.
My lord, paragraph 3, that he
Yes.
has a savings bank, and my lord, 8,20,000 he transferred, my lord, to IDFC. Then, my lord, please come to paragraph 4. At 10:33 a.m., he registered a payee and he transferred further funds. And
And
my lord, this is the way, my lord, he
petitioner
does all
prays for a
OTPs.
direction upon the ICICI Bank
Hmm.
to recover the money which was fraudulently transferred from the bank account of the petitioner. Stop. Paragraph D. In the course of hearing, it has been brought to the notice of the court that the amount was transferred by the petitioner himself upon sharing the one-time password. Stop. After 48 hours of the transfer of the money, the petitioner seeks for refund of the same, not refund, recovery of the same by the petitioner's banker. Stop. The petitioner refers to the RBI guidelines in this regard. Stop. Paragraph. Learned advocate representing ICICI Bank denies the contention of the petitioner. Stop. It has been submitted that the petitioner has obtained loan from the bank. Obtained loan from the bank online by sharing his one-time password. Stop. The petitioner, for the purpose of non-repaying the dues of the loan, has cooked up this story of fraudulent transfer of money from his account. Of fraudulent transfer of money from his account. Stop. The according to the bank, the petitioner himself voluntarily transferred the said amount. Stop. The bank is not obliged to take any steps for recovery of the money which the petitioner voluntarily transferred to some other account. Next, upon hearing the submission made on behalf of the parties and on perusal of the documents, it appears that there are several disputed questions of facts involved in the writ petition. Stop. The very factum of fraudulent transfer of funds is denied by the bank. Stop. The recipient bank is not impleaded as party in the instant writ petition. Stop. The court is of the opinion that it will not be proper for the writ court to enter into such disputed questions of facts. Stop. The petitioner appears to have lodged police complaint. Stop. It will be open for the petitioner to pursue the same with the police. Stop. If the petitioner alleges deficiency in service on the part of the bank, then there is a specific provision to deal with the same. Stop. The writ court will not be the appropriate forum to adjudicate the dispute in question. The writ petition accordingly fails and is hereby dismissed.
My lord, only one indulgence. My lord, I have not received the loan and OTP. My lord, this submission may be.
আচ্ছা যেখানে
Loan has not been received.
petitioner
You have used
Thank
the
you.
recreation card.
My
তারপরে
submission,
the petitioner
what my
denies
friend has
the
submitted, I deny to it, my lord.
the petitioner denies to the fact of obtaining loan from the bank
Through a OTP, my lord. Through
Through-
OTP.
not through by sharing
By sharing OTP.
one-time password.
Grateful, my lord.
Don't admit password.
Great.
Dismiss for default.
No, I am appearing for the Union of India.
Item 31. 31.
No,
31 dismissed.
I am appearing on behalf of the ED.
ED. Where is the petitioner?
Your Ladyship, I'm praying for a not this week, Your Ladyship. It's a new brief, Your Ladyship.
New brief?
It's a new
Lady?
brief, Your Ladyship. I'm representing the petitioner in this matter.
Yes, let me see the file once. Accommodation was sought for on the last occasion. How can it be a new brief?
Ladyship, for me, it's a new brief.
So if there is a change of counsel, then will the matter be adjourned?
Ladyship, I
In 2024, the matter was taken up. It was not served. Now service has been made. The counsel has been changed. How will the matter proceed? The petitioner is not inclined. In that case, I'll dismiss it.
Ladyship, just for this week, only for this week, Your Ladyship. I'm being.
What are you taking any steps in the matter?
My lord, in this matter, I am led by Mr. Odijit Chakraborty. Mr. Chakraborty on his legs.
Yes. So you also don't know what the matter is.
no,
Yes.
He is the main respondent, but
Right.
in this matter, show cause notices have been issued
By?
by the Enforcement Directorate under
Yes.
PMLA,
Right.
and the adjudication has also under FEMA.
All right.
Adjudication has also taken place, and thereafter probably they have entered appearance in these proceedings also.
So what is the purpose of the writ petition?
Ladyship, I don't have instructions on this as of now.
As I feel it is a spent force.
Acha, accommodation has been sought for by the learned advocate representing the petitioner. Stop. It appears that the writ petition is pending for quite some time. Stop. The petitioner does not appear to be seriously interested to proceed with the writ petition. Stop. Accordingly, release the matter on 3rd November 2025. Stop. Pendency of the writ petition will not stand in the way of the respondents from taking steps in the matter in accordance with law.
Much obliged.
Next. Appearance of any counsel not present will not be recorded. Next. Yes.
My lord, I am for the petition. My lord, exception was taken. 2 reports filed by the authorities, my lord, and this is my exception already served upon the authorities, my lord.
What is the matter?
But this matter, my lord, will remember the OMR sheet was initially not supplied during this writ proceedings, my lord. OMR sheet was supplied, and my lord, excess appointment is there, my lord. I will place, my lord, one after another, my lord, report.
Yes.
I first, my lord, take both the reports filed by the authorities, my lord. One is filed on 9th July 2025. Another one is 30 July 2025. First one on 9th July.
Yes.
But kindly take, although it is non-paginated, but page number 7. Ninth July report, my lord, got it?
Yes. First, 10th January 2018. Provisional appointment.
No, my lord, that is page number 7.
Page number 7. 11th November
11th November 2022. That is the reply.
Yes.
Kindly see the reply. Your application under RTI Act 2005 dated 7 November 2022. With reference to the subject cited above, I would like to submit the following information as per available office record. A. Approximate number of vacancies as advertised for Gram Panchayat Secretary was 76. Approximate number of vacancies as advertised for Nirman Sahayak was 7. So total 83. Now, my lord, kindly take very next page.
Yes.
Against 83, my lord, the appointment letter issued 102. Excess appointment.
Secretary.
Now, my lord, kindly take the recruitment rules. My lord, last occasion, my lord, I indicate it, and my lord says that what is about the update vacancy. Vacancy might be updated.
See, page 8, there are only 29, 30, 31, 30, 30, 35 names.
No, my lord. Total up to page 10, my lord, 102 names.
Page 9 is not here.
Yes, in my...
You have page 9?
Yes, yes.
I do not have page 9.
Well,
anyway, so you've checked up, it is 102 names.
Yes, yes.
All right.
It is their report.
All right, yes.
So, my lord, against 83 vacancy.
Not 83, it will be 76.
Yes, yes. Gram Panchayat, if we add up this two.
Don't, because the posts are different. One
Yes,
is
yes,
Gram
obviously.
Secretary and the other is Sahayak.
Yes.
And the page 8 is
Petitioner
regarding
in
a
the
secretary.
Panchayat secretary post.
Yes, so it is only 76.
76
vacancy, 102.
So excess appointment. So, my lord, it is prima facie proof that there is a corruption in this. Now, my lord came up with my OMR sheet and what they did with my OMR sheet.
Yes.
In second report, because of that, my lord, my case was that, my lord, they not supplied me my OMR sheet. This is initially in my writ petition, I also annexed it. This is untraceable.
All right.
During these proceedings, they says somehow we managed it, we traced it. Now, kindly say their second report.
Yes.
And thereafter, I came with my exception. In their second report, they annexed the OMR sheet.
Yes.
Page 5.
Yes.
Although it is non-paginated, I believe I myself page.
All right, page 5, yes.
Page 5 onward, my lord. Page 6 is that encircle portion.
Yes.
In this selection process, there was negative marking.
All right.
So I never encircle each and every question, my lord. That's my contention.
Yes.
And my lord, that's a specific environment in my exception, my lord. I not encircle every, and in this similar case, my lord, the coordinate bench pass an order. CFSL, send it to the CFSL because they says it is with them intact. So kindly send it this OMR sheet to the CFSL. Whether every encircle done by the petitioner or not, in similar type of situation, coordinate bench in one of the matter, in Madrasa matter, send it to the CFSL. From the CFSL report, it was evident that no, every encircle is not by the petitioner. And that is also annexed with my exception. That order is also annexed with my exception. Page number 33. Coordinate bench order, is annexed with my. So excess appointment, which is prima facie proof, and not only that, the advertisement is also annexed with my exception. That is page number 41st. Take the page number 41st.
In the coordinate bench's order, there is a direction for production of the ballpoint pen of the petitioner. Where from is the ballpoint pen?
That was there with that petitioner, but in this case, ballpoint pen is not with that. But it is traceable. Whether either by the same person or not, it is easily traceable because the press is there. Because somebody press heavily, somebody press lightly. So from the pressing of that.
All right, that I will see. First, you tell me.
The exception. Kindly take page number 40 first.
Page number 40 of what?
Of the exception, my lord. Advertisement is annexed.
Please give. Page number 40?
Yes, yes. Purbo Mednipure. Yes. What is the last portion, my lord? Purbo Mednipure 83 Sahayak executive. So it is
Shag.
Executive. It is evident from their RTI reply itself. The 76 is the Gram Panchayat secretary and 7 is Shayok. The excess appointment is there.
Is there any excess appointment according to your report?
There is excess appointments. Please my report number.
Yes.
Paragraph my lord.
Hmm.
In the same notification, the vacancy for the post of Gram Panchayat secretary was initially declared as 76 my lord. It was also clearly mentioned in the state notification that the number of vacancies was provisional and subject to change over time my lord. Kindly my lord sees my notification my lord. That is on third page.
Yes.
Third page of my report.
Mm-hmm.
And it sees the note, my lord. The vacancies that stated above are provisional and subject to change in course of time.
Yes.
My lord, there is some promotion and there some secretaries have been promoted to upper post. So that is why the post has been changed, my lord, from 76 to 102. That is my point.
Where have you disclosed that the final vacancy list has 102 vacancies?
That is earlier in my report. Earlier.
Show me which page.
9 July.
9 July.
9 July 2025, my lord.
Yes. Where have you disclosed?
The publication provisional appointment order, my lord, 10 January 2018, my lord.
Yes.
Page number 10.
Page number 10 is 10 January 2018.
Yes, my lord. The total appointment was 102, my lord.
Where from did you declare 102 vacancies? The main allegation is that 76 was declared and you have appointed 102. Where from did these people come in?
Some secretaries have been already retired, and all
Retired means the vacancy.
Post, my lord. Kindly seize my notification report, my lord. First page. Promotion of eligible Gram Panchayat secretaries to the post of executive assistant and superannuation of existing Gram
This is
Panchayat
not executive assistant post. This is the Panchayat secretary post. The post is Panchayat secretary.
My lord.
An initial appointment. It is not promotional.
Can you take the recruitment rules?
This is initial appointment.
Direct recruitment.
Right. How can you engage somebody on promotion to this post?
50% post is reserved for the. Kindly take the 2007 rule. Kindly take this.
OMR sheet, and we have supplied with the OMR sheet, my lord.
At the time, at the process, you have disclosed some other facts also.
Give me liberty to file a fresh report.
Kindly give this report, my lord.
I'll keep it.
Because they have not supplied me this report.
No,
Kindly
give a
take,
copy.
the recruitment rules once. 2007 recruitment rules. I believe, I have one. Yeah,
No, I'm not going to the recruitment process now.
The recruitment rules is very specific that in case of direct recruitment, what to do, in case of promotion, what to do.
Yes, this is
very
different.
specific.
This is not the issue over here. This is not the issue also over here.
Yes.
Here the issue was RTI.
Recruitment.
This issue was RTI.
Yes.
The information has been supplied to you.
That is not my OMR sheet, my lord. They first said it is not traceable. During this process, my lord, they says it is somehow they collect it. I says every encircle is not done by me. And from that process, it is evident that out of 76, they engage 102. So it is evident. On record, it is evident they did the corruption. 76 is the declared vacancy. They give appointment 102.
No, it's all right. But then
we have supplied them with the OMR sheet, my lord. Subject to the tampering of the document, that is, you can file a fresh petition, my lord. That is not the subject matter of
it is in this petition. And coordinate bench passed the order. Similar point. An excess appointment which is evident from the record itself.
My lord can mold prayer any time, my lord.
No, but to what extent? This is what I was
Yes,
saying.
my lord, it is evidence
Your
for a-
prayer is for
OMR.
providing RTI.
Yes, because
Right.
we not get the copy. That is, but during the process, my lord, it is evident that they done this corruption, my lord. The authority done it. To hide up their corruption, my lord, they, my lord,
Please come.
encirclement is there.
Please come.
Report একটা copy.
The matter relates to
They're not with the copy of it.
the Gram Panchayat Secretary Recruitment Process 2017 conducted by the
Scan for it. No, we will put a copy down.
District Panchayat and Rural Development Officer, Purva Mednipur. Stop. The petitioner participated in the recruitment process. Stop. He was not aware as to whether he was successful in the recruitment process or not. Stop. He made an application for providing a application under the Right to Information Act, 2005, for providing a copy of his OMR sheet. Stop. At the time of consideration of the writ petition, submission of the state was that the OMR sheet was not readily available. Traceable, not readily traceable. Stop. The court permitted adjournment with a direction for tracing out the OMR sheet. Stop. The OMR sheet of the petitioner was thereafter traced, and the same was produced before the court with a copy to the learned advocate for the petitioner. Stop. The learned advocate for the petitioner has filed an exception to the said report, report filed by the authority, clearly denying that the copy that has been supplied, that the OMR sheet that has been supplied does not belong to the petitioner. Stop. Specific submission is that the petitioner did not encircle, did not attempt each and every question in the answer sheet. Stop. The OMR sheet produced before the court has been answered by the candidate. In respect of all the questions. Stop. Paragraph. Prayer has been made to direct the Central Forensic Science Laboratory to examine the OMR sheet of the petitioner to ascertain as to whether the same was at all the petitioner's OMR sheet or not. Stop. The petitioner has also brought to the notice of the court from the report filed by the authority that though vacancy for the post of Gram Panchayat Secretary was declared to be 76, but 102 appointments have been made. Stop. Paragraph. The District Panchayat and Rural Development Officer, Purva Mednipur, has filed a report before this court dated 22nd August 2025. Mentions that though the notification was published in respect of 76 Gram Panchayat secretary vacancies, but the said notification also mentioned that the number of vacancies was provisional and subject to change over time. Stop. According to the authority, the number of vacancies increased due to promotion of eligible Gram Panchayat secretaries to the post of executive assistant, superannuation of existing Gram Panchayat secretaries, and inter-district transfer of Gram Panchayat secretaries. Transfers of Gram Panchayat secretaries. The reasons assigned for increase in the number of vacancies prima facie does not appear to be proper. Stuff. If a Gram Panchayat, আচ্ছা এটাকে না এটাকে আপনি does not appear to be proper টা আপনি কাটুন stuff the district reasons থেকে কেটে দিন the district panchayat and rural development officer Purva Mendipur is directed to file an affidavit giving details of the increase in the vacancies. Stop. The affidavit shall disclose as to whether the final vacancy list was at all made public or not. Stop.
Notification.
Acha.
Notification. Advertisement is notified. And is the advertisement and subsequent increase of the.
They will disclose. Let us see. Acha. The petitioner has relied on the order dated 26th August 2022, passed by this court in WPA 6548 of 2022 in the matter of Abdul Hamid versus the state of West Bengal and others, wherein the court exercised the provision of section 73 of the Indian Evidence Act, 1872, to compare the signatures, writings, seals, stop. Acha. The court was pleased to direct the OMR sheet and the ballpoint pen of the petitioner to be sent to the Central Forensic Science Laboratory for examining. Stop. Paragraph. The respondent authority is directed to produce the original OMR sheet of the petitioner before this court on the adjourned date. Stop. Release the matter on 23rd of September. At the exception of the petitioner to the report of the respondent number 2. Filed in court today is taken on record. Today's report, give a copy to him.
Kindly record it, otherwise it's very difficult to kindly record. I not get the copy.
In case you do not get it by today, please mention tomorrow morning. In case it is not given, he will mention it tomorrow morning. All right. Call the next matter, please. After 2 weeks.
Also, I am for the petitioner. Lordship,
Yes.
kindly come
I'm
to the
appealing for the
last
respondent on
order.
9 1.
Lordship, by 29.
Lordship, I appear for the DM Birbhum, District Judge
Lordship, the
Birbhum.
learned
The
district
respondent numbers 5 and 6.
Rejected to serve the copy of the report by 29th August 2025
Lordship, I'm filing the report.
and directed the petitioner to use an exception. Till date, no copy has.
I'm filing it right now.
আমার একটা copy দাও।
You are handing it over now. There was a date mentioned.
Lordship, actually, there was some difficulty because the district judge had to come down from Birbhum, Your Lordship. So at that point, Your Lordship, she was not there, and therefore the delay, Your Lordship.
একটা
If the
copy দাও আমার-
district
a
judge
copy may be served, my lord.
does not comply the direction passed by the High Court, what is the impression that is going out?
Your Lordship, she did come thereafter, Your Lordship.
What is the explanation?
For if Your Lordship takes page 43, Your Lordship, this is
You have not even handed over copies. How will your learned friend see what is there?
I will just do the needful, Your Lordship. I have sent soft copies, Your Lordship.
You have a soft copy?
I have soft copies. I've served it to the SLSA as well.
What will the petitioner do? It is his case. It is not SLSA's case. The case is of the petitioner.
Yes, Your Lordship.
And the petitioner doesn't have a copy? No, but then you are making submission. Relying on this copy and the petitioner
Lordship,
doesn't
in
know
that
what is
event-
it. Tell
in
me
that-
what is it?
It is that there was a letter that we received from the SLSA. Based on that letter, we had taken the requisite action, Your Lordship. We were told to issue a fresh advertisement, Your Lordship. Therefore, a fresh.
Was the earlier advertisement cancelled?
It did not. I'll read out the letter, Your Lordship.
How can two advertisements in respect of the self same post be published? Tell me this. This is what the petitioner is saying.
Very well. I bow down before Your Lordship, but Your Lordship, the letter merely asked me to issue a fresh advertisement. I'll just read the relevant portion. It said, His Lordships has been pleased to direct that as no recommendation was made by the selection committee of the district concerned due to unavailability of suitable candidates, the fresh selection process to be initiated immediately for selection of legal aid defense counsels as per vacancy of the district concerned.
No,
And-
then is it the case that the candidates were not available? Suitable candidates was not available?
Lordship.
For that, Your Lordship, I am taking Your Lordships to the minutes. On page 43, Your Lordship, it says after going through the interview marks and score in the written examination, a merit list was prepared, but no name was recommended earlier for any post of legal aid defense counsels. For the post of Deputy Chief Legal Aid Defense Counsel, preference was directed to be given to those having knowledge in handling computers. In this category, only one candidate, namely Ardhindu Shekhar Mondal, secured 40% marks. In these circumstances, the said candidate, though I'm just reading as it is, have no knowledge in handling computer, this committee unanimously decides to recommend his name as he is the only candidate who could be able to secure 40% marks in total as instructed verbally by the SLSA West Bengal. So thereafter, Your Lordship, this letter came. By virtue of this letter of the SLSA,
The writ petition is by Ardhindu Shekhar Mondal, whom you found to be eligible. Even then, appointment was not given to him,
but
and that is the writ
I am
petition.
bound by the directions of my superior, which is SLSA. SLSA sends me a letter on 23rd of December 2022 saying you are requested kindly to take initiatives for engagement of full-time legal aid defense counsels in respect of Chief Legal Aid Defense Counsel and Deputy Chief Legal Aid Defense as per vacancy status in your district at the earliest. And thereafter, they give the vacancy status on page 50, wherein Birbhum, Chief Legal Aid Defense Counsel 1, Deputy Legal Aid Defense Counsel 2.
What is the stand of SLSA? Who is representing?
Lordship, we have already filed our report, Your Lordship, and we have specified that with reference to the
Microphone, please.
cancellation or non-cancellation
You have
appointment. and
cancelled it.
No, Your Lordship, we do not have the document with us. We have already filed an affidavit pertaining to the same, Your Lordship. That
Does it go to show that the petitioner is also an eligible candidate?
Lordship, may I place one document, my lord?
What?
Lord, kindly consider, my lord.
What document is this?
Earlier panel was not approved and
By whom?
by the authority, my lord. Lordship
Which
indicated that.
authority?
Lordship, may I place, my lord?
If you want to rely upon document, you have to share copies and then only the court will see. Otherwise, the court will not see.
This is the document of authority, my lord.
It is not within the knowledge of the district judge.
The writ petition not annex the entire document. They have annexed only one page. Out of 4 pages, only 1 page annex, my lord. Lordship, may I place, my lord?
Give a copy to the SLSA.
I have given, my lord.
SLSA and the DM.
I'm reading. Their document. Document issued by the Secretary District Legal Service Authority, my lord. Lordship. This panel has not been approved by the State Legal Service Authority, West Bengal, as per letter number 50989 SLSA 2122 of London Member Secretary. Second one, no approval of this panel was duly notified in the notice board. Non-approval of this panel was duly notified in the notice board on 5th January 2023. Thereafter, on 6th, new advertisement was made, my lord. On 5th, it was notified, my lord. Lordship, kindly consider this line, my lord.
So I don't know, Lordship, how the
This is the Lordship.
the documents.
I'm working there, my lord. Lordship, this was displayed in the notice board. This was displayed in the notice board. For kindly consider, my lord.
The pure nexus between.
No. Displayed in the notice board, my lord. This is indicated in the notice board.
What is the stand of? Just wait. Yes.
May I just place a neutral narration of the facts?
Right.
By our letter, that is SLS's letter dated 28th August 2022, the process had started. 16 districts were to conduct examinations for recruitment to the post of LADCs. Guidelines were given. The guidelines specified 50 marks was to be the examination.
Just tell me.
I'm coming to that.
Whether
the final merit list, which Birbhum had prepared, that was sent to the SLSA by email on the 16th of November 2022.
Right.
That final merit list, the petitioner's name figured in serial number 1. After that, 10 districts who had submitted the final merit list were placed before the Honorable Executive Chairman. Here, the lapse that appears now is Birbhum was not in the list. A few districts were approved by the Honorable Executive Chairman. By implication, the other districts were not approved. But as Birbhum's name was not in the list, Birbhum could neither be approved nor be disapproved. Thereafter, this second
fresh notification came in.
Thereafter, the second letter 5098.
Now, how do you resolve this impasse that has been created?
That is why in my affidavit I have stated that I have no documents to substantiate or legally augment the second.
Why don't you speak to the executive chairman or whoever it is as to how this is to be resolved? Because you have selected found at least somebody to be eligible to be appointed. Thereafter, a fresh selection process has come in and somebody else has been appointed. What is going to happen?
Third position, but as there were only 2.
That was in the second recruitment examination. But the first one remains, not being cancelled.
Not being officially cancelled, not to my knowledge.
Yes. If that be so, then why will the writ petitioner not get a chance to be appointed? What will be your explanation? I don't think you can have an explanation over here.
I don't.
Then you have to take the help of whoever your senior authority is. Otherwise, the petitioner has to be accommodated somehow. I hope you've understood what is to be done now. Otherwise, the court has to interfere, which the court does not want to at this stage.
Whatever has fallen from your lordship before the Honorable Executive Chairman.
Please.
Lordship, prima facie non-approval of the panel is indicate that panel was not continued, my lord. Thereafter, they have issued notice.
And you take note of this also.
Lordship, kindly consider. Kindly consider.
You've annexed it.
They have not placed this, my lord.
Which page is it? Is it annexed? Is it annexed somewhere?
Your lordship, I can show
Lord,
you.
kindly let them produce the letter number 5098, my lord. Let them produce this.
Which I can.
If the selection is not approved, then it is something else. But if you do not take a decision
They have taken
and
decision.
thereafter publish the next one, what happens to the earlier one? There must have been some mistake and find out some solution. Find out a solution as to what can be done. Please come.
May I place in the record, my lord, this
No.
document?
The authorities are aware of it, they will take a decision.
Lordship.
The report in the form of affidavit by the District Judge Birbhum, filed in court today, is taken on record. Stop. Let copy of the same be circulated immediately. Stop. The member secretary, SLSA, is present in court and is heard. Stop. It appears that the selection process in which the petitioner participated has neither been approved nor cancelled. Stop. A fresh selection process was thereafter initiated and the private respondent has been found to be successful. Stop. The claim of the petitioner, being the only eligible candidate in the first selection process, still remains. Stop. The the member secretary is requested to take up the matter with the executive chairman of SLSA to resolve the dispute. Stop. 23rd of September relisting.
Lordship, my submission may be recorded.
What submission?
I have placed the document, my lord.
Your document is annexed to that a report, it is said.
Lordship, grateful, my lord.
Take up the report and see.
No copy of report.
My learned friend is also, clients also, Lordship, selected in the first selection process.
No, but you are the first panel candidate.
Two posts are
Doesn't
there.
matter. Two posts are there. Now one is still vacant.
No, two posts is filled up.
Posts have been filled up. Next.
No. Grateful, my lord. What is this?
I beg to appear on behalf of the petition. My lord, sir, kindly come to your lordship's last order. Last order, your lordship has not satisfied the report which has been prepared. My lord, paragraph 5 and 8 is the very vital.
Yes.
My lord, 5, your lordship is that my allegation is that the persons against whom appointment has been challenged, he has prepared a report, negative report has been prepared. That's why your lordship specifically directed the district magistrate, being the chairman of the regulatory market committee, to cause an inquiry. Without, my lord, the district magistrate, without leave of this honorable court, somebody else, again, my lord, they inquired the matter, a report has come negative. When a learned advocate, practicing advocate in this court, my lord, was present, his submission also not recorded, and he was not allowed to speak the, my lord, to make his submission. Second submission before the lordship, the persons whose name.
No, wait. Let a further report be placed on the adjourned date by
the
district magistrate chairman. Is this the report by the DM?
Deputy magistrate of the collector, at the instance of the inspector who has prepared the report earlier that had not been considered. Same report has come, but the person, somebody, disclosed their evidence. Those appointments, never they have been appointed by the authority concerned. My submission before your lordship, before your lordship.
1 minute. Was Abdus Salam kept out of the entire process?
Yes, he was not present.
Has he been kept out?
We have now engaged subdivisional officer.
Yes.
He is an WBCS executive.
All right.
He said someone from the
marketing authority will say negative against him. He had some grudge. That's what he told, as I understand. So DM has done. First, he engaged the local subdivisional officer who is an WBCS officer. The petitioner did not reach there.
Petitioner did not?
Reach because we informed them. In
Yes.
presence of that, he chose not to reach there. Then the learned advocate for them reached there.
All right.
So then question was asked that show me how you planted, whether you maintained any record, what are the books. He could not, of course, being an advocate, he was not aware of those facts. He could not reply. Then the magistrate gave another hearing, district magistrate, that yes, now evidence has been collected, come to my chamber, I will try to hear both. Then also they did not appear, they gave an electronic mail, said no, I presume you are closed. Now I will take
My
over.
lord, now,
Presume
my lord, may I only one submission? Kindly,
No, wait, let him finish. Yes.
Now kindly turn to.
Did you get a copy of this report?
yes, just yesterday, my lord, I have.
Yeah, yesterday.
I
means enough
I
time.
accept it.
Yes, then.
Lordship, kindly see, kindly turn to page 49.
Yes.
Torun Kanti Halda, Lordship is there.
Hmm.
With reference to subject demand from justice, Lordship, kindly see on 3/9/2025. The meeting was fixed in the DM's chamber on 3/9 itself. So he is writing that with reference to the subject matter, I directed my client to put up their protest apropos as asked up inter alia other criteria. They expressed their sheer astonished to see and appraise the style of crashing harassment such and such by those people. Entered in the contract with my client, got the work done, went to pay, turned back, raised honorable dues. So, Lordship, they gave a letter stating that you have get the job done.
Next, my lord, kindly read, my lord, what he has been.
Cannot vote.
1 minute, please. Yes, then.
Then, Lordship, they say hearing was got held on 1/9/2000 in participation of Deputy Magistrate Collector, a heavy of other official of the higher reason in terms of the letter dated 29/8/20 issued from the SDO Diamond Harbour and failed to make appearance of the concerned officer for examination to prove the veracity of the report submitted themselves. Same authority cannot trace further hearing by issuing another letter on 28/8/2025 on the same safe cause. They say that the report was made by the BDO Mothapur in connection with the issue and the same made by the Deputy Secretary as stated, were without notice and without jurisdiction to the sinister motive to complicate the matter germinated out of this contract such and such. The state end here, they preferred to prove that Lordship I could not read because and pursuant, I am invite your kind attention to the fact that the learned magistrate, although pleased to direct the other officer.
What does this mean? For first word in passant.
In percent.
Is this the word? First word you read out just in passant. Yes.
Then furnish the report and document read over by them to the learned magistrate at the hearing held on sir. To this undersigned, though his WhatsApp says.
Anyway, what is the ultimate thing that you found out?
Lordship, I found that he took the contract, he did not do it. By daily wager, the marketing authority had to complete the project. And after a year, they come back and claiming money. And this is happening day in day.
No,
All right.
my lord, only one.
Yes.
Kindly come to, my lord, the earlier report which has been prepared by the authority council.
Please come.
My lord, only one submission before your lordship, two matter to be heard analogous because of the related matter which has been pending. That's why, my lord, this matter.
The petitioner.
I obviously I file it, my lord, the exception to that report because of that.
A report in the form of affidavit filed by the respondent number 3, Secretary, South 24 Parganas Regulated Market Committee in court today is taken on record. It appears that despite repeated opportunities granted to the petitioner, the petitioner was unable to show any evidence regarding maintenance of the trees in terms of the contract given by the Regulated Market Committee in the year 2021. Stop paragraph. As the authority negates the contention of the petitioner regarding taking steps for maintenance of the plants, the authority is denying to make any payment to the petitioner. Stop paragraph. The petitioner strenuously denies the stand of the authority. Stop paragraph. As it appears that the very factum of maintenance of plants is denied by the authority. Accordingly, no direction can be passed upon the authority for releasing any payment to the petitioner. Stop. It will be open for the petitioner to take steps in the matter for seeking payment before the competent forum in accordance with law.
Only
if
one
so
submission.
advised.
Since our engagement has not been cancelled,
Next.
they have contrary report has come before your lordship.
Next.
Earlier report we have worked. Now today, my lord, the report has come.
Yes.
My lord, at number 36, I am for the petitioner. Petitioner preferred this writ petition challenging the tender not issued by the respondent number 2. The respondent number 2 is the Rampura Government Medical College and Hospital. My lord, kindly come to page 23 and 24. My lord, there was some requirement for appointment providing the cleaning and housekeeping staff. The 75 unskilled cleaning and housekeeping staff, and those who will be supervised by one semi-skilled staff.
Yes.
Which is very stringent condition.
What is your relief? To issue further corrigendum to the notice inviting tender.
My lord,
my instructions are, my lord, the tender that has been challenged has been cancelled.
Very well. The petitioner filed the instant writ petition challenging certain provisions in the notice inviting tender floated by the MSVP Rampurat Government Medical College and Hospital. Stop. Learned advocate representing the hospital relies upon a communication made by the MSVP dated 9 September 2025, which mentions that the notice inviting the subject e-tender for providing cleaning and housekeeping services had been cancelled due to administrative reasons on 16th of June 2025. Stop. In view of the aforesaid, in view of the cancellation of the subject notice inviting e-tender, there is no requirement of the cause of action for which the writ petition was filed does not subsist any longer. Stop. The writ petition stands disposed of. Next.
Kindly give a direction to Mr. Basumali to provide it.
Give a copy to him. Cancellation. Yes, cancellation. Next.
No. Actually, my purpose has already been served. I have.
37 lordship's order has been complied.
They have given interest at the rate of 3.9%.
That is the rate.
Kindly consider 2.9%. Kindly see,
No, nothing more.
2.3%. Kindly see order date.
Whatever it is.
Kindly see, your lordship directed paragraph 4.
Yes.
Order dated 8th of July 2025.
Yes.
Paragraph 4. The authority is directed to make necessary calculation for payment of simple interest at the banking rate on account of delayed release of fund. Now it is paid in 2.4%.
Yes. What is the rate?
Less than that.
No, section 34. Kindly see, section
What
34.
is the rate?
9% minimum.
No.
At least 6%, 6 to 9%. Kindly see, section. Kindly have a look. Section 34 of the CBC. Kindly have a look. Section 34 of the CBC. No, 2.4%. Kindly consider.
Petitioner has been provided interest on account of the delayed payment of its dues. Stop. According to the petitioner, the rate of interest that has been provided is extremely low and not in accordance with the banking regulations. Stop paragraph. The court is of the opinion that for further interest, the petitioner obtaining further interest, it will be open for the petitioner to approach the competent civil forum for remedy in accordance with law if so advised. I am not shutting you out.
Go
Writ petition disposed.
more than virtually shut out.
Yes, next. Call the next matter, please.
This my application, there is a uproot of tree.
Yes.
Report has been submitted. Report clearly sees, demonstrate that the damage has been started. And they are taking exception. I am going through the exception. I have served on yesterday. Nothing has been material has been so far my instruction. I have
Yes, please.
nothing is.
What has been said first, and it comes to page 9 of the exception, that is the report.
9 of the exception, that is the report.
That is the report. I have annexed the report.
It.
Yes, yes.
All right.
I have annexed the
Page 9, yes.
according to the undersigned, with other staff, such and such were present and the earth such and such lifted. It has been found that the roots of both mango and coconut tree are entering inside the premises of the petitioner. Roots of mango tree are touching the concrete wall of the septic tank, which is erroneous. And going down the roots of the coconut tree are touching.
Specialized agency has given a report and you say it's erroneous. For what good reason?
On fact, I'll show. Touching the concrete wall of the reservoir and going downwards inside the earth. However, in both the cases, no signs of visible damage in either the septic tank or reservoir is evident at present, as there was no foul smell coming out of the septic tank, nor there was any water leakage from the reservoir of the petitioner. Now, kindly sees, I have provided a map. Kindly comes to page 19.
This case map I am disputing.
Yes, maybe.
Yes.
Except case map cannot be accepted.
Now, my lord, kindly sees, the septic tank is shown, water tank is shown. There is a drain surrounding the septic tank.
Yes.
Lordship has seen. Now, kindly comes to the next page. These are the pictures. Lordship can see. Same pictures have been annexed. These are a bit blown up. Means thing. Kindly sees there is a septic tank. Lordship kindly sees septic tank is there. There is a water tank at the further side and there is a drain. Now it is being digged up. Now the roots are touching the drain first wall. It is not touching the septic tank, and kindly sees what is the width of the root. Very small.
Today it is small, tomorrow it will grow.
Now
it is as easy as.
Kindly sees the report. The roots after touching the tank or whatever is the obstruction, the roots are not supposed to go inside. They have diverted and gone downwards. Now point is that whether, now we come back to the fundamentals as to whether roots can at all be touched. That will be damaging the tree, and for that we have to obtain a permission. The person who is having the owner has to obtain a permission from the forest authorities, which I don't wish to do because it is within my premises. And my lord,
you keep your trees along with the roots within your premises and do not touch.
Yes, it is.
The petitioner
don't have any
property.
I don't have any control over where the roots go. Because it is the tree's roots.
You don't have any control and the petitioner's property will be damaged. You
cannot not being damaged. And even if there are roots,
21 says it is just water tank and the septic tank.
Kindly sees the pictures of the roots.
No, I won't see. Today it is small. Do not repeat the same thing.
Yes.
If it
and
is.
It has diverted. It has gone downwards.
Page 21 says clearly.
Please do whatever is necessary to keep your roots inside your premises so that it does not affect the petitioner in any manner.
The roots will be going underground. I don't have any control over the roots.
That's why.
In that case, the court will direct the authority to take steps to see how can be done.
The authority, if they want, first is as to whether the roots
suggest for uprooting the trees, my lord. The expert suggests that.
1 minute.
Cannot
What is
done.
the what?
Your lordship's order is there.
Way out.
Way out is, my lord.
Trimming of trees has been done.
No, uprooting the
Yes.
trees is the only remedy.
Course not.
Cut down what?
That is not the function of the forest department under the.
To uproot the trees. Forest
No,
department
what
is
is
saying
to be
so,
done?
it will be recorded.
Apart from cutting down the trees, there is no other alternative.
Because nobody knows when it will penetrate and where it will.
Yes, right.
It is forest department is not saying, it is the lawyer is saying.
Oh,
I want it from the expert as to what is to be done. Is uprooting the option? And if that is the option, that has to be taken care of.
Well, the forest department has given its detailed report.
Yes, what has any solution been mentioned
No, no.
therein?
Forest department has not said.
Then some solution has to
But in
come.
both the cases, no sign of visible damage is in either of the septic tank.
He
or-
has read out the report.
So that being the position, I leave it to a lordship.
No, the court is not the expert authority. It is you who's the expert authority who can.
Department is not. Is
Who will be?
They can say,
Yes.
but they cannot take any action.
You suggest measures as to how this problem is to be resolved. Then what is to be done? The
When brothers,
authority.
when brothers and neighbors fall out, there is none in this world to say.
Here it is not the brothers. Here the tree is,
Neighbor.
creating foul.
No, neighbors.
neighbors, ego satisfied.
No, I will
Only
not
for ego
come before
satisfaction.
your lordship if
Only for ego
if
satisfaction.
that root is not touching my water tank and the septic tank. Lordship, kindly appreciate if it is starting to damage my water tank and the septic tank, what will be the
So
consequence?
that is
The
in
court
that is
is
in
trying to
probability.
see
And-
what can be done.
It is reported root of the mango tree are touching the concrete wall of the septic tank
Yes.
and going downwards, and the roots of the coconut tree are touching the concrete wall of the reservoir of the growing and
Yes.
growing down inside the earth.
Right. So
It is going down inside the earth.
So, Malad,
So it will go down. It will go down
Septic
for
tank is
some time
underground.
longer.
Water tank is underground. If it is goes down,
It's
then
under
the
the ground.
consequence will be
if that be
serious.
the position, my lord, some action has to be taken.
yes. Now what action can be taken? Please suggest. Let your officer suggest what the action can be taken.
My lord, kindly, my lord, my humble submission kindly records
Achha.
that the trees cannot be felled. There is an order of passed by your
Please.
lordship also.
Please stop.
Order is there. Your
You
lordship's
can-
order.
Even if my order is there, I cannot permit a tree to stand if it damages somebody else's
It is
property.
not damaging. As
Eh,
of
that
today,
is
there
your
are no many-
contention.
Let-
I will not rely upon your
report says-
contention.
The report says so.
I will not rely upon.
Kindly-
I'll rely
kindly
upon
seize-
the authority.
Kindly seize the
I will
report.
not look at anything.
Last
Please.
line of the report, my lord, my humble
Exception
submission,
by the
my lord, this is the
Respondent
case.
numbers 5 and 6.
Sir, this writ petition cannot be
Dated
stretched
8
many
September
further.
2025.
There has been trimming of trees, voluntary. I have on the first
filed
date
in
said that
court.
trimming of trees
It's
should be
taken
done.
on record. Stop. The report of the expert body suggests that the roots of the subject trees are touching the boundary wall of the petitioner. Stop. The petitioner apprehends damage to his property, not his but her property. ঠিক আছে?
Septic tank and water is
The range forest officer is directed to suggest remedies to the problem, to the apprehension faced by the petitioner. 23rd of September.
Well, kindly records my submission, Balmar, this
Call the next matter, please.
writ petition has been stretched beyond ballot its scope and prayer.
I'm good.
ও 4:30 তো বেজে গেছে, ডাকতে হবে না। Call the
Breakup. My lord, they have to file the breakup.
No,
My lord, last order.
direction was
so
upon
this
you.
is a rail coach.
Well,
What has happened?
they were directed to file the breakup.
দেখি
Your lordship deserve
315 ম্যাটারটা দেখো।
They are ordered
No.
to.
Kindly
submit
have a
the
look at your
breakup.
lordship's order, last order.
Paragraph, my lord. Copy. A copy. Copy. How do you have soft copy?
4th of September, you made some payment? Payment receipt paid by the licensee, 4th of September?
4th of September 2024.
ও
Oh, 24.
24 months.
Yes.
That is the previous one. The 5 lakhs which I was supposed to.
The licensee is well about the amount to be paid on reinstatement. Has paid 5 lakh.
There was the terms and
And in the same line, the amount to be paid by the license for year will be calculated. Amount to be paid by the licensee on reinstatement of the contract will be calculated for the period between 2nd April 25 to the next date of reinstatement. Where is the figure?
that is 12 lakh 80,623, my lord.
Oh, 12 lakh 80,683.
23.
Give a copy.
Yeah, my lord,
Just
we have
now,
soft
just-
copy.
just now.
Got it? Make payment. Please come.
Since
No further.
no. Since November, they supposed to hand
The
over the
assist
place.
the
Kindly give.
calculation
Kota number 39.
forwarded by the Assistant Commercial Manager, Southeastern Railway, Kharagpur, dated 5th September 2025, showing the amount payable by the petitioner placed in court today is taken on record. Stop. Copy of the same has been handed over to the learned advocate for the petitioner. Stop. The petitioner shall take necessary steps. The writ petition stands disposed of.
Great,
Much
my lord.
Call the fixed matter, please. Obviously, no other.